268 ಹೋಗ್ಬಿಟ್ಟು 268 ಹೇಳ್ಬಿಟ್ಟಿದ್ರು. ಮತ್ತೆ ನನಗೆ ಅದು ವರ್ಡಿಂಗ್ ಅದು ನನಗೆ ಯಾಕೋ ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ತದೆ. ಐ ಆಮ್ ನಾಟ್ ಕನ್ವಿನ್ಸ್ ಬರ್ತಾ ಇದ್ರು. ಇನ್ ಕೇಸ್ ಬೇಕಂದ್ರೆ ಈ ಸರಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಅವರಿಗೆ ಬಿ ಎಸ್ ಸಿ ವಿನಾಯಿತಿ ಪಡೆದಿದ್ದಾರೆ. ಏನು ಪಡೆದಿದ್ದಾರೆ ಯಾರು ಯಾರು ಇದರ ವಿನಾಯಿತಿ ಏನು ಪಡೆದಿದ್ದಾರೆ? ಎಸ್ ಎಲ್ ಇ ಟಿ ತಗೊಂಡಿದ್ದಾರೆ. ಇದ್ದಿದ್ದು ಹಾಗೆ ಎರಡಿತ್ತು. ಈಗ 4 ಮಾಡಿದ್ದಾರೆ.
If I may mention a matter, my lord.
Ah.
Serial number 26, my lord, it is for final hearing. The arguing counsel for the appellant is unwell, my lord. Seek some accommodation.
26,
26, my lord.
2014 matter.
The arguing counsel for the appellant is unwell, Mr. Vivekananda.
Not well.
Not well. I've informed the other side as well.
Not well. Call this matter in the second week of January 2025.
The very next
Health
matter.
round of arguing counsel.
I'm sorry.
Ah.
Very next matter. Serial number 27.
27.
Mr. K.R. Bharatwaj is down with a viral fever, my lord. Any date may be fixed. I leave it to this honorable.
Same order.
Please.
In the third week of okay, on the health ground of arguing counsel appearing for petition.
Appellant.
The lordships.
Ah.
Kind permission. 23, my lord. Serial number 23.
23.
This matter is listed for further hearing, my lord. AG Pradeep was arguing this matter. It's part heard. It appears that he is not well, my lord. He is not able
well.
to speak. Sure.
Is not well is a very good ground in court, in this court.
He's gone to hospital, in fact.
All. Next
This
week,
matter pertains to insurance policy.
we know that.
Please,
That particular stipulation
please.
where the buyer of the policy commits suicide.
Yes, within 1 year. Yes, ma'am.
Your lordship, candidature of a 100% blind candidate was rejected on the ground that 100% blind person cannot be a primary graduate teacher. I'm moving a memo for listing.
Covered by judgment.
It is covered by judgment.
Sorry, next week. My lord, serial number.
The recruitment process is going on. If any date this week.
Day after that. Day after.
My lord, serial number 16, my lord. The arguing counsel is not seriously unwell, my lord.
16.
16.
Huh.
Any date in the next week or
Yeah, move madariddna.
have moved the matter.
You have moved it. All right, after 2 weeks, at the
My lord,
request of counsel for the petitioner on health ground.
This is
Authorized.
my lords, this is a KAT matter, my lords. I'm out of a job, my lords. The matter was supposed to be.
How long you have been out of the job?
My lords, close to 6 months, my lords.
6 months.
Please, my lords. The matter was supposed to be listed on 29th October, my lords. The date was given, my lords. The matter could kindly be listed within.
ಯಾಕೆ ನಾವು ಡೇಟ್ ಕೊಟ್ಟ ಮೇಲೆ ಯಾಕೆ ಪೋಸ್ಟ್ ಮಾಡಲ್ಲ ಅಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ಬಹಳ ವ್ಯವಹಾರ ನಡೀತಿದೆ ಅಂತ ಕೇಳ್ಬಿಟ್ಟಿವಿ ತುಂಬಾ ಲೆಟರ್ಸ್ ಬರ್ತಾ ಇದಾವ್ ನಂಗೆ.
This is from the previous
Why
roster.
your registry is not? Why even when memo is accepted, you will not post it?
In fact, my lords.
What is that ವ್ಯವಹಾರ going on? ಲಾಯರ್ಸ್ ಅದನ್ನ ಮಾಡ್ಕೋತ ಕೊಡ್ಬೇಕಾ ಏನು? ಅಲ್ಲಿ ಅವ್ರ ಹಿಂದಿಂದ ಕೋರ್ಟ್ ನಲ್ಲಿ ಕೆಲಸ ಮಾಡೋ ಬಿಟ್ಟು ಲೈಬ್ರರಿಯಲ್ಲಿ ಓದೋದ್ ಬಿಟ್ಟು ಮೊದಲೇ ಓದೋದ್ ಕಡಿಮೆ ಆಗಿದೆ ಮತ್ತೆ ಅಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲೇ ಹೋಗಿ ಅಡ್ಡಾಡ್ಬೇಕಾ? ನೋಡಿ ಅವ್ರಿಗೆ ವಾರ್ನಿಂಗ್ ಕೊಡಿ. We will inflict bleeding injury on them. ಎಲ್ಲ ಲಾಯರ್ಸ್ ಹರಾಸ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಲ್ಲಿ. ಎಷ್ಟು ಜನ ಬಂದ್ಕೊಂಡು ಹೇಳ್ತಾ ಇದಾರೆ ಲಾಯರ್ಸ್ ಬಂದು ರಿಪೋರ್ಟ್ ಮಾಡ್ತಾರೆ. ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರೆ ಪೋಸ್ಟ್ ಆಗಲ್ಲ. ವಾಟ್ ಈಸ್ ದಿಸ್ ಹ್ಯಾಪನಿಂಗ್? ಕರೀರಿ ಅವನಿಗೆ ಯಾರು ಇನ್ಚಾರ್ಜ್ ನಮ್ಮ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಇನ್ಚಾರ್ಜ್ ಯಾರು? ಅಲ್ಲ ಇದಾಯ್ತು. ಬೇರೆ we have received so many letters. ಯಾಕೆ ಪೋಸ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ? Many lawyers come and report to us.
If I may make a submission, my
Then
lords, the matter was learned court
Vacation
officer
ಅಂತೀರಿ.
was right. Matter was to be listed after Dasara vacation and 29th was given. We in fact moved another
date change
memo
ಮಾಡ್ಲಿಕ್ಕೆ
before your lordship.
ಡೇಟ್ ಆರ್ಡರ್ ಆಗಿದಂತ ಡೇಟ್ ಅನ್ನು ಚೇಂಜ್ ಮಾಡ್ಲಿಕ್ಕೆ ಎಕ್ಸ್ಟ್ರಾರ್ಡಿನರಿ ರೀಸನ್ ಬೇಕು. ಒಂದು ಇಲ್ಲ ಐಎ ಹಾಕ್ಬೇಕು.
Well, let's moved another memo
Next.
before your lordship.
ನೆಕ್ಸ್ಟ್ don't waste time.
Serial number 14, my lords.
Eh?
Serial number 14.
14.
14. I've informed the respondent also. Can it be taken up on 4th, my lords?
4th
4th December.
4th ಅಂತ ಆಗಲ್ಲ. Serial number
14, my lords.
14. Serial of 2019 matter.
Please,
Why were that?
my lords,
Bank
the arguing counsel has gone to Dharwad today. Some inconvenience.
All right, next week.
Any date, my lords?
Maybe.
ಡೇಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ನೀವು ಕೇಳಿದ್ರೆ.
Interim order may be extended.
If you want to continue for 1 week. Okay. Okay.
Kind submission, madam. Serial number 6, madam.
6.
6. One week time may be granted to comply with the office objection, madam.
ಇರಿ ಅದು ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ ಇದೆ ತಾನೇ? ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ ಇದೆ. ಇರಿ ನೋಡೋಣ ಏನೇನೋ ಇರ್ತದೆ ನೋಡೋಣ. ಎಸ್.
For the petitioners, my lord. Date may kindly be fixed, my lords, for the matter to be heard finally.
I had filed a retirement memo. My name may kindly be deleted, my lords.
Huh?
My name may kindly be deleted.
You're not there. Shri, so and so is permitted to retire from the post in the second week of January 20.
Interim order to be
Interim
extended.
order to continue.
Much.
I take my lord, steps is taken.
Steps ಹೋಗ್ಬೇಕಾ?
Yes, I already taken, my lord.
You are taken?
Yes.
1, 2, 3, 4, first time. Yaru lawyer advocate who appeared in the, before the single judge.
Second matter, Satish.
The AGA submits that steps have already been taken. First off, registry to verify. First off. The AGA, the appellant is directed to serve copy of the appeal memo along with all the documents on the counsel who represented the unserved respondents in the, before the learned single judge in writ petition within 1 week, and file acknowledgement in the registry within 1 week next following. Okay. Failing which appeal may be dismissed. Yes.
For appellant in this case, my lord.
Yes, Faiz sir.
But in this case, the respondent has to file this application, production of document. For that, the coordinate bench has directed to file the objections. Today, they have to file the objection for respondent number.
ಏನದು documents ಕೊಡಿ. writtenally writ appeal ನಲ್ಲಿ production of documents ಗೆ ಮೆಮೊ ಸಾಕು ಅಂತ hold ಮಾಡಿದ್ದಾರೆ.
Along with
Anyway,
application,
we are
by
just
outlining
telling
the reasons, my lord, I filed an application.
All right, all right.
Lord, in this case, my lord,
One
the survey
second.
number 26 of Kaji Sonnenalli is there.
One second.
Gomad land, my lord. Sorry.
ಏನದು documents ಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದು?
IA number 124, my lord.
Huh?
That IA number 1, this is the endorsement issued by the RTA under the RTA with the consent department stating that the land in question is not granted in favor of the father of the respondent number 5 and 6, my lord. But kindly see annexure A3
When,
page 22.
When copy was served?
Lord, this has been said. Thereafter, the 2 occasions this court has granted.
We are asking a question, you are not answering. When copy was served on?
7th January 2024.
ಬರ್ಕೊಳ್ಳಿ. Application supported by affidavit seeks leave of the court to produce additional evidence, that is certain documents in support of case of the appellants. First, though the application was served on the other side 10 months ago, no objections are filed, nor any justification for not filing the objections is pleaded. First, in the above circumstances, the application having been favored, leave is accorded to place the additional documents on record.
Well, objections are ready, my lord.
You can keep it with you.
Oh, my lord, we are applied in the RTA, my lord. That recently we received, my lord. We applied.
You also file whatever documents you want to file. They have produced certain documents. You have not filed objections to the IA.
The objections are all ready, my lord.
Keep
Ready, my
them
lord.
with you.
They kindly pass over it, pass over, my lord.
Next,
We applied
or
in,
in the second week of January 20.
my lord, we applied in 15/4, my lord. Last week only we received the copy, my lord.
You received it in on 24 January, on 24 January.
No, my lord, we applied in the RTA, my lord.
What RTI?
Well, what the disputing that Sagwali Chit issue register, my lord. We applied in 15/4/2024, my lord.
You also produce them.
I will.
It is open to the answering respondent to produce his documents, if any.
It will be taken next week itself, my lord.
Next. Third week of January, next.
For the first matter in the petition,
ಅಲ್ಲಿ objections R1 to R3 ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅವ್ರು ಎಲ್ಲಿ ಹೋದ್ರು? Faiz.
ಕೊಟ್ಟಿದ್ದಾರೆ ಇವರು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇದರಿಂದ ಕನ್ಸರ್ನ್ ಅಥಾರಿಟಿ.
Objection ಕೊಟ್ಟಿರಾ?
ಹೌದೌದು.
All right. ಅಲ್ಲಿ ನೋಡಿ, this objection is complied with. Okay. Next.
In the first matter, Melo, for the memo for withdrawal,
Ah.
with liberty to seek filing is necessary, the right is arise.
Counsel for the petitioner has moved.
Connected
ಏನಂತ
matters are there, Melo.
Date fix ಮಾಡಿ.
This appears to be most memorable memo.
Yes, my lord, because my lord, they are appointed earlier as a craft teachers. Thereafter, government has passed the order in the year 96, my lord, the fixing the pay scale as per the C and rules of the department, my lord.
Bakali. Counsel for the petitioner has moved this memo signed by the petitioner himself seeking leave of the court to withdraw the petition. First off, memo is too long. First off, however, on that ground, request for withdrawal cannot be denied. First off, if any grievance is sought to be made out in the memo, that obviously would be in accordance with law.
Please.
That obviously would have to be in accordance with law. First off. No objection from the other side.
Government has to say, government has to say.
Only government.
Government.
I had.
No objection from the other side for granting leave to withdraw the petition. First, in the above circumstances, leave having been granted, petition is dismissed as having been withdrawn. First off, nothing is mentioned about certain aspects stated in the memo.
That's those connected matters, my lord.
Ah.
A date may be fixed for hearing, my lord. Government's appeal, my lord.
Government appeals.
Several times they took time.
They have
No,
taken.
argument ready, Devi. Argument.
Then I have to seek instructions. This is regarding fixation of pay scale, my lord.
Pay scale.
Yes, my lord. For craft
Disparate.
teacher,
Ah.
I'll seek instructions. You can
Third
send.
week of December at the request of learned EGA, finally.
Please,
Okay.
May I make this request?
Ah.
Could a date be assigned because the proceedings were initiated in 2017 before the
We
tribunal.
moved contempt. order.
Writ is of the year 2020.
All right, other one, dated. ಅಲ್ಲಿ ಏನಾಗ್ತದೆ?
Yes, ma'am. I
ಏನೇನೋ
understand. Your
changes
lordship's
ಆಗ್ತದೆ.
vote.
Third week ಬರ್ಲಿದ್ರೆ ಮೂವ್ ಮಾಡಿ.
Very well,
Third week of December.
very well. Obliged.
ನಾವು ಇಲ್ಲೆಲ್ಲ ಪಾರ್ಟ್ ಟೈಮ್ ಜಡ್ಜಸ್ ನಾವೆಲ್ಲ. ಬಹಳ ಕಮಿಟಿ, ಬಹಳ ಬೆಂಚಸ್ ಹಿಂಗೆಲ್ಲ ಇದೆ ಅದಕ್ಕೆ. ಓಕೆ.
Obliged.
Four point five, 4.67 ನಾ? First, non-complete. 4.7 ದಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? AGA to
yes,
issue notice. AGA. Emergent notice to R5. ನೀವ್ಯಾರ ಇದ್ದೀರಾ R5 ಅದರಲ್ಲಿ? ಇಲ್ಲ. All right, next. ಅದ್ಯಾವುದು compliance in 4.5.
steps, we will
Ah.
do the needful.
Steps in this in 4.5. Within 1 week, failing which petition stands rejected. Next.
I represent R1. Today morning, I filed my wakalat in the counter minister.
Lord,
Infra LLP.
R1 is the
R1.
only relevant party. Notice was issued to the others. I will take fresh steps, or lordship may even dispense with that, because R1 is the only contesting party as far as I am concerned.
Section 16 is what has been dealt by the arbitrator, my lords, and the present petition itself is not maintainable.
It is a case.
R6 ನೆಲ್ಲ party ಮಾಡಬಾರ್ದು.
R6 in any case notice will have to be dispensed with, because
No notice dispense, you cannot make him a party.
no, lordship, what happens is under the,
Then you take notice.
No, no.
After he comes, you may impose cost also.
no, then
The
lordship
apex
passes.
court say,
No, I'll tell lordship why. Under the rules, under the 34 rules, section 34 High Court rules, arbitration rules, for section 34, the arbitrator needs to be made a party, but notice can be dispensed with. Same as a matter of practice, even in arbitration, writs have been followed. That's the only reason why I've done it.
But latest judgment, have you seen that? Justice Oka's judgment. The arbitrator shall not be made parties
Then I will,
except in ABC.
I'll carry out an amendment. I'll carry out an amendment.
Okay.
That's the only reason why, out of caution, I made
4, 5, 6 not necessary.
4, 5, in fact, 2,
6
2.
dispense ಮಾಡ ಅವ್ರಿಗೆ ನೋಡಿದ್ರೆ ನೋಟಿಸ್ ಮಾಡಿ.
Yes, yes.
Note,
May I make a mention?
6 deletion ಕೇಳಿ.
I will.
We will say that on our instruction here, because it should not affect your right.
Lot.
Petitioner is directed to disarray respondent number 6, who happens to be a retired judge, the arbitrator. First. Sorry, ಮಾಡಿಕೊಡಿ. Emergent notice to ಆಗಿದೆ. Service ಆಗಿದೆ ಏನು? Fresh steps in respect of
2 to 5.
2 to 5. 2 to 5.
It's only on the information I filed wakalat and instructions.
I'll
Not
serve
received the copy.
I'll
Copy
of course.
ಕೊಡಿ.
Great.
For my objections, time may be granted.
Office objections to be complied with.
No, objection. Objection is only in respect of the
Preliminary-
arbitrator, so therefore I'll.
ಕೌಂಟರ್ ಕ್ಲೇಮ್ ನಲ್ಲಿ ಮಾಡೋದು ಬೇಡವಾ? ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಇದ್ರೆ ಮಾಡ್ಬೇಕಾಗತ್ತಲ್ಲ. ಅಲ್ಲಿ R2 to R5 ಬೇಕಾಗ್ತಾರೆ ಅವ್ರು. Petitioner seeks time to implead.
ಈ ಪಿಟಿಷನ್ ಏನ್ ಬೇಕಾಗಲ್ಲ. ಸೆಕ್ಷನ್
ಬೇಕಾಗಲ್ಲ?
16 ಅಷ್ಟೇ ಇರೋದು.
316 ಇರೋದು.
16 ಒಂದೇ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು. ಬಟ್ ಅವ್ರ ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಇದೆ. ಇವ್ರದ್ದು ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಆಸ್ ಅಗೇನ್ಸ್ಟ್ ದೆಮ್.
Office objection as to non-arraignment of counterclaimants is overruled.
For my objections, time may be granted.
ಅಲ್ಲ, ಯಾವಾಗ ಮಾಡ್ತೀರಿ?
After 2 weeks.
All right. 2 weeks for filing objections, if any.
Okay.
Next. Scrutiny bench. In non-compliance of office objections raised in scrutiny bench, can there any other branch?
Translation.
Translation, ಅಲ್ಲ, ಇಷ್ಟೆಲ್ಲ ಬರೀತಾರೆ. Non-compliance of office objection. Okay. What is this, brother? Anil Kumar.
This is the retro perspective of the excise department, my lord.
Huh? Promotion.
To-
Three. Steps, non-compliant office objection separate ಇದೆ. Translation. Translation dispensed it for the time being. Steps in respect of R3 within 3 days, failing which petition as against him stands rejected. As against him all petition ಹೋಗುತ್ತೆ. Petition stands rejected. Okay.
Appealing for the petitioner, my lord. There are 3 minor objections.
Non-compliance of four time. How many times the matter should come before the court?
There were like 150 pages to be translated, my lord. We have done all
Translation
that.
ಬಿಡಿ. Translation ಏನ್ ಬೇಕಿಲ್ಲ.
We have done all that. Now,
ಏನಿದೆ?
since the petition is large,
Huh?
it has to be divided into 2 is
2 volumes. Pages exceed ಆಗಿದೆ ಅಂತನಾ? Color photographs. ಹೆಂಗರು ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಪಿಟಿಷನರ್ ಅಲ್ಲಿ?
petitioner.
ಪಿಟಿಷನರ್. ನೋಡೋಣ ಹೆಂಗಿದೆ. ಏನಿದೆ ಮ್ಯಾಟ್ರ್ ಹೇಳಿ. ಮೆರಿಟ್ಸ್ ನಾಗ ಏನ್ರ ಇದ್ರೆ ನೋಡೋಣ. ಮೆರಿಟ್ಸ್ ನಾಗ ಏನಿಲ್ಲ ಅಂದ್ರೆ ಸುಮ್ಮನೆ ಇಲ್ಲ ಅದ್ರ ಮೇಲೆ ಹೋಗುತ್ತೆ. ಏನಿದೆ?
ರೂರಲ್ ಕ್ಲೈಮ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಗೆ.
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಪಿಟಿಷನ್ ಹಾಕುವಾಗ ಇಷ್ಟು ದಪ್ಪ ಮಾಡಬಾರ್ದು.
Produced your lordship.
We are weak judges. We can't lift heavy weights. We are not heavyweight lifters. Office objection is overruled with the request that hereafter such objection shall not be, no scope will be given for such objections. All right. Yes, brother, ಏನಿದು? ಹೇಳಿ.
My lord, rural quota was claimed, my lord.
ಹಾ.
So BEO initially issued the certificate for rural quota. Then later on, when it went for verification, they themselves have rejected the quota
Yes.
saying.
ಏನಂತ?
Within the limits of municipality, the where he has studied, your lordship.
ಹಾ.
The school where he has studied comes within the
Municipal limits.
municipality area.
So municipal schools.
Please, your lordship.
BBMP
He is
run
not
schools.
eligible for rural quota. So he has claimed under rural quota, therefore it was rejected.
But my lord,
And in fact, he has also admitted that by mistake it was issued.
That certificate.
but it was issued, madam.
Considering that fact, you not.
That issued, all right. But suppose it is issued, but what is issued does not have the truth. The truth remains that you studied in municipal schools. How rural quota?
Ramdurga village, 269 you lost.
Ramdurga village,
Ramdurga town.
Town.
269 page you lost.
269.
Town since 1927 itself.
269,
ಅದರಲ್ಲಿ ರಾಮದುರ್ಗ ಪುರಸಭೆ since 1927 ಈವರೆಗೆ.
ಏನಿದು? ಇದು ಕನ್ನಡ ಎಲ್ಲಿದೆ ಇದ್ರದ್ದು? 266
269.
269. 268, 269. ಏನದು ನೀವು?
ರಾಮದುರ್ಗ
270.
ಬೆಳಗಾವಿ ಜಿಲ್ಲೆ ರಾಮದುರ್ಗ ಪುರಸಭೆ 5/6/1927 ಈವರೆಗೆ.
ದೊಡ್ಡ ನಗರ ಪ್ರದೇಶ, ಲಾರ್ಜರ್ ಅರ್ಬನ್ ಏರಿಯಾನ, ಗ್ರೇಟರ್ ಅರ್ಬನ್ ಏರಿಯಾ.
ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಅವ್ರು ಕೊಟ್ಟಿರೋ ಪೇಜ್ ಕೊಟ್ಟಿದ್ದೇನೆ.
270.
269.
269. ನೀವು ಓದಿ, ಅದು ಏನಿದೆ ಓದಿ ನೋಡೋಣ.
ಇದರಲ್ಲಿ ರಿಗಾರ್ಡಿಂಗ್ ಪುರಸಭೆ ರಾಮದುರ್ಗ ಪುರಸಭೆ 5/6/1927 ಇಂದ ಈವರೆಗೆ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. And the document is also produced, that certificate, your lordship, transfer certificate of the, it refers to Ramdurga, does not refers to any rural area.
You have studied in at municipal
Pragati
schools.
Vidyalaya, ಅನುದಾನಿತ ಶಾಲೆ ರಾಮದುರ್ಗ ಅಂತಾನೆ ಇದೆ.
ಮೊದಲಿಂದನೂ ರಾಮದುರ್ಗ ಸ್ಕೂಲ್ನಲ್ಲೇ ಓದಿದ್ದಾರೆ.
ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ 274 ಬನ್ನಿ. ಈ ಶಾಲೆಯು ಕರ್ನಾಟಕ ಪೌರ ನಿಗಮಗಳು ಅಧಿನಿಯಮ 76/64 ಅಡಿಯಲ್ಲಿ ನಿರ್ದಿಷ್ಟಪಡಿಸಿದ ದೊಡ್ಡ ನಗರ ಪ್ರದೇಶ, ಸಣ್ಣ ನಗರ ಪ್ರದೇಶ ಅಥವಾ ಪರಿವರ್ತನೆ ಆದ ಪ್ರದೇಶಗಳ ಹೊರತಾದ ಪ್ರದೇಶದಲ್ಲಿದೆ ಅಂತ ಒಂದಿದೆಯಲ್ಲ.
ಅದನ್ನ ಅವರು ಹೇಳ್ತಾ ಇರೋದು ಇದ್ರ ಬಗ್ಗೆ, ತಹಸೀಲ್ದಾರ್ ರಿಪೋರ್ಟ್ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ.
ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿಗಳು ರಾಮದುರ್ಗ ಜಿಲ್ಲೆ,
ಪ್ರಧಾನ ಗುರುಗಳು ಇದೆ. ಅಲ್ಲ ಜಿಲ್ಲೆ ಅಲ್ಲ, ರೂರಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಅಂದ್ರೆ ಏನ್ ಡೆಫಿನಿಷನ್ ಏನಿದೆ? ರೂರಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಅಂದ್ರೆ ಯಾರು? ನಿಮ್ಮ ರೂರಲ್
ಒಂದು ಹುದ್ದೆಗೆ ಲಾರ್ಡ್ಶಿಪ್ 264 ಅದು ಪರೀಕ್ಷೆ SLC ಅಥವಾ ಉನ್ನತ ಗ್ರಾಮೀಣ ಅಭ್ಯರ್ಥಿ ಎಂದರೆ ಒಂದು ಹುದ್ದೆಗಾಗಿ ನೇಮಿಸಲಾದ ಅರ್ಹತಾ ಪರೀಕ್ಷೆಯು SLC ಅಥವಾ ಉನ್ನತ ಪರೀಕ್ಷೆಯಾಗಿದ್ದಲ್ಲಿ 1ನೇ ತರಗತಿಯಿಂದ 10ನೇ ತರಗತಿಯವರೆಗೆ, ಒಂದು ಹುದ್ದೆಗೆ ನಿಯಮಿಸಲಾದ ಅರ್ಹತಾ ಪರೀಕ್ಷೆಯ SLCಗಿಂತ ಕಡಿಮೆಯಾಗಿದ್ದಲ್ಲಿ 1ನೇ ತರಗತಿ ಅರ್ಹತಾ ಪರೀಕ್ಷೆಯವರೆಗೆ ಕರ್ನಾಟಕ ಪೌರ ನಿಗಮಗಳ ಅಧಿನಿಯಮ 1976 ಅಥವಾ ಕರ್ನಾಟಕದ ಪುರಸಭೆ ಅಧಿನಿಯಮ 1964 ಅಡಿಯಲ್ಲಿ ನಿರ್ದಿಷ್ಟಪಡಿಸಿದೆ. ಒಂದು ದೊಡ್ಡ ನಗರ ಪ್ರದೇಶ, ಸಣ್ಣ ನಗರ ಪ್ರದೇಶ ಅಥವಾ ಪರಿವರ್ತನೆ ಹಂತದಲ್ಲಿ
ದೊಡ್ಡ ನಗರ ಪ್ರದೇಶದ ಹೊರಗಡೆ ಇದೆ ಅಂತ, ಹೊರತಾದ ಪ್ರದೇಶದಲ್ಲಿದೆ.
ಬಟ್ ಮುನ್ಸಿಪಾಲಿಟಿನೇ ಅಂತ ಇದೆಯಲ್ಲ ಸರ್, 269 ಮುನ್ಸಿಪಾಲಿಟಿ ಅಂತಾನೆ ಇದೆ.
ಏನ್ರಿ ನೀವೇನ್ ಹೇಳ್ತಾನೆ ಇಲ್ಲ?
My lord, kind submission, my lord. 2 days time may be granted, my lord. Because senior is going to come and argue.
ಸೀನಿಯರ್ ತಗೊಂಡು ಏನ್ ಮಾಡ್ತೀರಿ? ನಿಮ್ ಕೈಯಲ್ಲಿ ಫೈಲ್ ಇತ್ತು, ನೀವು ಓದ್ಕೊಳ್ಳಿಲ್ವಾ? ನೀವ್ ಯಾಕೆ ಓದ್ಲಿಲ್ಲಪ್ಪ? ಯಾಕಂದ್ರೆ ಫೈಲ್ ಹೊತ್ಕೊಂಡು ಹೋಗೋದು ಅಷ್ಟನ್ನ ಕೆಲಸ.
Kindly 2 days.
ಮತ್ತೆ ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕು, ನಿಮ್ಗೊಂದು ಅಪರ್ಚುನಿಟಿ ಅಲ್ವಾ? ಆಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ನಮ್ಮೇಲೆ ಹಾಕ್ಲಿಕ್ಕೆ ಬಂದೇ ಬರ್ತದ. ಆ ಜಡ್ಜಿಗೆ ಏನ್ ತಿಳಿಲಿಲ್ಲ, ಏನಿಲ್ಲ, ಬೇರೆ ಏನೋ ಒಂದು ಬರ್ದು ಹಾಕ್ದ ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಕ್ ಬರಲ್ಲ. ಆಮೇಲೆ ಓದಂಗೆಲ್ಲ ಓದ್ಕೋಬೇಕು ಫೈಲ್, ಒಂದು ಅಪರ್ಚುನಿಟಿ. ವೆನ್ ಸೀನಿಯರ್ ಇಸ್ ನಾಟ್ ವೆಲ್ ಆರ್ away from place, they are all golden opportunities for the juniors to exhibit their talent in the court. You should pray God, let my senior be happy, but be outside court. Yes. Yes, simple is the case. Next week. On request. Okay. Arjun, counsel submission with respect to office objection number 2.
Lord, there is an office objection on limitation, time to file, my lord. The registry's contention, it is 30 days. This is an appeal coming, it's an original side appeal from an order of the company judge, my lord. So as per the rules, it is whatever is applicable to RFA applies to this. So it is 90 days, which is filed well within 90 days.
Within RFA, if it is within Bangalore, 90 days. 60 days alva. Outside Bangalore, it is 90 days. 60 days.
Entry 116, A nalli barutte, to a high court from any decree or order. There's a division bench. I agree, the law, the court.
Other than Bangalore idre, 90 days. If we in Bangalore ittu andre 60 days anta hold madar Swami. Justice, Honorable Justice Swami, a great judge of this court.
Yes.
On the application haki. ನೋಡ್ಕೊಂಡಾದ್ರು ಬನ್ನಿ.
ನೋಡ್ತೇವೆ. The way we read it, seems 90
way-
ಇಲ್ಲಾದ್ರೆ ಒಂದು ಹಾಕ್ತೇವೆ. I mean, after all, it's an application. We'll file an application.
2 weeks.
An application.
ನೋಡ್ಕೊಂಡ ಹಂಗೆ ಅವ್ರು ಹೇಳ್ತಾರಂತ ಹಾಕೋದಲ್ಲ. That's what we
will examine it.
Honorable Justice Swami say.
We'll
Appeals
examine.
Coming from outside Bangalore, 90 days. In Bangalore, 60 days ಅಂತ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಓದಿದ್ದೆ ನಾನು.
ನೋಡ್ತೀವಿ.
ನೋಡ್ಕೊಂಡೆ. ಅಲ್ಲ. 2 weeks?
2 weeks.
2 weeks.
ಆಮೇಲೆ ಅದು in between, either this is arising out of a thing, single judge, company judge. ಅದು ಇದು enquiry, the evidence ಅಂತ December 3rd post ಮಾಡಿದ್ದಾರೆ. Let them not precipitate till
Next week ಹಾಕ್ಬೇಡಿ. Next week, call next week. Next week ನೀವು ಸರಿ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. We can't touch after that, which is that famous judgment. ಅದು ಉತ್ತರಾದಿ ಮಠ್ versus ರಾಘವೇಂದ್ರ ಸ್ವಾಮಿ ಮಠ್. After that judgment, unless delay is condoned.
you can't pass any.
ಅದಕ್ಕೆ
Next week oblige me.
ನೋಡ್ಕೊಂಡು ನಮಗೂ ಹೇಳಿ ಕರೆಕ್ಟ್ ಪೊಸಿಷನ್ ಏನಿದೆ ಅಂತ. So that we can make it use of that. Fine. Vijay Kumar.
I appear.
Serious, first matter, Lord, respond number 24. Lord, respond number 24 has been deleted before the tribunal itself, Lord. And in connected matter, that order is passed on 30th of April 2024, Lord. Deleted the respond number 24.
Counsel for the petitioner submits that response number 24 being neither a necessary nor a proper party be deleted from the array of the cause.
Please, my lord. In connected matter is already deleted, my lord.
First off, he also adds that the said respondent is already deleted in the companion writ petition.
And in respect of, in connected matter, my lord, 3 respondents, my lord, have already filed wakalat.
Undertake to file wakalat.
3.
R38.
Gayatri, panel counsel.
Respondents. Private respondent.
Respondents, 38, 64 and 69.
Notice. For response numbers?
68, 64 and 69.
Normal. 38, 64, 69.
Blood, urgency is there, my lord, because our promotion to the next cadre is, my lord, it is not granting because of the pendency of this petition. My lord, we respondents, my lord, in the special recruitment, my lord, we entered into services in the year 2016. My lord, as per the 2000, my lord, the RDPI department, my lord, framed the rules in the year 2008. One time option was given under the rules. These petitioners, they have not exercised the option, even though they were working in the, my lord, PW department.
From there they came here.
Please, my lord. Thereafter, my lord, we were promoted to the cadre of, my lord, the assistant executive engineer on 1/7/2020.
Entry ಮಾಡಿದೆ ಅಲ್ಲ. ಹೌದು. Subject to result.
Subject result ಅಂತ ಇದೆ, but ಆದ್ರೂ ಪ್ರಮೋಷನ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
My lords may fix a date,
Short
any day,
point
my
is there, my lord, any date may be fixed.
Yes, my lord. We are also ready in the matter, my lords. My lords may fix a date in the matter so that.
ಇದು
We heard and
ಇದರಲ್ಲಿ ಕವರ್ ಆಗತ್ತಾನು ಡಾಕ್ಟರ್ ರೇಣುಕಾ ಪ್ರಸಾದ್ ವರ್ಸಸ್ ಆಗತ್ತಾ? Do you have that judgment?
ಅದು ಇದೆ, ಇನ್ನೊಂದು ಕೇಸಿಗೆ ತಂದಿದ್ದೀನಿ, ಇದೆ ಸ್ವಾಮಿ.
ಇದೆಯಾ?
ಇದೆ.
ಮತ್ತೆ ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
ನೋಡ್ಕೊಂಬನ್ನಿ.
Please, my lord.
In the second week of January 2025.
Please, second week, ಡಿಸೆಂಬರ್ ದೊಳಗೆ.
ಡಿಸೆಂಬರ್ ಆಗಲ್ಲ. December, you have seen roses in December, chaglas. In December, we should not work.
At least first week of January.
First week.
Please.
Macho.
Great.
Have you read that book? Roses in December by M.C. Chagla.
ಇಲ್ಲ, ನೋಡ್ತೇನೆ.
The finest books. If it appears your colleague has read that.
For us, it was a lesson in.
ಅದನ್ನ ಕನ್ನಡಕ್ಕೆ ಅನುವಾದಿಸ್ಯಾರ. ಶಿಶಿರದ ಹೂವುಗಳು, ಶಿಶಿರದ ಗುಲಾಬಿಗಳು. ಎಷ್ಟು ಚಂದ ಇದೆ ಕನ್ನಡ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಸಹಿತ. ನೋಡಿ ಒಂದ್ಸರಿ, ಬ್ಯೂಟಿಫುಲ್ ಬುಕ್.
ಮತ್ತೆ
ಶಿಶಿರದ ಗುಲಾಬಿಗಳು.
Respond number 3, man.
Yes, Satish, ಏನಿದೆ?
But
Translation.
the only office objection is not translation. But the petitioner was working as my lord assistant executive engineer in my lord Vijayanagar subdivision. But the allegation is my lord with regard to unauthorized construction, which is permitted, alleged to have been permitted by the petitioner, my lord, while working at Vijayanagar. Lord, I have issued, my lord, 321 notice. Lord, there is a delay of, my lord, the complaint was given, Lord, on 21/1/2022. Lord, I have issued notice after 15 days.
Complaint is not a cause of action. Illegal construction is. Complaint ಕೊಡ್ತಿರ್ಲಿಲ್ಲ.
There is a delay in taking action is the after
section 421 address
321
provisional order, confirmation order.
321.
ಮಾಡಿದೀನಿ, ಅದನ್ನೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಯಾವಾಗ ಕೊಟ್ಟಿದ್ರಿ? ಅವರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟ ಮೇಲೆ ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಿರ್ಲಿಲ್ಲ.
Complaint on facts, my lord, only after
ಇದು ಏನು
withholding of 2 annual increments with cumulative effect.
The lordships may kindly peruse page 101.
ಅದಷ್ಟೇನ ಅಲಿಗೇಷನ್, ಬೇರೆ ಏನ್ರ ಇದೆಯಾ?
ಅಷ್ಟೇನೆ ಸರ್, ಅದಷ್ಟೇನೆ.
ನಾವೆಲ್ಲ ಬೇರೆ ಕೇಸ್ನಲ್ಲಿ 1 increment ಮಾಡಿ, 1 annual increment with cumulative effect.
Please.
ಆ ರೀತಿ ಮಾಡಿ.
17 is the complaint. He issues notice under 321 subclause 1 in 2018.
2018.
After 1 year, he takes that is
ಹಂಗಾಗಿ 1 annual increment, 1 year ಇದೆ. 2 years is the 2 increments. Allowed in part. Punishment downwardly altered to withholding of 1 annual increment with cumulative effect. ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ನಾವು ಹೋಲ್ಡ್ ಮಾಡಿದ್ದು? ಯಾರು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ವಿ? ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರಲ್ಲ.
Mr.
ಸಂಜೀವ ಯಾರು?
Mr. Nagbhushan has argued last week.
ಅದೊಂದು ಕಾಪಿ ಇದೆಯಾ?
It is not released, my lord.
Release ಆಗಿಲ್ವಾ? Why our judgment every day we sign judgments and go home. ಅಲ್ಲಿ ತನಕ ಹೋಗೋದೇ ಇಲ್ಲ ನಾವು. ಬಾರಿಂಗ್ 1 or 2 ಎಲ್ಲಿ ಬಹಳ ಕಾಂಪ್ಲಿಕೇಶನ್ ಇರ್ತದೆ, where we want to put a lot of frill to the frock, ಅವಾಗ ಮಾತ್ರ ಟೈಮ್ ತಗೋತೇವೆ ನಾವು. Otherwise day to day judgments every day we sign and then go home.
Yes,
then we don't get down at all.
On the same day or next day it will be released.
That's what. One annual.
One in
next. Next.
Only one
sentence very big. We are mindful of the legal position that ordinarily the levy of penalty punishment is within the exclusive domain of the employer, subject to all just exceptions. First, however, withholding of 2 annual increments is disproportionate and therefore disproportionate to the gravity of the charge proved and therefore violates the doctrine of proportionality. Adu.
Begar.
Begar alla.
Proportionality.
Proportionality there. Begar is a state, High Court of Gujarat versus State of Gujarat.
Yes.
Adbe. Nodama, to the 2009 or something is there. Okay. Next.
This will not come in the way of his promotion to the next cadre.
Okay.
Not one increment.
1 increment ಬರಲ್ಲ ಅಂತ ಬರ್ತದೆ.
ಅಲ್ಲ, with cumulative effect ಆದ್ರೆ ಬರುತ್ತೆ. ನೋಡಿ 1 ವರ್ಷ ಆಗೋಗುತ್ತೆ ಅಂತ ಈಗ. The order is dated 8/8/2023.
With cumulative effect ಇದ್ರೆ ಅಂತ ನಾಗರಾಜನ್
1 ವರ್ಷ ಬರುತ್ತೆ ಸ್ವಾಮಿ.
ಒಂದೇ ವರ್ಷ.
1 ವರ್ಷ ಬರುತ್ತೆ. 8/8/2024 ಗೆ ಮುಗಿಯುತ್ತೆ.
We have noted that this altered punishment will not come in the way of petitioner earning the promotion in accordance with law.
Yes, 8/8/2024, it, by modification, my lord, it comes to
Because
8/8
1 year has already lapsed.
lapsed.
Since 1 year has already lapsed. On 8/8/24,
Yes,
Okay.
7/8/2024.
Next. Good.
Please, my lords, I filed an application for dispensation of Kannada translation.
All
Lords. Please, my
translation.
lords. And the second objection raised is, my lords,
Yeah.
annexure A9, page number.
ಮೆರಿಟ್ಸ್ ಹೇಳ್ರಿ ನೋಡೋಣ ಆಮೇಲೆ
Please,
ಅಲ್ಲಿ ಹೋಗೋಣ
Lords,
ಅಲ್ಲಿ ತನಕ ಹೋಗೋ ಪ್ರಸಂಗನ ಬರಲಿದ್ರೆ
Please. My lords, the
Merits
petitioner's,
ಮೇಲೆ ಹೇಳಿ.
the petitioner's retrospective promotion has been withdrawn, my lords, without assigning,
Retrospective promotion is withdrawn.
my lords,
On what?
without assigning any reasons, my lord.
Without assigning any.
Please, my lords.
ಯಾವ್ದು order?
My lords, the court holds that, my lords, it has done due to administrative purpose. Page 21 is the impugned order, my lords, annexure A.
21 is tribunal's order.
Please, my lord, tribunal's order.
ಅಲ್ಲಿ ಅವ್ರು ಇವ್ರದ್ದು ವಿಡ್ರಾ ಮಾಡಿದ್ದೆಲ್ಲಿದೆ?
Withdraw ಮಾಡಿದ್ದು, my lords, annexure A15, page number.
Next, sir.
Page 30, Lord.
Page number 200, my lords. Annexure A14, 197 is the starting, my lords. Relevant portion is at 200.
Why they withdrew?
My lords,
Explained in
on the basis of, my
30,
lords,
Lord, 80 order.
Page 30.
30.
Substantive portion ಅಲ್ಲಿ ಇರಲಿಲ್ಲ.
my lords, what has happened is, my lords,
Well, we were not holding the substantive post at all.
no, my lords, what has happened is, my lords, 2000 gradation list was prepared, my lords. Lord, that list was challenged before the tribunal, my lords, in several applications, my lords. Lords, ultimately, my lords, the tribunal holds that, my lords, the 2000 list, gradation list which was prepared, seniority list, that has attained finality, my lords. Lords, as per the 2000 list, my lords, the petitioner, my lords, is eligible for promotion, my lords. Hence, my lords, retrospective promotions, he retired in 2013, my lords. Lords, he was given retrospective promotions, my lord, for grade 2 Tahsildar, my lords, and grade 1 Tahsildar, my lords. Lords,
ಇದೇನು ಈ
please.
withdrawal after retirement ಆಗಿದೆ ಏನು?
ಹೌದು ಸ್ವಾಮಿ, withdrawal.
Brother, after retirement ಇದ್ರೆ ಸ್ವಲ್ಪ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಇದ್ದಾಗ ಏನೋ ಒಂದು ಮಾಡಿದ್ರೆ that's another thing. Pension ಎಲ್ಲ ಫಿಕ್ಸ್ ಆಗಿರುತ್ತೆ. Based upon that, he organizes his the evening of his life. Issue notice.
Lords, I have sought for interim order, my lords.
ಏನಂತ? ಕೆಳಗಲ್ಲಿ ಇತ್ತ ಎಂಟ್ರಿ ಮಾಡಿರ್ತ ಕೋರ್ಟ್ KAT-ಯಲ್ಲಿ?
Retired, your Lord. The retired.
That's what.
ಇಲ್ಲ,
ಅಲ್ಲ ಬಟ್ ಟರ್ಮಿನಲ್ ಬೆನಿಫಿಟ್ಸ್ ಅಲ್ಟರ್ ಆಗಬಾರ್ದು.
please, lords.
Learned AGA is requested to accept notice for the respondents. No adverse action pursuant to order that was impugned before the KAT would be taken till next date of hearing.
Please, my lords, much of it.
Full stop. This order is made in the special circumstance, namely, the petitioner has already retired from service and that the order that was impugned in the KAT, before the KAT was made post-retirement. Okay.
Lord, appearing for the petitioner in this matter. Well, appearing for the petitioner in this matter, my lord, kindly request for a passover, senior counsel.
Passover?
Please.
Please, second matters, 12 something, one other. Vacate in Northern Station.
Huh?
Vacate in Northern Station. We are Sarthi.
Where Sarthi is not here.
Lords, the
ಯಾವಾಗ
state,
ಬರ್ತದೆ?
state had moved this matter
Ah.
on 14/10/2024. Matter pertains to, my lords, transfer of medical officers under the act and the rules through counseling, my lords. The court had permitted us, the provisional list was challenged. The court had permitted us to finalize it and place it before the court, take the leave of the court. We have submitted, my lords, on 29th of October, the final vacancy list, where we have considered all their objections, and, my lords, additional posts have been included. Their objections have been considered. Final priority list and vacancy list has been held. Now, my lord, we have placed it before the court. We seek leave of the court, my lords, to proceed with the counseling. Not only that, in the meantime, 44 medical officers are waiting for posting. I'm not able to send them, my lords, because I have to hold it through counseling only. So that is the difficulty, my lords.
ಸಾರಥಿ ನಾಳೆ ಹಾಕೋಣ.
ನಾಳೆ ಹಾಕ್ಬೋದು.
Please.
Tomorrow.
Lord, interim order. maybe.
Request of Sarthi, interim order to continue for 1 day. Yes.
Grateful. Please, my lord.
I had recited. And it is on the service report is awaited of the sole respondent.
Yes, sir. Await notice.
Interim order to continue.
Interim order ಇದೆಯಾ?
Please, my lord.
ಇದೆಯಾ?
Please, my lord.
Interim order to continue.
Please. Obliged.
Deeply obliged.
Kindly pass it
Yes,
over.
Kashi ಏನಿದು?
Kindly pass over.
Pass over. Pass over. Yes, subject number.
My lord, the petitioner has challenged the order dated 12/3/2024 passed by the Honorable KCT in application number 4584/2023, my lord. My lord, the petitioner has issued the notification calling for applications to fill up the posts of Sub-Inspector of Excise, Excise Guard men and Excise Guard woman. The respondent number 1 has applied for the post of Excise Guard man, giving first preference to Bangalore Rural District, second preference to Bangalore Urban District, third preference to Tumkur District, 25th preference to Kolar District. Therefore, my lord, the petition has published the revised additional selection list on 38/2023, in which, in additional selection list, the respondent number 1 came to be selected. Respondent number 4 also came to be selected in additional selection list, my lord. And my lord, thereafter, the petitioner has published the district-wise additional selection list, posting the respondent number 1 to the Kolar district and posting respondent number 4 to the Bangalore Urban District. The grievance of the petitioner is that, albeit he has given the first preference to, second preference to Bangalore Urban District, he was not given to Bangalore Urban District, but he was shown to Kolar District. It is his grievance. My lord, the respondent number 1 was not selected in the final selection list. He was selected in the additional selection. It means, my lord, he was one of the candidates selected under GM and others against the vacant post which arose due to the non-reporting of 3 candidates under GM others category, reservation category under Kolar district. And respondent number 4 was selected under GM others against the vacant post which had fallen vacant due to the non-reporting candidates who were selected under GM others under Bangalore Urban District. My lord, at the time of preparing the additional selection list, the preferences will not be
Marks nimdestu.
Lord, my marks is 219, his marks is 217. Lord,
17.
Yes, Lord, preference should be in accordance, not
Merits.
merit.
My lord,
Lord, the copy.
I have posted, my lord.
All right, answer. We have read paper side. We have not come to.
In view of rule 10,
Marriage children. Rule padi.
in view of, my lord, rule 10 of Karnataka Civil Services.
All right, rule 10 odi.
Rule 10, my lord. After provided, my lord.
in the order of merit.
For form number 7, I have received form number 7 from DC Excise Kolar district on 25/2020.
No, but otherwise,
One more matter of other court is being argued.
My lord, I have received form number 7 first in point of time.
Come to 10, read 10, last line.
Yes, ma'am.
To the different appointing authorities arranging their names in the order of merit.
My lord, I'm taking your lordship to last para. After appointment of candidates, because my lord, he has not been selected under the final selection list. He has been selected under the additional selection list. I will take your lordship kind attention to third para. After appointment of candidates assigned under sub-rule 1.
It's included an additional list prepared on sub-rule 2. I shall be assigned in accordance with the requisitions received. Different authority. The candidates included in the additional list shall be assigned to each appointing authority in the chronological order in which requisitions are received in the. How you are aggrieved by this? Who are you? You are only selection.
My lord, I have posted him to Kolar. He was shown to Kolar district. Respondent for was shown to urban district.
You are only selection.
Because my lord, I have prepared the list in view of rule 10, my lord.
You prepared this. How you are aggrieved by this?
My lord.
Other candidate can be aggrieved.
No, my lord. I want humble submission. I have issued form number 7 from DC Excise Kolar on 25/2020. Thereafter, I have issued form number 7 from DC Excise Bangalore on 9/4/2020. I will take your lordship's kind attention to page number 253. Page number 253, my lord. That is form number 7 issued from Kolar district, that is 25/2020. Page number 253.
One day earlier.
One ವರ್ಷ ಮೊದಲು, my lord.
1 year earlier.
ಯಾಕಂದ್ರೆ ಆಮೇಲೆ I have issued the requisition from
This is not tea shop. Give it back. Give it back. This is not tea shop.
Yes, I have not produced, my lord.
You are not produced, means you should suffer.
Yes, I'm sorry, my lord. I'm sorry, my lord. My lord, I have prepared the list as per rule 10 of I have prepared the list as per rule of Karnataka Civil Services Recruitment of the Ministerial Post Rules 1978. Because what it says, my lord, if a candidate had not been selected in the final selection list, if he has been selected in the additional selection list, then rule 10 has to be followed. This is what I have followed. Because respondent came to be selected against the vacant post. He was not selected in the final selection list. Had he been selected in the final selection list, then preference would have been given. But here is a case where he was selected in the final additional selection list. So I have followed rule 10.
Come to para 8, that is 221. The reasoning is given by the KT. 221 of your paper book.
221. Yes, ma'am.
Read. Para 8.
Para 8. Both the applicants are in the essence list, which is a common list
Both
for all.
they are in the additional list.
Yes, ma'am.
You mean to say if they are in the additional list, you can act like a Mughal?
No, my humble submission is that, my lord. The form number 7, since I have
But you
received.
had consolidated list you had prepared.
No, thereafter, because what, my lord, what rule number 10 says, my lord, just I may permit.
You read it, how many times you read? We are not reading a constitution.
The third para, my lord.
Third para only I read. Third para relates to operating the additional list. There you say 10(1) ದಲ್ಲಿರುವಂತದ್ದೇನಿದೆ ಅದು ಥರ್ಡ್ ಗೆ ಅಪ್ಲೈ ಆಗಲ್ಲ ಅನ್ನೋದು ನಿಮ್ ಕಂಟೆನ್ಷನ್. How much time will take to understand
Yes,
these
yes.
things?
In a chronological way, I have to post, man.
Dismissed, agreeing with the reasoning of the tribunal. Yes, next. Refer to para 8 of the impugned judge. Next.
Lord, I am for the petitioner, my lord.
Yes, Vijay Kumar.
Yes, my lord. My lord, petitioner is a retired executive engineer, retired on 36/22, my lord. Lord, in 2001 and 2, he had executed a work relating to revival of a borewell, my lord, at a cost of 1,80,000 rupees.
My lord, a criminal case was initiated against him, my lord, alleging that he has misappropriated the funds. My lord, that criminal proceedings ended up with filing a B report in 2009 itself. Subsequently, my lord, after lapse of...
Ended in acquittal.
Yes, ma'am. No, my lord.
Acquittal.
Yes, ma'am. As per the Rudrapa's case, my lord. My lord, subsequently, my lord, after lapse of 11 years, a 12-3 report was submitted stating that there is procedural lapse.
12-3, Lokayukta.
Yes, after lapse of 11 years. Thereafter, my lord,
lapse of 11 years.
And a recommendation was made for withholding 5% of the pension permanently, my lord. My lord, it being a procedural lapse, my lord, in terms of Rule 213, my lord, there being no finding of grave misconduct, they could not have imposed the penalty of withholding 5% of the pension for permanently, my lord. That is all is my case, my lord. And there was an order of stay granted by the Honorable Tribunal during the pendency of the application.
You had entry order?
Yes, ma'am.
Whether he had entry order?
Yes, my lord. I produced Annexure C, my lord.
ಇದರಲ್ಲಿ ಎಕ್ಸೆಸ್ paid to the laborers ಅಂತ ಮಾಡಿರೋದು.
Correct. After 12 years.
80,000 rupees.
After 11 years.
It is
How he will know? Unfortunately, human memory is too short to be little. Who will remember what happened last year? ಏನಾಗಿದೆ ಗೊತ್ತಿರಲ್ಲ. ಬೇರೆ ನೆನಪಿಟ್ಕೊಳ್ಳೋದಿರಲಿ.
ಅಲ್ಲ ಅದು ಆಮೇಲೆ ರಿಮಿಟ್ ಆಗಿದೆ ಆ ದುಡ್ಡೆಲ್ಲ ಕಟ್ಟಿದಾರೆ ಅಂತ. If that is the case, your lordship, there was no occasion for her to deposit that amount. 11
ವರ್ಷ ಆದ್ಮೇಲೆ ಇದೆಲ್ಲ ಕಿರಿಕಿರಿ ಬೇಡ ಅನ್ಕೊಂಡು ಡಿಪಾಸಿಟ್ ಮಾಡಿಬಿಡ್ತಾರೆ. Who will remember after 11 years? 11 months ಅನ್ನು ನೆನಪಿಟ್ಕೊಳ್ಳೋ ಶಕ್ತಿ ಇಲ್ಲ ನಮ್ಗೆಲ್ಲ.
5ಗೆ ಮಾಡಿದ್ದಾರೆ. 7 to 2005 ಗೆ ಮಾಡಿದ್ದಾರೆ.
ಎಷ್ಟು ವರ್ಷ ಆಗಿತ್ತು ಅವಾಗ? ಅವಾಗ 11 years ಆಗಿತ್ತು.
2 years ಆಗಿತ್ತು. 2 years ಆಗಿತ್ತು.
No.
2002 the ಸಮಯ.
Correct. But action is sought to be taken when? After 11 years.
Continued, your lordship. Action was continued.
Issue notice, entry order as per for learned AG is requested to accept notice for the respondent. Full stop. We have issued entry order, keeping in view two aspects. Number one, the petitioner had the entry order at the hands of the tribunal. Number two, 12-2 report is acted upon highly belatedly. Okay. Next. Yes, Nagendra.
Senior is held up in another court.
You start. We'll help you. You start on the one mushti marks ಜಾಸ್ತಿ ಕೊಟ್ಬಿಡ್ತೇವೆ ಈಗ ನೀ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ. You start, turn the pages. Turn the pages. ಹೇಳಿ ಓಪನ್ ಮಾಡಿ ಬುಕ್. ಏನಿದು ಅರೆಸ್ಟ್ ಏನಾ?
ಲೋಕಾಯುಕ್ತ ಅನ್ನೋದು ಯಾರಿಗೆ?
ಲೋಕಾಯುಕ್ತ. You for R1.
ಹೌದು.
ಅಲ್ಲೇ ಲೋಕಾಯುಕ್ತಿಗೆ ಅದು ಮಾಡ್ಕೋಬೇಕು. Turn pages. ಪುಟ ತಿರ್ಸಿ. ಪುಟ ಅಂದ್ರೆ ಏನ್ ಗೊತ್ತಾ? ಏನಾಗಿದ್ರ ಇದು? ಒಂದ್ ಸ್ವಲ್ಪ ಏನ್ರ ಹೇಳ್ಬೇಕಲ್ಲ ನೀನ್ ನಮ್ಗೆ ಇವತ್ತು. ಏನ್ರ ನೀನು ಹೇಳ್ದಂಗ ನಾವು ಬಿಡಲ್ಲ ನಿನ್ಗೆ ಇವತ್ತು.
Hyderabad Karnataka reservation without considering that reservation.
Without considering norms of reservation. ಏನಂತ ಆಗಿದೆ? You just say how it happened.
They rejected.
Why tribunal denied a leave to you?
Page
ಯಾರು ನಿಮ್ ಕ್ಲೈಂಟ್ ಏನ್ ಮಾಡ್ತಾರೆ? ನಾಗೇಂದ್ರ, ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಬಾರಿಗೆ ಬಂದು? ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಲಾಯರ್ ಆಗಿ? ಎಷ್ಟು ವರ್ಷ?
5 years.
5 years. ಎಷ್ಟೊತ್ತಿಗೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕಲ್ಲ. ಇದರಲ್ಲಿ ವಿಲ್ ಸ್ಟಾರ್ಟ್ ದಟ್. ಜಸ್ಟ್ ರೀಡ್. ಏನಾರ ಡಿಫಿಕಲ್ಟಿ ಇದ್ರೆ ವಿಲ್ ಹೆಲ್ಪ್ ಯು. ಡೋಂಟ್ ವರಿ. ಡಿಸ್ಮಿಸ್ಸಿಂಗು ಮಾಡಲ್ಲ. ಏನಿದು ಮ್ಯಾಟ್ರು? ಅರೆಸ್ಟ್ ಏನಾ? RF ಏನೋ RS ಏನೋ ಇದು?
Writ petition.
Writ petition. ಯಾವ ಸೆಕ್ಷನ್ ಕೆಳಗಡೆ? 96 or 100?
226.
226, 227. Correct. Wonderfully answered. Next go to the ಆರ್ಡರ್. ಯಾವುದು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ ನೀವಲ್ಲಿ KAT ಅಲ್ಲಿ? Go to 133. Come to 134. ಅಲ್ಲಿ 134 ನಲ್ಲಿ ಇಲ್ಲಿ ನೋಡು, ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದೆ ನೋಡು, ಅದ್ರಲ್ಲಿ ಸಿಗತ್ತೆ ನಿನಗೆ. ರೀಡ್ ಇಟ್ ನೌ. This application is
The applicant
134.
The applicant being unsuccessful candidate for selection to the post of motor vehicle inspector. Transport department filed these applications are per writ in the nature of the mandamus to direct the respondents to consider select the applicant for the post.
Next time ಒಂದ್ಸರಿ ಇವೆಲ್ಲ ಓದ್ಕೊಂಬಂದ್ಬಿಡು. ಇವತ್ತು ಡಿಸ್ಮಿಸ್ ಮಾಡಲ್ಲ ಇದನ್ನ. Next time you should come after reading. Next week ಹಾಕೋಣ.
Next week.
All right. You did well. ಓಪನ್ ಮಾಡ್ಬೇಕು. ಅದು ಏನಿರಲ್ಲ ಅದರಲ್ಲಿ ಹುಲಿ ಸಿಂಹ ಇರ್ತಾವ ಒಳಗಡೆ. ಅಕ್ಷರನ ಇರ್ತದೆ ತಿರ್ಕೊಂಡು ಓದ್ಬೇಕು. All right.
Notice has to go for KPs.
Yes, ನೋಡಪ್ಪ. AG is requested to accept. Having heard, ನಿಮ್ಮ ಹೆಸರು ಏನ್ ಹೆಸರು?
Ganesh Gowda.
Ganesh
Gowda.
Having heard Ganesh Soins appearing for the petitioner, come on. We are issuing notice. First off, issue notice. AG is requested to accept notice for R1, R2. ಮತ್ತೆ ಯಾರು ಬೇರೆ?
R3 KPs.
Panel counsel ಯಾರು? KM Prakash, panel counsel is requested to accept notice for respondent number 3. Next time ನೀನೇ argue ಮಾಡಬೇಕು. You only have to argue. ಓದಿರ್ ಬರುತ್ತದು ಏನೋ ಅದ್ರಾಗ ಏನು ದೊಡ್ಡ ಅಂತ ವಿಷಯ ಇರೋದು ಇಂಗ್ಲಿಷ್ನಾಗ ಇರ್ತದೆ ಅಷ್ಟೇ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Regarding this academic pay scale, they are demanding lots. In connected matter, there is a stay referring to that matter only, not stay lots.
Stay andre
Contempt na precipitate ಮಾಡಬಾರದು ಅಂತ ಎಲ್ಲ connected ಇದೆ.
Issue.
May I just make
Supplement what appears for KVITRA?
House. ಅಲ್ಲ ಒಂದೇ ಒಂದು ಮಾತು ಹೇಳ್ಬಿಟ್ಟು ಹೇಳಿ. ಅದರಲ್ಲಿ 4 ಇನ್ಕ್ರಿಮೆಂಟ್ ಕೊಡಬೇಕು UGC ಗೈಡ್ಲೈನ್ಸ್ ಪ್ರಕಾರ. ಆಮೇಲೆ 4 ವರ್ಷ ಆದ್ಮೇಲೆ ಒಂದು ಪ್ಲೇಸ್ಮೆಂಟ್ ಕೊಡಬೇಕು. ಆಮೇಲೆ ಪುನಃ 9 ವರ್ಷಕ್ಕೆ 2ನೇ ಪ್ಲೇಸ್ಮೆಂಟ್ ಕೊಡಬೇಕು. ಅದು UGC ನಾರ್ಮ್ಸ್ ಪ್ರಕಾರ ಕೊಡಬೇಕು. All that the honorable KSAT has done is only has held that I am entitled for these benefits in terms of the statutory regulations.
ನೋಡಿ ಈಗ ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ಅನ್ನು ಪೋಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿವಿ, ಎಲ್ಲದನ್ನು ಪೋಸ್ಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ವಿ. ಅಲ್ಲಿವರೆಗೆ ನೀವು ಪ್ರೆಸಿಪಿಟೇಟ್ ಮಾಡ್ಬಿಡಿ. ಬರ್ಕೊಳ್ಳಿ.
Petition number 24803 lots.
The parties are directed. Petition ಅಲ್ಲಿ respondent KVITR is directed not to precipitate the contempt proceeding, pending contempt proceedings till next date of hearing. Call this matter.
Writ petition 24803 of 2024.
Along with.
Please.
ಎರಡು ನಂಬರ್.
Along with sides. ಅಕೌಂಟೆಂಟ್ ಜನರಲ್ಗೆ ಅವ್ರ ಅಪಿಯರ್ ಆಗ್ತಾರೆ. ಅಕೌಂಟೆಂಟ್ ಜನರಲ್ಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? ನಾವೇ ಹೆಂಗ್ ನೀವು 2 ಸೈಡ್ ಅಪಿಯರ್ ಆಗ್ತೀರಾ?
ನೋಡ್ತೇನೆ.
Issue emergent notice to respondent AG. Accountant general. Next.
21 also same lot.
Same.
Please
call along with.
ಡೇಟ್ ಏನಾದ್ರು ಸಿಗತ್ತ? ಡೇಟ್ ಸ್ವಲ್ಪ ಅರ್ಜೆಂಟ್ ಇದೆ.
No, 2024 matter. In the first week of January 22nd week of January 20.
Please.
Same. ಅದೆಲ್ಲ ಜೊತೆಗೆ ಬರ್ಲಿ, ಆರ್ಗ್ಯೂ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡು. Okay. Next. Manmohan ಏನಿದೆ? Objections. May request a short accommodation. Nagaraj wants short accommodation. Generally, he will not take time at all. Short time.
Next Monday, Lord. Next Monday, Lord. It's a short issue, Lord. Whether Lord rejection of plaint can be Lord filed and entertained, Lord, in a probate petition. Probate petition, Lord, continuous right, Lord, is available as held by the Supreme Court. Lord, the court has held, Lord, right to apply for probate is not a legal, Lord, duty. It's only a moral obligation. Therefore, the court says, Lord, it's a continuous right. So long as, Lord, the trust exists, you're entitled to file an application for probate.
ಅದಕ್ಕೆ limitation ಇಲ್ಲ ಅಂತ.
Limitation ಬರುವುದಿಲ್ಲ. That is my submission. In fact, here, Lord, there was not a suit that was filed, Lord, by the respondents, where the issue with regard to my will, Lord, which I thought now for probate, was also subject matter, and issue was framed. That suit was dismissed, Lord, which was filed by them, it was dismissed. After which immediately I filed, Lord, the probate petition. That is the only issue. Because, Lord, I relied upon the judgment, Lord said, rendered, Lord, in the full bench decision, to say that, Lord, the CPC will not strictly apply, Lord, for a probate proceedings. as far as practical is what my lords have observed. Rest,
That matter did not go to Supreme Court.
but I have not seen anything subsequent to that. I'll anyway further verify. Because
Both
learned
of us have
single
relied
judge,
judgments. Madam, both of us have relied on a judgment of Supreme Court, madam, wherein probate proceedings, CPC applies under Article 7, Rule 7, plain rejected. Both of us have relied.
We have considered, but I am the author of that judgment.
I heard.
Yes, I.
Hey, weeks, Monday, madam.
Call on Monday
grateful.
at the request of.
Please.
ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ ನಾವು ಇನ್ನೊಂದ್ ಸರಿ ಓದ್ಕೊಂಡ್ ಬಂದ್ಬಿಡ್ತೀವಿ.
Yes, Lord. I'll place the judgments on.
Myself, Narendra Prasad
Yes.
and Veerappa.
Yes, yes, yes.
Lord. Same month. Whether provisions of CPC would apply in conclusion. I think we refer to conflicting judgments.
Yes, Lord.
Number one. Number two, we refer to Jyoti Basu also.
But Jyoti Basu, not seen a reference to that.
Because same question arose in respect of representation of people act. So as far as possible CPC procedure we followed in EP.
Yes.
What is meant by that? The Justice Chinnappa Reddy's judgment. Anyway,
I'll place it on record.
wrappings up, that's what, that's what.
Wrappings of
That's
Lord,
wrappings.
Lords have given the distinction between caveat filed not in a civil proceeding.
Yeah, in CPC
And-
caveat and
Yes.
Succession Act caveat, there are two different caveats.
Grateful.
Okay.
Serial
number 23. 23.
Matter pertains.
ಅವ್ರೇನೋ ಟೈಮ್ ತೊಗೊಂಡ್ರು ಸ್ವಲ್ಪ ಇನ್ನ ಶಾರ್ಟ್ ಟೈಮ್ ಬೇಕು ಅನ್ಕೊಂಡು ನಿಮ್ಗೆ ಹೇಳಿಲ್ಲ ನಾವು ಸಾರಿ ದಟ್ ದೇ ಶುಡ್ ಹ್ಯಾವ್ ಟೋಲ್ಡ್ ಬಿಕಾಸ್ ವೆನ್ ಎಸ್ಪೆಷಲಿ ವೆನ್ ದೇರ್ ಇಸ್ amicus, it's our duty to inform them. Some date they have taken.
Well, a note, small note is being submitted.
Huh.
We'll make it available to the honorable court so that
What?
the area of
Right.
presentation forum.
I was just reading similar, Kutram. Kudu. Similar
ಯಾರು ಇಲ್ಲ ಅಂತಂದ್ರೆ ಒಂದು
provisions.
ಬಂದ್ಕೋಬೇಕು ಅಂತ ಗೊತ್ತಾಗಲ್ಲ ನಿಮ್ಗೆ ಯಾರು ಬಂದಿದ್ದು ಎಲ್ಲಿ ಬಂದಿದ್ದು
Similar provisions on some parts of the globe. Perhaps these provisions are made, as Oliver Wendell Holmes said in Common Law. He says, the faith of the people animates the statutory process, judicial process, political process. Almost all scriptures, at least 5-6 scriptures. I read Janda Avesta of Parsis,
Yes.
Torah of Jews, Bible, Old Testament also, then Quran, and in Manusmriti, apart from other Smritis. They say, they all proscribe commission of suicide. Atmahatya Mahapapam. Manusmriti says that way. There are other Smritis also. Because every individual is valuable to the civilization. Therefore, section 309, right? Commission of attempt to commit suicide is offense. Macaulay, when he drafted that, he was called for a debate as to why population of India is growing like anything. If some people want to commit suicide, let them commit. This is what one of the members of the First Law Commission said. Then Macaulay said, no, all scriptures prohibit, proscribe commission of suicide.
What is the effect of repeal of section 307? No, it's not there in the statute book.
That's not it. That's true.
Yes.
No,
But
it is there now.
Attempt to suicide.
Suicide is not punishable because
please,
he is not available for punishing him.
being punished
He has escaped your punishment.
is beyond us.
Therefore, but attempt to commit suicide is an offense. That was struck down, then revived.
The 38 says, death by suicide ಅಂತ ಹೇಳ್ತಾರೆ,
Correct.
not attempt. So it's a concluded offense, death by suicide. If it is not within 1 year, if he doesn't commit suicide, the policy is valid ಅಂತ ಹೇಳಿ ಹಾಗೆ ಹೇಳ್ತಾರೆ. ನೆಗೆಟಿವ್ ಟರ್ಮ್ಸ್ ಅಲ್ಲಿ ಇದೆ. The state rule 38 framed under Article 309. It is not under the Insurance Act. It is framed under Article 309. If it is framed under Article 309, what is the effect?
It is a protection given. 14, 21, both of them will be applicable. Then the contra preferentum, which is enunciated by the bench of 5 judges, the constitution bench, is applicable. These are the small notes I have given. But second thing is, it's subject to your lordship's hearing me for, though its matter is urgent, is this matter. This honorable court remanded the matter. You have not considered the validity of Rule 38. The tribunal inquires into it and holds that it's invalid, constitutionally invalid. And the appellate, the state appellate tribunal says he has no locus standi. The petitioner has no locus standi. I think.
Administrative tribunal.
Yes. That's where your lordship could.
No, locus standi, perhaps that may not be correct.
Who
Who else can challenge that? He alone can challenge that. A person who has committed suicide, he cannot come before the court.
Yes.
We cannot resurrect him.
And that's gore, it should go back. So to hold an inquiry and find out this issue. I think limited issue. If it
Need not go back. We'll decide it here. Otherwise, no justice.
Then my participation becomes relevant.
Correct. Your participation will be highly relevant.
If my lords were to accept that this has to go back because this High Court had asked them to examine.
They have not done,
the
but
tribunal
therefore we'll examine now.
Tribunals, the fresh tribunal, new incumbent, they say, no. Adu tappagtade anta nan bhavane, judicial discipline.
Correct.
My lord would remember Shamaraju's case.
Correct.
And Supreme
When
Court.
High Court says you should do it. That's all.
Right
Unless
or
you
wrong,
get it
right or
modified.
wrong,
etc.
they have no, they can't sit in judgment. Aದಾಗ್ತದೆ. This is the two. ಯಾವ date ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ರಾ?
ತಮ್ಗೆ ಯಾವ್ದು ಬೇಕು? Since you are amicus,
No, no.
we are at your disposal. Whichever date you want.
No.
Government has taken time.
Government has taken time.
No, government.
What role have you got? Except giving trouble.
So the rule maker is a government only.
I didn't imagine this. So, we learn new things.
29th ಹಾಕೋಬೋದಾ?
4th ಹಾಕೋಣ?
Fourth
November.
ಆಯ್ತು. 4th December.
Oh, 4th December. We are already in the end of the year.
Therefore, I am requesting members of the bar to read the roses in December.
Please. The synopsis shall be submitted to the officer here.
For you, there is no restriction.
No.
Your extended arm of the
And then-
extended alter ego of court.
But the second thing is, the Honorable Supreme Court in only one decision has held the want of liability to pay the amount has to be, that burden of want of liability has to be discharged by the insurer alone. They cannot pick a sentence from what Ramakrishna has said, that ನನ್ನ ಮಗ suicide I ಮಾಡ್ಕೊಂಡಿದ್ದಾನೆ.
Of course.
That police authorities asked him to sign and he signed it. This is his expression. Being a lawyer, he has made an admission and the admission is being explained. It's capable of being explained. This is how it comes.
But from the fact that suicide is prescribed by all the
Yes.
world over, this is one part. The second part,
Law also.
Rule 38. See, in case of a contract, in respect of a private insurance company, either life insurance or any life insurance.
Not for state.
They avoid it because in the guise of the insurance, they will be put to loss. That
Please.
is, he will insure for 1 crore and then
Commit suicide.
Commit suicide.
Please, sir.
So to
I
avoid
think
that,
I am benefited by this observation.
What that
Please,
period appears to be that in 1 year, many things happen and he may change his mind. And therefore, 1 year time
Is prescribed.
is prescribed. After that, if he commits suicide, then the insurance company is liable. But within 1 month, if he plans that
And
he should
commit suicide.
commit suicide in order to benefit all his family members or come out of
My lord,
some debt
my lord's observation now is founded on the principles of law. But your lordship could also add one more thing to it. Rule 15 says the moment premium is paid, risk is assumed.
Yeah.
And risk
Subject
cannot
to
be
Rule
disowned.
28.
Risk cannot be disowned.
It has to be looked in the light of the rules. Because For
Well, yeah, please,
KGID, for KGID, there is no such
Restriction,
it's not-
stipulation.
Oh,
Rule says, but when rule says what you can say, a kind of loose framing of Rule 38.
Yes.
It is not strictly framed.
that's
It has been framed.
terminology nodi. Policies which have been in force for at least 1 year are not rendered void by the negative statement is made.
They could have said, anyway, we understand what is meant by that. We can't read a rule.
No.
It's a subordinate legislation.
Not.
Number one. We can't read the subordinate legislation like the statute of Westminster Abbey.
No, this is done under Article 309.
Correct.
It's in aid of service, beneficial rule.
Correct.
This beneficial rule cannot be given a restricted meaning. Nantra ಹೇಳ್ತೇನೆ. ಅದು I think the purposive construction, benevolent construction. I am borrowing by the expressions of your lordship in the 2-3 editions.
We have borrowed a lot from you.
I'm grateful to you.
Okay, all right. Next.
Matter pertains to transfer, my lord.
Transfer.
ಅದು
ಅದು ಎಲ್ಲಿಗೆ ಮಾಡಿದ್ರಿ ಲೇಡಿನಲ್ಲಿ ಕಳಿಸಿದ್ದು
ಅದು ನನಗೆ ಕೋಡಾಲ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಸರ್. ಕೋಡಾರಿಗೆ
ಕೋಲಾರ್ಗೆ ಕಳಿಸಾಗಿದೆಯಾ?
Signature has to happen. Secretary is not there. He's maybe by 4 o'clock it will happen.
4 o'clock today.
Yes,
We'll call this day after.
Yes.
Day
Yes.
ಮತ್ತೆ ಅವ್ರಿಗೆ ಏನ್ ಮಾಡಿರಿ?
Whatever they have sought, my lord, it is given.
ಯಾವ್ದಾರ ಅವ್ರಿಗೆ ಒಂದು ಆಪ್ಷನ್ ಕೊಡಿ.
Chikkaballapura.
ಇಲ್ಲ ಗೌರಿಬಿದನೂರಿಗೆ ಹೊಸೂರು ಅಂತಿದೆ ದಟ್ ಮೇ ಬಿ ಟ್ರೀಟ್. ಗೌರಿಬಿದನೂರು ಹೊಸೂರು ಅಂತಿದೆ.
ಹೊಸೂರ್ ಹತ್ರ.
ಹೌದು.
ಏನು ವಿಶೇಷ ಅಲ್ಲಿ ಏನಿದೆ?
ಅಲ್ಲಿ ಏನಿಲ್ಲ ಅಲ್ಲಿ ಇರೋ ಪ್ಲೇಸ್ ಒಂದೇ ವೇಕೆಂಟ್ ಇದೆ ಅದಕ್ಕೆ. ವೇಕೆಂಟ್ ಇದೆ.
ನೋಡ್ಕೊಳ್ಳಿ ಕ್ಯಾಲ್ಕುಲೇಟ್.
Yes.
You should keep employees happy.
Yes.
ಅವ್ರನ್ನ ಫೈಟಿಂಗ್ ಗೆ ಹಚ್ಚಬಾರ್ದು.
Yes.
ಅಲ್ವಾ?
Please.
They are not the slaves of East India Company. We are a welfare state. ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಅವರಿಗೆ ಕೇಳಿ ಎಲ್ಲಿ ಮಾಡ್ಬೋದು ಏನು. That's how the idea of counseling took birth. Day after tomorrow at the request of. ಕೇಳ್ಕೊಳ್ಳಿ ಅವ್ರಿಗೆ ಏನ್ ಮಾಡ್ಬೇಕು.
Yes.
Next. Mr. Rangramu. Mahale sir appear ಆಗ್ತಾರಾ? Yes sir.
It says suit for partition filed by.
Your friends can have a coffee round and come back. This will take some time perhaps.
No, it will not take much time.
Not
much time. Daughter filed a suit for partition, claiming 1/5 share. Kindly see.
ನಾಲ್ಕು ಮಕ್ಕಳು ಒಬ್ಬ ವಿಡೋನಾ? 1/5 ಶೇರ್ ಯಾಕೆ?
But ಮದರು ಇಟ್ಕೊಂಡು 1/5 ಮಾಡಿದ್ದಾರೆ. 4. And kindly see, my lord, the issues, page 51.
Okay. 51.
52, my lord, sorry.
52.
Additional, no, it's additional.
Additional issue. Issues are at 50. 50. 50.
Correct.
Alva?
51, correct.
Last 50.
4 lines. From the bottom.
51, bottom.
Whether the plaintiff proves that
he is
this
the
is the
class
class
one legal
1 legal heir of deceased Soma Shetty and jointly succeeded the suit shuttle property along with the defendants. Whether the defendants prove that the suit shuttle property is already been partitioned and the plaintiff has received more than 65,000 in lieu of her share. Whether the suit is properly valued and court fee paid is sufficient. And additional issue, whether the defendant number 3 proves that the suit is bad for non-jointer of necessary plaintiff in support of this case got examined herself as PW1 and marked so and so. Now, my lord, your lordship may kindly please to see the findings on this issues.
All negative. First is negative, second is affirmative.
Yes.
Second is whether plaintiff received 65,000 ankonda.
That, yes.
Is held to be affirmative.
No, my lord, may I straightway, my lord, take your lordships to the, they have relied on Pushpalata's case
Justice
instead of
Kumar's,
Vinit Sharma.
Justice Kumar's judgment. Pushpalata Kumar, Justice Kumar and A.N. Venugopala Sahebaru madittu.
No, my lord, subsequently the Supreme Court, that is the Pushpalata has been overruled.
In Phulvati.
In Vinit Sharma. So this is the only, my lord, ground is sufficient to set aside the matter, the judgment and send it back. My lord, finding, my lord, your lordship may kindly please to see page.
No, no, sir. If the second issue is answered in the affirmative, then Pushpalata is not available to it. The Vinit Sharma also is not available. Not available. Because already he has received it.
No, that is 65,000 rupees is received.
Adit bitre, Pushpalata, Phulvati, Vinit Sharma, 3 are have to be kept aside. That's all. That's the law. That itself clarifies that. Yeah. It went from Bombay. I forgot that.
I may be permitted to read para 16.
Yes, sir.
As far as item number 1 to 3 is concerned, plaintiffship contending that the suit schedule properties are the joint family properties and she has got the share in the said properties. The contention of the defendant that the plaintiff is born prior to 1956. This, the entire, the judgment has proceeded on this basis. Born prior to 1956 and she cannot claim share in the suit schedule properties. It is also the contention of the defendant that with respect to the item number 1 to 3 properties, they are already partitioned in the family and mutation was made in that regard. And the plaintiff is not entitled for any share in the suit schedule properties as he has already received 65,000 rupees in lieu of her share from her mother prior to filing of the suit. The receipt of the amount by the plaintiff is denied by the plaintiff. However, during cross-examination, she has stated that the amount received by her from T.S. Rajsekara and defendant number 4 are with respect to the marriage expenses.
Next paragraph, next page. Exhibit P12 and in that P12 itself, they have said 65,000 is received by installments towards my share.
Issued and defendant have given the reply to the said notice as per exhibit P12. In exhibit P12 itself,
yes,
the defendant have contended that amount of 65,000 was given to the plaintiff in installments towards her share in the suit. That is their contention.
No, that's proved also, na? Contention taken with different.
Bank passbook as per exhibit D 137 to 139, wherein the payment made to the plaintiff is reflected. When with respect to this payment, already there is a contention taken by the defendant in exhibit P12 and in the present suit, the plaintiff has not stated anything in respect of this said payment. But during the cross-examination.
He was already employed. He was a lecturer.
Yes, yes. And No, that's the only point, whether that, my lord, the 65,000 rupees is in lieu of her share or not is the question. Now, my lord, the court has proceeded on the basis that it is 65,000 is paid to her in a partition.
No, she admitted. She admitted 65,000.
65,000.
He says it was towards marriage.
Marriage expense.
Whose marriage? Rajshekar's marriage.
Rajshekar's marriage.
He was already a lecturer.
My lord. No, there is.
Nita Sharma, para 135. Say.
No, yes.
Entries have been effected and it has been acted upon. They are living separate. If there is conclusive evidence in respect of that separation.
That's on fact, my lord. No, I wanted.
Assuming that nothing has happened. What about your admission?
No, I admitted that I have received 65.
But you
know, it is
was
for the marriage
of Rajshekar.
My lord, she was running the shop. My lord, which shop?
Under section 58, sir, you know how we need not say that at all. Anyway, there is an admission. Admission, though, is not a conclusive proof. You could have explained. You said it was for the marriage of Rajshekar.
That's all.
That you should have, by that time, Rajshekar was earning huge money as lecturer.
No, my lord, see, 65,000 rupees, he may be earning money, but my lord, she was running the Kirana shop. And my lord, for marriage purpose, she must have given some material. And the 65,000 must have been given to her.
You did not utter one word in your plaint. You should have said, I had received 65,000 rupees. It was for the marriage.
No, in the plaint.
An honest gentlewoman. You should, daughter of the family. It's not outside. The fighting is not against some XYZ. It is within the family, partition. You should have said, yes, I have received this one. That you should have pleaded that.
Pleading is not there, my lord, because in the pleading, my lord, because he has sought for a partition, the question of pleading, my lord, will not arise. I need not say that I have received 65,000 rupees.
You should say.
That is, my lord, he has taken in the written statement that I have paid 65,000.
Correct. You should have disclosed them because you admitted in the cross-examination.
There in the notice which you had received.
Exhibit P12.
P12.
It was there.
Reply notice.
His reply,
He replied,
specifically he said,
Yeah.
yes, we have given 65,000 to her. You should have taken up that. You went to court only after receiving the notice, not before.
Not
And-
towards the share.
Not towards the share and thing.
Next.
So I'm in a bad ground.
That is the reason you have been engaged actually. So that you will do some magic and yes.
Obliged.
Okay. Yes, next one.
According for the respondent number 1 to 5 in this case, my lord. True. 20.
No updation. Hmm.
27, my lord. 27.
27. You know, time ತೊಗೊಂಡಂಗೆ ಕೇಳು. ಆರಾಮಿರ್ಲಿಲ್ಲ ಅವರಿಗೆ.
Last time, last sheet has put in condition. Next date, entry ಅದು delay ಆಯ್ತು, delay condonation ಆಯ್ತು. LR's application allow ಆಯ್ತು. I have no objection. Subject to the condition that they should argue on the next date of hearing. Last time date not on. Date may be fixed.
ಯಾವ ಡೇಟ್? ಬೈನ್
Court of memo move ಮಾಡಿದ್ದೆ.
3rd week of January.
Short date may be given. It is a PTCL land.
2013 ನಡೆಸಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು PTCL land. Agreement ಮೇಲೆ ಅವರು ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಹಾಕೊಂಡಿದ್ರು. ಅದ್ರ ಮೇಲೆ 7 to 11 ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಆಯ್ತು. They are second more than 10 to 15 adjournment. Before
ಹುಷಾರಿಲ್ಲ ಅಂತ ಕೊಟ್ವಿ.
ಅದಕ್ಕೆ next week ಅಲ್ಲಿ ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್.
ಬರ್ದಾಗಿದ್ದೇನು? ಬರ್ದಾಗಿದೆ. ರಿಟರ್ನ್ ಆಲ್ರೆಡಿ. Yes.
I may be permitted to move the memo.
ಮೆಮೊ ಬರಲ್ಲ ಅದಕ್ಕೆ.
Memo move ಮಾಡಿ
ನೆಕ್ಸ್ಟ್.
Appearing with the respondent number 1 to 5 in this case, my lord.
Correct. Third week of January 25 to enable counsel for the appellant to come and argue. Next.
My lord, serial 29.
29.
Appearing for the appellant, my lords. My lords, the matter may be kindly passed over, my lords. Senior is arguing a matter in Dharwad court, my lords.
Third week. Yes. Third week.
Obliged.
And for the third respondent.
Yes, Raghavendra.
Respondent 2, my lord, appearing.
Second respond. Ready.
Pass over, kindly pass over.
Pass over.
See, case of my lord, absorption of a person from Health and Family Welfare Department to my lord, dental my lord, institute my lord, framed by the government, my lord. No, my lord, they have.
My lord ಅಲ್ಲೊಂದು ನಿಲ್ಸಿ ಸ್ವಲ್ಪ ಸೆಂಟೆನ್ಸ್ ಮಾಡಿ. ಬರೀ my lord ಅಷ್ಟೇ ಕೇಳ್ತದೆ ನಮ್ಗೆ
Sentence, my lord. The third respondent entered into services, my lord, in the Health and Family Welfare Department on 4/2/2005.
4/2/2005.
5. Lord, I have taken my lord, the file of.
ಕೂತ್ಕೊಳ್ಳಮ್ಮ. ಪೇಪರ್ಸ್ ಓದ್ಕೊಳ್ಳಿ. ಅವ್ರು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಟೈಮ್ ಕೊಡಲ್ಲ, ಪಾಸ್ ಅವರು ಕೊಡಲ್ಲ. ಇದಾಗ್ತದೆ.
Writ appeal number 644 of 2023 I have taken for my lord. In this my lord, 4/2/2005, the third 4/2/2005.
1 second. Writ appeal 644. 23.
4/2/2005 my lord.
ಏನದು?
That is the deputation appointment, my lord, of the third respondent in the Health and Family Welfare Department.
4/2/2005 is date of appointment of third
respondent.
Or 3 appointed as?
Appointed as my lord, the
Dental health officer.
dental health officer, my lord.
Dental health officer.
On 26/9/2005.
1 second. In health department.
Please. Of Government of Karnataka. On 26/9/2005. My lord, she was sent on deputation to.
Deputation to?
Government Dental College.
Government Dental College ಇದ್ರೆ ಡೆಪ್ಯುಟೇಷನ್ ಆಗತ್ತಾ?
Then clearly, my lord, it was a government dental college. When she was sent on deputation, my lord, in the year 2006, it became an institute, my lord.
ಏನು? ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಅಂದ್ರೆ ಏನರ್ಥ?
That is a certain, it became an my lord, autonomous institution on 16/11/2006 as Government Dental College and Research Institute.
On
16/11/2006, my lord.
16/11/2006.
6, my lord. Then, my lord,
it became autonomous body.
Autonomous body. She was continued on deputation, my lord.
R3 continued.
Continued on deputation. Then, my lord, walk-in interview was, my lord, called for to fill up the post of lecturers, my lord, in the department, institute on 19/7/2007. 19/11/2007, my lord.
Walk-in interview.
Walk-in interview, my lord, 2 professors, 11 assistant professors, 9 lecturers, my lord.
ಇವಳು ಯಾರ್ದು?
initial, my lord, assistant professor. My lord,
Interview for-
applicant, my lord, appellant, my lord, as well as, my lord, third respondent, my lord, participated in the selection.
Appellant and third
Third
respondent.
respondent, both were, my lord, participated.
Appellant or petitioner?
Appellant, my lord, it is a writ appeal, my lord.
Okay. Appellant and R3.
My lord,
Participation.
I was appointed on 19/5/2008.
You were selected and appointed.
Selected and appointed. She was not selected.
ಅದೇನು ಸೂಟಬಿಲಿಟಿ ಇವನ್ನೆಲ್ಲ
ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ, ಸೆಲೆಕ್ಷನ್ ಆಗಿದೆ. Then, my lord,
ಅಪಾಯಿಂಟೆಡ್ ಆನ್
19/5/2008, my lord.
ಓಕೆ.
My lord, and 1/8/2008, third respondent exercised the, my lord, option for absorption.
ಯಾವತ್ತು?
1/8/2008, my lord.
ಅವತ್ತು ಅಬ್ಸಾರ್ಬ್ ಆದ್ರ?
ಅಲ್ಲ, she was observed on 24/5/2010, my lord. 24/5/2010.
24/5/2010. Okay.
My lord, it was on request. It was not in public interest, my lord. No, my lord, question is, my lord,
Seniority issue.
seniority is to be seen, my lord, between the third respondent and appellant. My lord, identical matter in one more writ petition was also applied. It was also clubbed. Where
ಇದು ರೇಣುಕಾ ಪ್ರಸಾದ್ ಇದ್ದಂಗಿದೆ.
Renuka Prasad case ಇದೆ. My contention is, my lord, the learned single judge, my lord, given the seniority to the third respondent on the ground that she had qualification at the time of absorption, at the time of deputation. Only on that ground, my lord, between me and third respondent,
Placed above.
placed the, directed to be placed the above. Insofar as Anup and, my lord, the another candidate Kalavati is concerned, my lord, seniority is from the date of absorption. In the same matter, a different, my lord, judgment is given, my lord, by the learned single judge. Your lordship may come to, my lord, judgment pass.
Same judge.
Same connected matter, all clubbed together, my lord. So many matters were clubbed together, heard by the single judge, my lord.
1 second.
Your lordship may come to, my lord. I'm sorry. I'm sorry.
Dr. Renuka Prasad says where a deputationist holding equivalent post is absorbed in public interest, the previous service needs to be reckoned. Alva.
May I submit one point, my lord? One point, my lord. My learned friend left out one point, my lord. My lord, my services were observed in public interest by another corrigendum issued, my lord, on 27/4/2011.
24/5/2010.
My lord, my absorption was 27/7/2010. Subsequently, a corrigendum was issued to that stating that my absorption is in public interest on 27/4/2011.
How that corrigendum comes into existence except to favor your candidate?
That was
whether it was in public interest or not should have been uttered.
Yes,
as on the date the order for absorption was made.
yes, my lord.
How
What
it came
happened
to
here
be?
was, my lord, what happened was the second respondent had repeatedly made a request for absorption of our services since, my lord, they were facing difficulty in getting recognition from the commission, the authorities, my lord, regarding the government dental college recognition, my lord. Therefore, my lord, it was repeatedly requested.
One sentence ಹೇಳಿದ್ಮೇಲೆ ಸ್ವಲ್ಪ ಪಾಸ್ ಅಂಡ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ಬೇಕು. ನಾವು
I'm sorry.
ಅಸೆಸ್ ಮಾಡ್ಬೇಕು. ನೀವೇನ್ ಹೇಳ್ತಾ ಇದೀರಿ ಅನ್ಕೊಂಡು ನೀವು anxiety ಹೇಳ್ಬಿಟ್ರೆ ನಾವು ಅಸೆಸ್ ಮಾಡೋದು ಹೆಂಗ ಅದ್ರ ಮೆರಿಟ್ ಅನ್ನ?
Yes, my lord.
Osho used to say pause is an integral part of speech. ಅದನ್ನ ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ನಾವು.
I'm sorry.
ಕೊಡಿ ನಿಮ್ ಪೇಪರ್ಸ್ ಕೊಡಿ.
644 your lordship may take.
ಅವರ ಅಬ್ಸಾರ್ಪ್ಷನ್ ರಿಕ್ವೆಸ್ಟ್ ಅಲ್ಲಿ ತೋರಿಸಿ.
My lord, I
ನಾವ್ ಹೇಳಿ ತೋರಿಸಿ ಆಮೇಲೆ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
ಆಯ್ತು.
8 ದಿವಸ ಆಗ್ತದೆ ನಿಮ್ಮ ಮಾತು ಕೂತ್ಕೊಂಡ್ರೆ ನಾವು ಏನಿರ್ತದೆ ಇಂಥ ಮ್ಯಾಟ್ರಸ್ ನಲ್ಲಿ ಎಲ್ಲಿದೆ ಅದು ಅಬ್ಸಾರ್ಪ್ಷನ್ ರಿಕ್ವೆಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ. ದಟ್ ಇಸ್ ದಿ ಲಾ ಅಷ್ಟೇ. ಅಲ್ಲ ಇದನ್ನ ಕೊಡಿ ರೇಣುಕಾ ಪ್ರಸಾದ್ ಕೊಡಿ. ಐ ಆಲ್ಸೋ
ರೇಣುಕಾ ಪ್ರಸಾದ್ ಕೊಡಿ.
ಐ ಅಪಿಯರ್ಡ್ ಇನ್ ರೇಣುಕಾ ಪ್ರಸಾದ್ perhaps.
ಹೌದು.
M.R. Achar was arguing that matter.
ಇಲ್ಲಿದೆ ನೋಡು.
It went in appeal. What happened in appeal?
It is confirmed.
Confirmed.
Page number 173, my lordship.
Huh?
Single bench is referred the apex court judge.
Apex court ಯಾವ judgment?
The Dakshayani versus State of Karnataka.
Whether Dakshayani is considered in this matter?
Please, ma'am.
ಅದಲ್ಲ.
ಇಲ್ಲಿದೆ ಅದು.
Dakshayani is of which year?
That is 24, 2018.
24, 2018.
ಇಲ್ಲಿದೆ ನೋಡಿದೆಯಲ್ಲ ನೀನು.
In 102, impugned Adam.
ಇಲ್ಲ 353 ಅಲ್ಲ ಹೇಮ ಮೈತಿಲಿ.
So relevant factor was the same employer. So after it became autonomous body, it ceases to be same employer. ಅಂತ ನಿಮ್ contention.
Please, kindly, my lord, here, my lord.
Two 270. The government, both departments, suppose under the government, ಇನ್ನೊಂದು ಕಡೆ ಕಳಿಸ್ತೇವೆ. ಗವರ್ಮೆಂಟ್ ಆರ್ಗನೈಸೇಷನ್
353 ಅಲ್ಲ
ಅಲ್ಲಿ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಅಂದ್ರೆ ಸೊಸೈಟಿ ಆಯ್ತು ಅನ್ನೋದು.
ರಿಜಿಸ್ಟರ್ಡ್ ಸೊಸೈಟಿ.
Society, it became society.
Please. Yes. 353 is the, my lord, option exercised by the third respondent. Lordship asked that question, my lord. 353.
ಅಲ್ಲ option there. Courts have differentiated option being exercised and request being made. Option comes from the side of employer. Request comes from the side of employee. Option ಇದ್ದಾಕ್ಷಣ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ ಅಂತಲ್ಲ, ಬಟ್ ರಿಕ್ವೆಸ್ಟ್ ಇದ್ದಾಗ ಅಮೌಂಟ್ ಆಫ್ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಇಸ್ ಡಿಮಿನಿಶ್ಡ್. ಇಟ್ ಈಸ್ ಇನ್ ಹರ್ ಈಸ್ ಇಂಟ್ರೆಸ್ಟ್. ದಟ್ಸ್ ಹೌ ದಿ ಲಾ ಈಸ್.
Here is a case, my lord. It is not, my lord, absorption to a same cadre pay scale to another, my lord, same pay scale. Here, my lord, she was working in the dental health officer, which is a lower cadre, sent on deputation to higher cadre as a, my lord, lecturer. My lord,
trying what salary? Lecturer salary.
Lecturer salary higher. Dental council salary ಬರುತ್ತೆ. ಅವಾಗ ಏನಾಗುತ್ತೆ?
ನಿಮಿಷ ಎಷ್ಟು ಅವಸರ. Communicate, you have to take this along. You mean to say the post which she held in the parent department was lower compared to the post to which she has been deputed to the institute?
ಹೌದು.
Yes, sir. That is on the basis of pay scale.
Pay scale.
But Supreme Court says in E.P. Royappa, That pay scale is not the decisive factor to decide equivalence of the posts. Alliro nature of job, illiro nature of job.
Different, totally different.
Alleno.
She is the dental health officer, my lord, in the clinical side. Here my lord, she is the my lord, like work as a lecturer with my lord attached to the hospital. My lord, single judges, my lord.
Deputation ಅವಳೇ ಕೇಳ್ಕೊಂಡು ಬಂದಿದ್ದೋ ಅಥವಾ ನೀವೇ ಕಳಿಸಿದ್ದು ಗೌರ್ಮೆಂಟೇ ಕಳಿಸಿದ್ದೋ?
ಅವರೇ ಕೇಳ್ಕೊಂಡ್ ಬಂದಿರೋದು.
ಎಲ್ಲಿದೆ?
3 ರಿಟ್ ಅಪೀಲ್ ಆಗಿದೆ, ನನಗೆ ಪೇಜಸ್ ಇದು ಆಗ್ತಾ ಇಲ್ಲ.
ವಿಜಯ್ ಕುಮಾರ್.
Yes.
ಅದು ನಿಮ್ ಕ್ಲೈಂಟ್ ಕೇಳ್ಕೊಂಡು ಡೆಪ್ಯುಟೇಷನ್ ಹೋದ್ರ?
No, my lord, it was
go on deputation ಅಂತ ಆರ್ಡರ್ ಇತ್ತು.
But it was the government which has passed the order, my lord. She had never requested for deputation.
ಎಲ್ಲಿದೆ?
But that is at order dated, the deputation order is at 21/9/2005, my lord.
But in one matter which you have argued, we say deputation is a tripartite arrangement, which includes the lending department, borrowing department, and the deputationist. You have argued that matter, na, before us. We accepted your contention.
Order doesn't say either it is on her request or in public interest. I read the deputation order, my lord.
When institute was managed by the state, it was treated as department of the government. Institute was not a society as it. It was part of the government.
Petition was made, it was not a society.
It was a government department, but different department. Health and Family Welfare Department and Medical Education Department.
So employer was same. Employer was same. Now, it became autonomous institute, and she continued. Alva.
But she was not selected in the direct recruitment, which I also participated. My lord, regular cadre via interview, I my lord selected and my lord working in the institute. Then she, my lord, a proposal is mailed, my lord, for absorption, where she exercised, and subsequently she was absorbed. My right, my lord, of seniority and benefits, my lord, it will be curtailed because of a subsequent absorption of her. And single judge, my lord, gives benefit to one Anu, who is similarly selected along with me.
On a contra proposition.
Contra proposition, because where their Kalavati doesn't have the qualification. Here, my lord, Kalavati also came, my lord, on deputation.
But the point is not that she lacked the qualification. But this lady na or gent?
Lady.
Lady.
Both are ladies.
Well, absorptions, my lord, is not permissible under the bylaws.
Okay.
Because, my lord, option has to be exercised, my lord, persons who are within the dental college. Elsewhere dental college, my lord, option required to be, my lord, exercised. My lord, she was, therefore, my lord, while initial absorption of the, my lord, the employees of the dental college, this respondent 3 was excluded. Thereafter, my lord, they requested, my lord, their file was moved. Then, my lord, option called for. Then she, my lord, observed in the year 2010, 2009. My lord, employees of the dental college were observed. And my lord, Health and Family Welfare Department, my lord, sent a letter to the Medical Education Department stating that they required their services in their department. Those all, my lord, files were, my lord, moved in the department. In spite of that, my lord, subsequently they were observed. My contention is, my lord, under the bylaws, there was no such provision.
When absorbed.
Please, my lord.
Can absorption happen without bylaws? What's the law on the point?
the
Absorption. For valid
The
absorption.
absorption method without having the bylaws, it is illegal absorption. Therefore,
It is your contention. Where is the law? Legal literature, supportive.
My lord, page 158, my lord, there was absorption provision under the bylaws. Page 158, my lord, the single judge has culled out the provision.
158, huh?
Yes, ma'am.
87 in impugned order.
Of the impugned order.
Please.
Yes, ma'am.
Academic staff means members of the staff who are wholly engaged in teaching. Employee means person in the employment of the institute. Bylaws means so and so. The institute shall obtain option from the existing staff when they are willing to be absorbed in the institution or not. So there was a rule for absorption.
absorption, rule 14, my lord, the institute shall obtain option from the existing staff when they are willing to be absorbed in the institute or not.
Existing staff ಅಂದ್ರೆ
Existing staff,
ಅಂದ್ರೆ ಯಾರು ಹೊರಗಿನಿಂದ ಬಂದವರೇ
ಅಲ್ಲ,
ಅಲ್ಲೇ ಇರೋರ್ನ ಅಬ್ಸಾರ್ವ್ ಮಾಡೋ ಪ್ರಶ್ನೆ
ಅಲ್ಲ, 2G ದಲ್ಲಿ employee means a persons in the employment of the institute.
ಕರೆಕ್ಟ್. ಅವನು ಎಂಪ್ಲಾಯಿ ಅಲ್ಲಿಲ್ಲ, ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಸ್ಟಾಫ್ ಇಲ್ಲಿ ಉಪಯೋಗ.
Existing staff, she was not an existing staff, she was on deputation.
Otherwise, where is the question of absorption? Absorption has to be of the deputationist. If she is the employee of the institute, where is the question, idea of deputation? The absorption. The idea of absorption envisages that she is not having lien to the post which she is holding because she is on deputation to this organization.
She is, my lord, having lien in the, my lord, health and family welfare department.
Therefore absorption.
The absorption, my lord, I have no grievance regarding her absorption. My lord, while giving the absorption, my lord, they can't take away. I'm sorry.
ಸ್ವಲ್ಪ ನಿಮ್ಮ ಮಾತಿನಲ್ಲಿ ತುಂಬಾ ಲಾರ್ಡ್ ಬರ್ತಾ ಇದೆ. ಅವಾಗ ಮಾತಿನ ತೂಕ ಕಡಿಮೆ ಆಗ್ತದೆ. ಯಾಕಂದ್ರೆ ಲಾರ್ಡ್ ಕಡೆ ಹೋಗ್ತದೆ ಹೆಚ್ಚು.
ಅಲ್ಲ, ಅದು ಯಾಕೆ ಆಗ್ತಾ ಇದೆ ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ. ಐಮ್ ಸಾರಿ ಮಲಾಡ್, ನಾನು ಯಾಕೆ ಹಂಗೆ ಆಗ್ತಾ ಇದೆ ಹೇಳ್ತಾ ಇದ್ದೆ ಮಲಾಡ್. ಐ ಹ್ಯಾವ್ ಎಂಗೇಜ್ ದಿ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಮಲಾಡ್, ಅದು ಬಂದಿಲ್ಲ, ಅದಕ್ಕೆ ನನಗೆ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ. I engage the senior counsel in this matter, but I don't want to take time in this case because I moved the matter.
ಆಯ್ತು, ಇನ್ನೊಂದು ದಿವಸ ಇಟ್ಕೊಂಡು ಅದಕ್ಕೆ ಯಾಕಷ್ಟು ಯಾವಾಗೂ ಅಷ್ಟು ಸಾರಿ ನೀವು ಲಾರ್ಡ್ ಎಲ್ಲ ಅನ್ಬಾರ್ದು ಜಡ್ಜಸ್ಸಿಗೆ. ಮೊದಲೇ ಮೇಲೆ ಎದ್ದು ಕೂತ್ಕೊಂಡಿರ್ತೀವಿ ನಾವು, ಮತ್ತೆ ಮೇಲೆ ಸರಿ ಸಫಿಶಿಯಂಟ್. ಅಷ್ಟೊಂದು ಸಾರಿ ಅನ್ಬಾರ್ದು. ಏನಾಗ್ತದೆ, ಅದು ಒಂದು ಕಂಟೆಂಟ್ ಆಫ್ ದ ಸ್ಪೀಚ್ ಅನ್ನು ರಾಬ್ ಮಾಡಿಬಿಡ್ತದೆ. ಈಗ ಉತ್ಕೃಷ್ಟವಾಗಿರುವಂತ ಮೈಸೂರು ಪಾಕ ಅಥವಾ ಏನೋ ಇರ್ತದೆ, ಅದ್ರ ಜೊತೆ ನೀವೇನೋ ಒಂದು ಮಿಕ್ಸ್ ಮಾಡಿ ಕೊಟ್ಬಿಟ್ರಿ ಅಂದ್ರೆ ಅಲ್ಲಿ ಹೋಗ್ಬಿಡ್ತದೆ ಅರ್ಧ ಎಲ್ಲ. ಅದ್ರದ್ದು ಸತ್ವ ಇರ್ತದಲ್ಲ. ನಮ್ ಕನ್ನಡ ಅಷ್ಟು ಚೆನ್ನಾಗಿಲ್ಲ, ಅಲ್ಲಿ ಹಿಂದ್ ಕೂತಾರ ನೋಡ್ರಿ ನಿತಿನ್. ಅಲ್ಲಿ ಎಲ್ಲೇ ಒಂದ್ ಕಡೆ ಸರಿ ಇದೆ ಅನಿಸ್ತದ ಆರ್ಡರ್. ಯಾಕೆಂದ್ರೆ ವಿಲ್ ನಾಟ್ ಡಿಸೈಡ್ ಇಟ್, ಜಸ್ಟ್ ವಿ ಆರ್ ಥಿಂಕಿಂಗ್ ಅಲೌಡ್. Always the other side argument is also possible. The deputation, as we understand in service jurisprudence, two departments of the same government, from one department to another department, ordinarily, that's how we understand. Their rules provide for deputation, therefore consent of the employee is not necessary. Okay, but if the employee dissents, what would happen is not yet decided. Anyway, please, we are not concerned with that. When she went on deputation, it was part of the government. The college was part of the government. Subsequently, it became autonomous body. This is what you are saying. It is formed as a society. It is the government which forms it as a society. Okay, please, your bylaws, perhaps the bylaws are promulgated after it became institute, or before that it.
ಇಲ್ಲ, ಆಮೇಲೆ ಆಗಿದೆ.
Obviously. It provides for absorption. ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಸ್ಟಾಫ್ ಅಂದ್ರೆ ನೀವ್ ಹೇಳೋದು ಅಲ್ಲೇ ಇರುವಂತ ಎಂಪ್ಲಾಯೀಸ್ ಅಂತ. ಅವಾಗ ಯಾಕೆ ಅಬ್ಸಾರ್ಪ್ಷನ್ ಮಾಡ್ಕೋಬೇಕು? ಅಬ್ಸಾರ್ಪ್ಷನ್ in our service jurisprudence is treated as one of the modes of appointment. But once appointed, question is not the appointment. Once absorption takes place, does it wipe out pre-absorption service or not is the question.
ಅದಕ್ಕೆಲ್ಲ ಸೈಟೇಷನ್ ತಂದಿದ್ದೀನಿ.
ಅದೇ
ಅದಕ್ಕೆಲ್ಲ ತಂದಿದ್ದೇನೆ.
ಆಯ್ತು, ನಾನು ಡೇಟಿಂಗ್ ಮಾಡಿ
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಗೊತ್ತಿಲ್ಲ ನಮಗೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ
ನಾನೇ ಮಾಡ್ತೀನಿ ಸರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಾನೇ.
No problem, no problem. Even otherwise we would have granted you time. Why you are all under impression that this bench does not give time? We give time on the ground ಅಷ್ಟೇ.
ಹೌದು.
ಹಾಗೆ ನಾವೇನೋ ಒಂದು ಬೇಕು ಅಂದ್ರೆ ಕೊಡಲ್ಲ ನಾವು. ಯಾಕಂದ್ರೆ ನಾವು ಓದ್ಕೊಂಡ್ ಬಂದಿರ್ತೀವಿ.
ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ನಾವು ಈ ಪೇಜ್ ಕೇಳಕ್ ತಕ್ಕಂತ ಹೇಳ್ಬೇಕು. ನಾವ್ ಹೇಳಲಿಲ್ಲ ನನ್ನ ತಪ್ಪಾಗ್ತದೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ, ನಾನು ಮುಗಿಸ್ತೇನೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬನ್ನಿ. ಪೋಸ್ಟ್ ನೆಕ್ಸ್ಟ್
ಮತ್ತೊಬ್ಬ
ಪ್ರೀ ಅಬ್ಸಾರ್ಪ್ಷನ್ ಸರ್ವಿಸ್ ಪೂರ ತೆಗೆದುಬಿಟ್ರೆ ಅವ್ರ ಗತಿ ಏನು? ಒಂದು ಫೈನಲ್ ಆಸ್ಪೆಕ್ಟ್ ಅಂದ್ರೆ ವಾಕ್-ಇನ್ ಇಂಟರ್ವ್ಯೂದಲ್ಲಿ ಇಬ್ರು ಅಪಿಯರ್ ಆದ್ರು. He came to be selected, she was not. Subsequently, she has been absent. ಹಾಗಾಗಿ ವಾಕ್-ಇನ್ ಇಂಟರ್ವ್ಯೂ ಇಂಪ್ಯಾಕ್ಟ್ ಏನಾಗ್ತದೆ ನೋಡ್ಕೋಬೇಕು.
In this case, Learner Council, Shivram 6 pass or not? Yes, in the
ಯಾವ್ದ್ರಲ್ಲಿ?
Shivram
ಪಾಸು ಯಾವ ಮ್ಯಾಟ್ರ್?
31.
31
Connected matters.
ಇಲ್ಲೇ ಇದ್ರು ಅವರು.
ಇಲ್ಲೇ ಇದ್ರು. ನಿಮಿಷ ಅಲ್ಲಿ ಹೋಗಿ ಬರ್ತೀನಿ.
ಅಲ್ಲ ಪಾಸ್ವರ್ಡ್. ಹಾ ಯಾಕೆ?
Previous matter,
Ha.
29, moved it. It's a 2017 matter. The other side is not appearing at all. I had sought a pass over, your lordship has given a long day. Only one point, my lords, there is no elaborate hearing on merits. Why it has to be remanded back to the trial court? 29. Partition suit ಅಲ್ಲಿ. Why it has to be remanded is only the point.
ಬರ್ದಾಗಿದೆ ಏನದು? ಬರ್ದಿಲ್ಲ.
29. It is the sisters who have filed against the brothers.
Yes.
Partition is supposedly an oral partition. Only on one point I'll argue, my lords, beyond that I will not.
Unrepresented.
They have been unrepresented in the trial court also.
Then what is the point?
The point is only this. Kindly see, my lords, the trial court in the appeal memo, page 19, my lords, is the 18, ink page 18 and 19.
ಪೇಪರ್ ಬುಕ್ ಇಲ್ಲ ಇದರಲ್ಲಿ?
Paper book ಇದೆ ಸ್ವಾಮಿ, we have filed it, but I will, the reason why I plead for a remand is the manner in which the judgment has been written.
Page 19,
Page 18, 19. Kindly see how the issues are framed. This is a suit in which oral evidence is.
ಪೇಪರ್ ಬುಕ್ ಇಟ್ಕೊಂಡ್ರೆ ನಿಮ್ ಕೈಲಿ?
I don't have the paper book.
Okay,
It's
it's
a referred matter. I just.
ಏನು ನೀವು ರೆಫರ್ ಮಾಡ್ತಾ ಇರೋದು ಜಜ್ಮೆಂಟಾ?
Judgment ಮಾತ್ರ.
ಇಂಟರ್ನಲ್ ಪೇಜ್?
Internal page 18. 18
ಪೇಜ್ 15 ಇರೋದೇ 10. ಇಂಟರ್ನಲ್ ಪೇಜ್, ರನ್ನಿಂಗ್ ಪೇಜ್ ಅಲ್ಲ.
Sorry, internal page. Has been masked, my lords, 1, 2, 4, fourth page. Fourth page, para 4, 4, 5 and 6.
Paragraph 4, 5, 6.
4, 5,
When the
6.
case was put to plaintiff herself exam PW1 and got documents P1, P9.
I've heard arguments. Kindly see the issues in a suit for partition. Whether they prove that this is a joint family property, nothing mentioned. Just whether entitled for relief sought for.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಅದ್ರ ಮೇಲ್ಗಡೆ issues ಇಲ್ಲ.
Issues ಇಲ್ಲ.
ಅದೇ that's it.
Issues, WS ಹಾಕಿದ್ರೆ issues.
ಅಲ್ಲ, the question is whether he, but on the ground of merit, saying that we have done a collusive suit. It has been decided. Kindly come to page 21, which is page 5, 6, 7, my lords, para 10. Para 10. ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ಆಗುತ್ತೆ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಕೊಲ್ಯೂಸಿವ್ ಅಂತ ಹೇಳ್ತಾರೆ. ವೈ ವುಡ್ ಐ ಕೊಲ್ಯೂಟ್ ವಿತ್ ಮೈ ಬ್ರದರ್ ಮೈ ಲಾರ್ಡ್ಸ್? ಇಟ್ಸ್ ಕಂಪ್ಲೀಟ್ಲಿ ಅಗೇನ್ಸ್ಟ್ ಇಂಟ್ಯೂಷನ್.
ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ.
ಕೊಲ್ಯೂಷನ್ ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೇ ಫ್ರಾಡ್ ಕೊಲ್ಯೂಷನ್ unless the issues are framed and particular pleadings ಬೇಕು.
Please.
ಅದಕ್ಕೆ
ಅಲ್ಲ, kindly see only one submission on it. It is completely counterintuitive is my submission. If I have filed a suit, partition suit against my brothers who have shared the entire my father's property amongst themselves, the issue is why will I collude with my own brother against whom I am claiming the remedy?
Illogical.
ಅದಕ್ಕೆ counterintuitive ಅಂದಿದ್ದು. It just doesn't sit with logic. If I am doing it with some third party, you can. And even on the question of fraud, there has to be an issue.
ಒಂದು ಅದರ್ ಸೈಡ್ ಅಪಿಯರ್ ಆಗಿ ಪ್ಲೀಡಿಂಗ್ಸ್ ತಗೋಬೇಕಿತ್ತು.
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಈಗ ಅವಕಾಶ ಕೊಡ್ಬೋದು ಸ್ವಾಮಿ. ವಿದಿನ್ ಎ ಟೈಮ್ ಫ್ರೇಮ್. ಇಟ್ಸ್ 2016 ಮ್ಯಾಟರ್, 17 appeal. If they can be given a choice, but this judgment cannot sustain as it stands. Freshly application of mind ಆಗಬೇಕು.
In the absence of pleadings. Pleadings ಇದ್ದು ಮಾತ್ರ ಬರ್ತದೆ. Because I think it was in P. Changalavarayan Naidu versus Seshadri, something like that.
Even recently, my lords, Justice Narasimha's judgment, my lords, his lordship, Justice Narasimha's judgment, my lords, I can't recollect the name, but the same issue has been said, my lords. Because fraud and coercion deflates everything. It completely renders it nugatory even if other evidence are laid. Now, if they are saying that I have colluded, I should be given an opportunity to prove that I have not colluded. It is only in the time of judgment without framing any issue.
Without any pleadings at the other side also. Are you unrepresented?
Unrepresented, served unrepresented. And that is used as a suspicion against me. Nano ಅವ್ರದ್ದು ex parte place ಆಯ್ತು. ಆಯ್ತು. Please.
The plaintiff produced RTC extract of server number 33 standing Narayana.
ಹೌದು. Please.
RTC extract so and so.
Please.
May consider view the PW1 contents of the above same documents are not helpful to the case of the governments in the plaintiff and plaintiff has described the suit properties like so and so so and so.
Please.
ಆಮೇಲೆ ಅದನ್ನು ಕೊಲ್ಲಿದ್ದು ಅನ್ನೋದನ್ನು ಬಿಡಿ.
Please.
To the next point.
Please.
Next page.
Paragraph notes. They have not come with clean hands. Anta there's please.
It is also pertinent to note here that the plaintiffs have not produced any piece of document to show that the scheduled sites are standing in their respective names.
Illa, we don't. Our case is not that any sites are forming in my name. My case is originally the property belonged to one Ashwath Narayana. The propositus is Ranga Hanumaya, I think. Not from him. It has come to Ashwath Narayana. Ashwath Narayana ಅವ್ರದ್ದು exhibit P2 ಅಲ್ಲಿ ಅದು ವಿಭಾಗ ಆಗಿದೆ ಅಂತ ಓರಲ್ ವಿಭಾಗದ ಒಂದು ರೆಫರೆನ್ಸ್ ಇದೆ. ಸೊ ಇವಾಗ ಅನ್ಲೆಸ್ ಇಟ್ ಈಸ್ ಅಟ್ ಲೀಸ್ಟ್ ಇಶ್ಯೂ ಇಸ್ ಫ್ರೇಮ್ಡ್ ಟು ಆಸ್ಕ್ ವೆದರ್ ದಿಸ್ ವಾಸ್ ಪಾರ್ಟ್ ಆಫ್ ಅ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಆರ್ ನಾಟ್. ಮೈ ಕೇಸ್ ಇಸ್ ನಾಟ್ ಆ ಸೈಟ್. ಇವ್ರು ಏನಾಗಿದೆ, ನಮ್ಮ ಅಣ್ಣಂದಿರು ಆ ಪ್ರಾಪರ್ಟಿನ ತಗೊಂಡು ಸೈಟ್ಗಳನ್ನ ಮಾಡಿ ಮಾರಾಟ ಮಾಡಿ ಅವರು ಅದನ್ನ ಬೆನಿಫಿಟ್ ಪಡ್ಕೊಂಡಿದ್ದಾರೆ. ಐ ಕಮ್ ಟು ನೋ ದಟ್ ಐ ಆಮ್ ಆಲ್ಸೋ ಎಂಟೈಟಲ್ಡ್ ಟು ದಿಸ್ ಶೇರ್ ಬಿಕಾಸ್ ಇಟ್ ಬಿಲಾಂಗ್ ಟು ಮೈ ಫಾದರ್. ಸೊ ದ ಫ್ಯಾಕ್ಟ್ ವೆದರ್ this particular property, scheduled property 10 items ಏನಿದೆ ಇದರಲ್ಲಿ ಯಾವುದು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ, ಇಟ್ ಕುಡ್ ಬಿ, ಮೈ ಲಾರ್ಡ್ಸ್, ದಟ್ ಸಮ್ ಆಫ್ ದೆಮ್ ಮೇ ನಾಟ್ ಬಿ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ, ಸಮ್ ಕುಡ್ ಬಿ. ಆ 10 ಐಟಮ್ ಅಲ್ಲಿ ಐಡೆಂಟಿಫೈ ಮಾಡಿ ಹೌದು ಇದರಲ್ಲಿ ಇದು ವಿಭಾಗ ಆಗಿರೋದು ಓರಲ್ ಪಾರ್ಟಿಷನ್, ಓನ್ಲಿ ಮೇಲ್ ಚಿಲ್ಡ್ರನ್ ಹ್ಯಾವ್ ಟೇಕನ್ ಇಟ್ ಫ್ರಮ್ ದ ಬೆನಿಫಿಟ್ ಆಫ್ ದ ಪ್ರಪೋಸಿಟರ್ಸ್, ದ ಫೀಮೇಲ್ ಚಿಲ್ಡ್ರನ್ ಹ್ಯಾವ್ ನಾಟ್ ಟೇಕನ್. ಏನಾದ್ರೂ ಒಂದು ಫೈಂಡಿಂಗ್ ಬೇಕಿಲ್ಲ, ಫೈಂಡಿಂಗ್ ಇಲ್ಲ. ಸೊ this, unless this, at least the determination whether it is a joint family property or not, merely because I have not produced site certificates or sale certificates or sale deeds, will not make it a case where I am completely ousted, my lords, saying predominantly the major premise working in the background is I have not come with clean hands. At least the judgment will have to be rewritten, my lords, if not given an opportunity for the other side also to lead evidence. That's the only limited submission, my lords. I don't want to give.
Reviewed by the,
Please be seated.
being reviewed by the judgment and decree. Case number 4658 up to 2016. The plaintiffs are before this court in appeal.
Plaintiffs.
The plaintiffs who are the sisters of defendant number,
Defendants, all the defendants, my lord. Sisters of defendants,
defendants.
oh, defendants.
The plaintiffs and the defendants are the siblings.
Yes.
Born to
Ashwath Narayan.
Ashwath Narayan. The plaintiffs being the daughters have instituted the suit against the defendants 1, 2, 3 who are their brothers, and defendant number 4 is another sister. The plaintiffs contended that Ranga Hanamaya was the proposed witness of the joint family. And he had 4 children during his lifetime. 4 children, and during his lifetime,
Oral partition, 2003.
these children had acquired immovable properties. He and his children had acquired immovable property. And when Ranga Hanamaya died intestate, the joint family consisting of the plaintiffs and defendants inherited the suitable properties. Thereafter, there was an oral partition between the defendant number 1 to 4.
1 to 3, sir. 4 is actually the wife of 3.
4 yaru?
4, 3 our wife to whom a gift deed is made, which also we have challenged.
The oral partition. Will depend number 1 to 3 only. It is the contention of the plaintiffs that they being the daughters are also entitled for partition. A share in the partition. It was also alleged that the partition deed executed among the defendant number 1 to 3. And later the defendant number 4 being gifted by one of the property by her husband.
Her husband, defendant number 3.
Husband, that is defendant number 3. He is not binding on the plaintiffs, and therefore they are entitled for a share. On being summoned by the court, some of the defendant did not appear to contest the suit. After recording the evidence of the plaintiff, one of the plaintiffs come up and exhibits P1 to nothing being marked, come up. The court framed only one point to the effect that whether the plaintiffs are entitled for the relief sought for. By holding that the evidence placed on record by the plaintiffs is not does not disclose all the facts, but opining that the plaintiffs have tried to mislead the court only to get the collusive decree, it dismissed the suit. The reason to hold that the plaintiffs had misled the court was that all the documents showing that the name of the plaintiffs was also shown in the revenue records was not placed before it. The learned counsel appearing for the appellant plaintiffs submit that there was no contest by any of the defendants in the matter, and there was no reason to opine that it is a collusive decree. Full part. Collusive suit. It is also submitted that the only question the trial court should have looked into is to find out whether the suit schedule properties are the joint family properties or not, and whether they are amenable for partition. It is submitted that when the properties were standing in the name of Ranga Hanumaya, and some other properties were acquired by the joint exertion of the defendant number 1 to 3. The properties remain to be the joint family properties, and as such, on the demise of Ranga Hanumaya, the plaintiffs are also entitled for a share, they being the daughters of Ranga Hanumaya. Therefore, this aspect was never looked into by the trial court, and as such, the impugned judgment is not sustainable in law. On a careful perusal of the impugned judgment as well as the records, it is evident that the moot question that was before the trial court was to find out whether the plaintiff and defendants had succeeded to or had acquired any right in the suit shell properties, for they being either the properties devolved upon them from Ranga Hanumaya or being acquired by the joint exertion of Ranga Hanumaya and the defendant number 1 to 3. Therefore, the trial court coming to the conclusion that the plaintiffs have not placed any document on record to show that their name also appeared in the revenue records of the joint family property does not stand for any reason. It is the case of the plaintiffs that even though there was a oral partition among the defendants 1 to 3, such oral partition is not binding on them, since they had already acquired a share in the property that could have fallen to the share of Ranga Hanumaya in the notional partition. Obviously, this aspect is not considered by the trial court. Therefore, we are of the view that an appropriate point has not been considered by the trial court on the basis of the available material. Hence, the matter has to be sent back to the trial court to answer the point raised by the plaintiffs in the suit. That is, whether the suit shell properties are the joint family properties, are the ancestral or the acquired properties of the joint family of Ranga Hanumaya and his children. After answering the said question, the trial court has to dispose of the matter in accordance with law. Of course, after affording another opportunity to the defendants to place their view, to place their contention in the matter. Hence, we direct that the trial court shall complete the exercise within a period of 6 months from the date of the order of this court. Records. Appeal is allowed accordingly in terms of the above order.
I'm so grateful.
Okay.
I'm sorry, my lord, I was. I'm sorry, my lord, I was waiting here, I was called in the other court, my lord.
Sorry.
I was called in
You
the
need
other,
not be a permanent fixture in our court because
No.
very cases.
I was called in the other court, that's why. I
No
went.
issue, no issue.
Yes.
Understood.
But the petition applicant, my lord, petitioner before this honorable court, my lord, who was working as an FTA, my lord, was charged with certain offense, my lord, of releasing of 75% of the amount of suspension amount. That tribunal, that was challenged by various persons, my lord, including the petitioner before this honorable court. The tribunal, my lord, having come to the conclusion, has set aside the order.
Case again,
My lord, we have been exonerated, your lords.
exonerated,
Exonerated.
acquitted.
Yes, your lords, acquitted.
The honorable acquittal or the benefit of doubt?
Honorable acquittal. My lord, may kindly see page 279, my lord, for a moment, my lord. Will not take much of your time. Page 278 of the inquiry report of the inquiry officer.
270.
279, my lord. It starts from, my lord, inquiry report, Annex D, my lord. My lord will get it, my lord, page 279, my lord.
ರುಜುವಾತುಗೊಂಡಿರುವುದಿಲ್ಲ.
Yes.
ರೀಸನಿಂಗ್ ಏನು?
ರೀಸನಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಕೆ ನಾಗರಾಜನ್ ನನ್ನ ಒಬ್ಬರನ್ನೇ ಇದು ಪ್ಯಾರಾ 32 ಮೇಲೆ ಆದ್ಮೇಲೆ ಕೈಂಡ್ಲಿ ಸಿ ಫಾರ್ವರ್ಡ್ ಪ್ಯಾರಾ 32 ಮೇಲೆ ಐ ವಿಲ್ ಗೋ ಬೈ. ಆಪಾದಿತ ಅಧಿಕಾರಿ ಶ್ರೀ ನಾಗರಾಜನ್ ಹುದ್ದೆ ಅವರನ್ನ ಒಬ್ಬರನ್ನ ಚೀಫ್ ಅಕ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ಉಳಿದವರೆಲ್ಲ ಎಕ್ಸಾನರೇಟ್ ಆಗಿದ್ದಾರೆ ಅಂತೆ. ಹುದ್ದೆ ಆಗಿದ್ದು ವಿ ಆರ್ ಆಲ್ FDA ಮೇಲೆ ವಿ ಡೋಂಟ್ ಹ್ಯಾವ್ ಪವರ್ ಟು ಡೂ ಎನಿಥಿಂಗ್ ಇವೆಲ್ಲ. ಈ ಹುದ್ದೆಗೆ ನೇರ ನೇಮಕಾತಿ ಆಗಿರದೆ ಭರ್ತಿಯಿಂದ ತುಂಬಲ್ಪಟ್ಟ ಹುದ್ದೆ ಎಂದು ವಾದವನ್ನು ಮಂಡಿಸಲಾಗಿದೆ. ಆದರೆ ಶ್ರೀ ನಾಗರಾಜನ್ ಅವರು ಹುದ್ದೆಗೆ ಭರ್ತಿ ಪಡೆಯಲು ಕೆಳಾಂತಸ್ತಿನ ಹುದ್ದೆಗಳಲ್ಲಿ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ. ಆದರೆ ಇವರ ಅನುಭವ ಬಹಳ ವಿಶಾಲವಾದುದು. ಸೋನ್ಸೋ ನುಡಿ ಸಾಕ್ಷ್ಯಗಳನ್ನು ಒಟ್ಟಾಗಿ ಓದಿಕೊಂಡಲ್ಲಿ ಈ ಅಧಿಕಾರಿ ವಿಶೇಷ ನಿರ್ವಾಹಕನಿಂದ ತನ್ನಲ್ಲಿಗೆ ಬಂದ ಕಡತವನ್ನು ಗಮನದಲ್ಲಿಟ್ಟುಕೊಂಡು ಪರಿಶೀಲಿಸಿ ಆದೇಶ ಮಾಡಿದ್ದಾರೆ. ಹೀಗಿರುವಲ್ಲಿ ಪ್ರಾಣಿ 15 ಆದೇಶದ ಇಲಾಖೆಯ ಉನ್ನತಾಧಿಕಾರಿ ಹೊರಡಿಸಿರುವ ಆದೇಶವಾಗಿದ್ದು, ಉಳಿದ ಅಧಿಕಾರಿ ನೌಕರರು ಈ ಆದೇಶವನ್ನು ಮಾನ್ಯತೆ ಮಾಡಬೇಕು. ಮಾಡದೇ ಇದ್ದಲ್ಲಿ ಅದನ್ನು ನೌಕರರ ವಿರುದ್ಧ ಮಾಡಿರುವ ಆಪಾದನೆ ಸೋನ್ಸೋ ಆದೇಶವನ್ನು ಆಪಾದಿತ ಅಧಿಕಾರಿ ಶ್ರೀ ನಾಗರಾಜನ್ ಹೊರಡಿಸಲು ಕಡತಗಳನ್ನು ಅವರವರ ಹಂತದಲ್ಲಿ ಅವರವರಿಗೆ ಬೇಕಾದ ರೀತಿಯಲ್ಲಿ ಮಂಡಿಸಿದ್ದಾರೆ ಎಂದು ಆಗಿದೆ. ದುರಾದೃಷ್ಟಕರ ಸಂಗತಿ ಎಂದರೆ ಪ್ರಾಣಿ 15 ಆದೇಶವನ್ನು ಹೊರಡಿಸಲು ಮಂಡಿಸಲಾಗಿದೆ ಎಂದು ಹೇಳಿರುವ ಕಡತದ ಟಿಪ್ಪಣಿ ಹಾಳೆಗಳು ಲಭ್ಯವಿರುವುದಿಲ್ಲ. ಯಾವ ಕಾರಣ, ಯಾವ ಸಂದರ್ಭ ಮತ್ತು ಯಾವ ಆಧಾರಗಳ ಮೇಲೆ ಪ್ರಾಣಿಯನ್ನು ಹೊರಡಿಸಲಾಗಿದೆ ಎಂದು ತಿಳಿಯಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಕಡತದ ಟಿಪ್ಪಣಿ ಹಾಳೆಗಳನ್ನು ಸಂಪೂರ್ಣ ಮಂಡಿಸಿದ್ದಲ್ಲಿ ಯಾವ ಮಟ್ಟದಲ್ಲಿ ಯಾವ ಆಪಾದಿತ ಅಧಿಕಾರಿ ನೌಕರರು ಎಷ್ಟರ ಮಟ್ಟಿಗೆ ಹೊಣೆಗಾರರಾಗಿದ್ದಾರೆ ಎಂದು ತಿಳಿಯಲು ಸಾಧ್ಯವಾಗಿದ್ದು, ಕೆಲವೇ ಟಿಪ್ಪಣಿ ಹಾಳೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದು ಅದು ಆಪಾದಿತ ಅಧಿಕಾರಿ ನೌಕರರ ಕಡೆಯಿಂದ ಹಾಜರುಪಡಿಸಲಾಗಿದೆ. ಆದರೆ ಎಲ್ಲಾ ಅಕೃತ್ಯಗಳಿಗೂ ಬೆರಳು ಮಾಡಿ ತೋರಿಸಬೇಕಾದರೆ ಮುಖ್ಯವಾಗಿ ಮುಖ್ಯವಾಗಿ ಅದನ್ನು ಶ್ರೀ ನಾಗರಾಜನ್ ರವರ ಕಡೆಗೆ ತೋರಿಸಬೇಕಾಗಿದೆ. ಆಪಾದನೆಗಳಿಗೆ ಮುಖ್ಯ ಹೊಣೆಗಾರ ಶ್ರೀ ನಾಗರಾಜನ್, ಆದರೆ ಅವರನ್ನು ಈ ವಿಚಾರಣೆಯಿಂದ ಕಾರಣ ಏನೇ ಇದ್ದರೂ ಹೊರಗಡೆ ಇರಿಸಲಾಗಿದೆ. ಈ ಸಂಬಂಧ ರಾಘವೇಲು ವಿರುದ್ಧ ಆಂಧ್ರ ಸರ್ಕಾರ ಹಾಗೂ ಮತ್ತೊಬ್ಬರು CA ನಂಬರ್ ಸೋನ್ಸೋ ಈ ರೀತಿ ತಿಳಿಸಲಾಗಿದೆ. ವೇರ್ ಸಿಮಿಲರ್ಲಿ ಚಾರ್ಜ್ಡ್ ಆಫೀಸರ್ಸ್ ಫಾರ್ ಐಡೆಂಟಿಕಲ್ misconduct and on the same set of evidence are exonerated. The officers who is indirectly connected in the case cannot be punished. ಈ ಎಲ್ಲಾ ಕಾರಣಗಳಿಂದ ಯಾವುದೇ ಆಪಾದಿತ ಅಧಿಕಾರಿ ನೌಕರರ ವಿರುದ್ಧ ಮಾಡಿರುವ ಯಾವುದೇ ಆರೋಪಗಳು ರುಜುವಾತುಗೊಂಡಿರುವುದಿಲ್ಲ. And my lord, the common objection was filed in a batch of cases, my lord. A common
enquiry ಅಲ್ಲಿ ಏನಾಯ್ತು?
My lord.
Disciplinary enquiry ಅಲ್ಲಿ ಏನಾಯ್ತು?
Inquiry.
This is the disciplinary inquiring authorities order, my lord.
ಇದು acquittal ಆಗಿದ್ದಲ್ವಾ?
ಇಲ್ಲ, there is no criminal proceedings initiated.
There was no criminal proceedings initiated, your lord.
It is only a departmental inquiry, my lord, for having
ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ ಸಸ್ಪೆನ್ಷನ್ ಅಲೋಯನ್ಸ್ ಅನ್ನ ಜಾಸ್ತಿ ರಿಲೀಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇವರು ಅಂತ. ದಟ್ಸ್ ವಾಟ್ ದಿ ಚಾರ್ಜಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ಇವರು ರಿಲೀಸ್ ಮಾಡೋಕೆ ಅಧಿಕಾರನೇ ಇಲ್ಲ ಇವರಿಗೆ. ದೇ ಹ್ಯಾವ್ ಪುಟ್ ಅಪ್ ದಿ ಫೈಲ್ ಆಸ್ ಪರ್ ದಿ ಡೈರೆಕ್ಷನ್ ಆಫ್ ದಿ ಹೈಯರ್ ಆಫೀಸರ್. 50% ಇವರು ಪುಟ್ ಅಪ್ ಮಾಡಿದ್ದಾರೆ. ಕಾಮನ್ ಅಬ್ಜೆಕ್ಷನ್ 75% ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ದಟ್ ವಾಸ್ ಟೇಕನ್ ಇನ್ ಟು ಕನ್ಸಿಡರೇಷನ್. And based on that common objection, my lord, without independently considering each of the person's mistake or allegation, the tribunal, of course, ordered in our favor, but directed to issue show cause notice.
But the proposal was sent by BEO And it was approved by the deputy director. Both the BEO and deputy director, my lords, were kept out of the inquiry.
ನೀವ್ ಯಾರಿಗೆ appear ಆಗ್ತೀರಿ?
I am for one superintendent and second division assistant, my lord. That is one Mr. Venkatesh Murthy. That is at page number in my petition, my lord. He is DGO number 5 and DGO number 7 in the inquiry.
One. Connected matters. 1, 2, 3, 4 idavana.
I appear for Nagesh, MJ Nagesh.
The order of the tribunal, page 75, my lord.
ಅಲ್ಲಿಗೆ ಅಲ್ಲಿ ನೀವು ಈಗ ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ said you are not responsible.
No.
Yes.
ಅದಾದ್ಮೇಲೆ ಮುಂದೇನಾಯ್ತು?
My lord, thereafter the disciplinary authority first respondent, my lord, issued a second show cause notice, my lord, differing from the view expressed by the inquiry officer. My lord, to that we submitted explanation. Thereafter, my lord, he proceeded to impose a penalty. My lord, that was challenged before the tribunal, my lord, specifically taking a contention. I mean, so far as the petitioner in Venkatesh Murthy, my lord, he never worked during that period. When the enhanced suspension payment was made, the Venkatesh Murthy has never worked in that department. Still, my lord, he was included in the.
And proceedings was initiated after 12 years from the
ನಿಮ್ಮ
date.
ಕ್ಲೈಂಟ್ ವೆಂಕಟೇಶ್ ಮೂರ್ತಿ ನಿಮ್ ಕ್ಲೈಂಟ್ ಅನ್ನ?
Yes.
The proceedings was initiated after 12 years from the date of said allegation, mistake said to have been committed, your lords, after 12 years. That is also one of the contention, your lords.
ಟ್ರೈಬ್ಯುನಲ್ ಏನ್ ಹೇಳ್ತದೆ?
And my lord, the tribunal, my lord, it has come to the conclusion that the order is incorrect and ಹೇಳಿ, a show cause, my lord, I will take your lordship's attention to para. There, page 74, your lordship, page 74, my lord, of the tribunal order. My lords got it, my lord.
74.
74.
Paragraph 10.
74. In my petition 22-188 of 2023. Therefore, looking at the second show cause notice, my lords got it. Issued by the disciplinary authority in all the applications are not sustainable in law, and the consequential, the penalty orders imposed against the applicants basing upon such second show cause notice is also not sustainable. Hence, the applicants have made out case. Having come to the conclusion, last page of 74, my lord, in my writ petition.
ಅಲ್ಲ, page 74 ನಲ್ಲಿ ಪ್ಯಾರಾ 10 ಅರ್ಧ ಇದೆ.
Para 10,
ಮುಂದೆ
para 9, my lord. Oh, ಅದಲ್ಲ. Para 10. ಇಲ್ಲ 27 ಕಂಟಿನ್ಯೂ ಇದೆ ಸ್ವಾಮಿ.
ಕ್ವಾಶ್ ಮಾಡಿ ರಿಮೈಂಡ್ ಮಾಡ್ಯಾರೆ.
ರಿಮೈಂಡ್ ಮಾಡಿ.
ರಿಮೈಂಡ್ ಮಾಡಬಾರ್ದಿತ್ತು, ಪೂರಾ ಎಕ್ಸಾಮ್ ಮಾಡ್ಬೇಕಿತ್ತು.
ಈಗ 2-3 persons melody is about to retire, your lordship. ಇನ್ನೊಂದು 2-3 months ಅಲ್ಲಿ ರಿಟೈರ್ ಆಗ್ತಾರೆ. ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇನಿಷಿಯೇಟ್ ಮಾಡಿದ್ರೆ 12 ವರ್ಷ ಡಿಲೇ. ಅಂಡ್ ಚಾರ್ಜಸ್ ಮಿಲಾಡ್ ಅವ್ರದ್ದು ಇವ್ರೇನು ರಿಲೀಸಿಂಗ್ ಅಥಾರಿಟಿಯೂ ಅಲ್ಲ, ಸ್ಯಾಂಕ್ಷನಿಂಗ್ ಅಥಾರಿಟಿಯೂ ಅಲ್ಲ, ರೆಕಮೆಂಡಿಂಗ್ ಅಥಾರಿಟಿಯೂ ಅಲ್ಲ. ಇವ್ ಪುಟ್ ಅಪ್ ದಿಸ್ ರೆಕಾರ್ಡ್ ಅಂದ್ರೆ ಇವ್ರು FDA ಆಗಿದ್ರು. FDA
ಪ್ರಪೋಸಲ್ ನೋಟಿಸ್ ನಲ್ಲಿ ಏನನ್ನ ರಿವರ್ಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ಯಾವ ಫೈಂಡಿಂಗ್ ಅನ್ನು ರಿವರ್ಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು.
ಅದನ್ನ
ವೆರಿ ಸೆಕೆಂಡ್ ನೋಟಿಸ್ ಅಲ್ಲಿ ಇದೆ. ಶೋಕಂದ್
ಸೆಕೆಂಡ್ ನೋಟಿಸ್
4 ಮೇಲೋ. 204 page number.
204.
Yes, second show cause notice, my lord, page 204. ನೀವು ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿ ದಕ್ಷಿಣ ವಲಯ 3 ಕಚೇರಿಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಅವಧಿಯಲ್ಲಿ ಅನುದಾನಿತ ಶಾಲೆಯ ಅಮಾನತುಗೊಂಡ ಶಿಕ್ಷಕರಿಗೆ ಜೀವನಾಧಾರ ಭತ್ಯೆ ಅಮಾನತುಗೊಂಡ 6 ತಿಂಗಳ ನಂತರದ ಅವಧಿಗೆ ಬಂದರೆ ದಿನಾಂಕ 18-12-2009 ಮಾರ್ಚ್ 2010 50% ಜೀವನಾಧಾರ ಭತ್ಯೆಯನ್ನು ಪಾವತಿಗೆ ಬಿಲ್ಲು ಮಂಡಿಸುತ್ತೀರಿ. ದಿಸ್ ಇಸ್ ದಿ ಚಾರ್ಜ್. ಬಟ್ ಕಾಮನ್ ಅಬ್ಜೆಕ್ಷನ್ ವಾಸ್ ಫೈಲ್ಡ್, ಮೈ ಲಾರ್ಡ್. 75% ರಿಲೀಸ್ ಮಾಡಿದ್ದಾರೆ. ಆ 75% ರಿಲೀಸ್ ಮಾಡಿದವ್ರನ್ನ ಗಮನಕ್ಕೆ ತಗೊಂಡು ನಮಗೂ ಸೇಮ್ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಅಪ್ಲೈ ಮಾಡಿ ನೋಟಿಸ್ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. 50% ಅವ್ರಿಗೆ ಸಪರೇಟ್ ಆಗಿ ಡೀಲ್ ಫೈಂಡಿಂಗ್ ಕೊಡಬೇಕಾಗಿತ್ತು. 75% ಅಂತ ಯಾರು ರಿಲೀಸ್ ಮಾಡ್ತಾರೆ, ರೆಕಮೆಂಡ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಅವ್ರಿಗೆ ಒಂದು ಇಂಡಿಪೆಂಡೆಂಟ್ ಫೈಂಡಿಂಗ್ ಕೊಡಬೇಕಾಗಿದೆ. ಎ ಕಾಮನ್ ಫೈಂಡಿಂಗ್ ಹ್ಯಾಸ್ ಬಿನ್ ರೆಕಾರ್ಡೆಡ್. Though charges are face manner different and one to another. Then, my lord, we gave a reply, my lord. So,
ಇಷ್ಟು ಜನ ಪಿಟಿಷನರ್ಸ್ ಅಲ್ಲಿ ಯಾರು ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಇದಕ್ಕೆ?
My lord,
Nagarajan ante.
my lord, Deputy Director and Block Education Officer.
Deputy Director, my lord.
ಅವ್ರು ಯಾರು?
Deputy Director, my lord.
ಅವ್ರು ಯಾರು? ಈ ತರ ಪಿಟಿಷನ್ ದಲ್ಲಿ ಯಾರು ಅವರು?
They are not there, my lord. They have retired from service and therefore they
They
are
are
left.
retired from service, my lord.
ಅವ್ರು ರಿಟೈರ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ರು.
ಹೌದು. ಅದಕ್ಕೆ
Therefore, they
para
are left
23 of my grounds I have stated, my lord, may kindly see para 23, it makes it clear, your lordship. Para 23, my lord. Para 23 of my grounds, page 39, my lord. ಒಂದೆರಡು para, it gives a correct picture, your lordship. My lords, para 23, my lord. The impugned orders of the tribunal is also liable to be quashed in so far as remitting the matter to the disciplinary authority for the reason that the inquiry officer has categorically given a finding that the petitioner herein was acted as per the direction of the Deputy Director of Public Instructions. Therefore, the petitioner has no independent right to do anything in the matter. As he being a first division assistant, he has no right to or power to sanction or release or grant any subsistence allowance. When that being the situation, when the petitioner has no power to do so, the allegation being tainted with malefides and report of the inquiry officer being in accordance with law, where he has clearly stated that where similarly charged officer in identical misconduct and on the same set of evidence are exonerated.
23,270 ರಿಕವರ್ ಮಾಡಿಕೊಳ್ಳಿ. ಇನ್ಕ್ರಿಮೆಂಟ್ ಹಾಕೋದು ಬೇಡ.
ಅಲ್ಲ ಒಬ್ಬರಿಗೆ ಈ ಚಾರ್ಜ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ತಪ್ಪು ಮಾಡಿದ್ರೆ ಮಾಡ್ಲಿ ಸ್ವಾಮಿ, ಅದರ್ವೈಸ್ ಇಟ್ ವಿಲ್ ಬಿ ಸ್ಟಿಗ್ಮಾ ಮೇಲೆ ಪ್ರಮೋಷನ್ ಡ್ಯೂ ಇದೆ.
ಅಲ್ಲ ರಿಕವರಿ ಪೆನಾಲ್ಟಿ ಆಗತ್ತನ?
ಇನ್ನೊಂದು 3 ತಿಂಗಳಿಗೆ ಪ್ರಮೋಷನ್ ಕೊಡ್ಬೇಕಾಯ್ತು, ಇದಕ್ಕೋಸ್ಕರ ಕೊಟ್ಟಿಲ್ಲ. 10 ವರ್ಷ ಹಿಂದೆ ಪ್ರಮೋಷನ್ ಅವರ್ ಜೂನಿಯರ್ಸ್ ಆರ್ ವರ್ಕಿಂಗ್ ಮೇಲೆ ಅಂಡರ್ ದೆಮ್ ವಿ ಆರ್ ವರ್ಕಿಂಗ್ ಮೇಲೆ. ಇನ್ 3 ತಿಂಗಳಲ್ಲಿ ರಿಟೈರ್ ಆಗ್ತೀನಿ, ಪ್ರಮೋಷನ್ ಕೊಡ್ಬೇಕು, ಅದಕ್ಕೋಸ್ಕರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿತ್ತು, ಅದು ಇಲ್ಲ. ಪ್ರೊಫೆಷನಲ್ ಬೆನಿಫಿಟ್ ಇಲ್ಲ. ದಟ್ ಆಲ್ಸೋ ಅಮೌಂಟ್ಸ್ ಟು ಸ್ಟಿಗ್ಮಾ ಮೇಲೆ.
May I submit, my lord, your lordship may kindly take my writ petition 26631, my lord. 3 documents I will show, my lord, to show who is responsible. 26631, my lord. Lordship got it.
ಇವು FDC ಏನ್ ಸಂಬಂಧ ಪಡ್ತಾನೆ ಅಂತ?
Yes, my lord, your lordship.
ಅಲ್ಲಮ್ಮ,
Page 77.
Madam Kulkarni.
Yes, my lord.
How these officers concerned with this? Who is the authority who decides? ಭಾಳ ಅಂದ್ರೆ ಹೆಡ್ ಮಾಸ್ಟರ್ ಇರ್ತಾರೆ. How these persons are concerned with this?
My lords may kindly see the second show cause notice, my lord. My lord, here what has happened, the disciplinary authority has disagreed with the
Exonerated all the
yes, my lord,
employees.
he's disagreed
But
with the finding
proposal
of the
notice was-
inquiry officer. In the second show cause notice, my lord, they say about Sri Lokesh Kumar.
Lokesh Kumar.
Yes, my lord. So
ಏನಂತ?
one Sri Lokesh Kumar, my lord.
Oh, he is FDC.
Yes, my lord.
FDA.
FDA, that's
is
what. How he is concerned with the sanctioning of subsistence allowance? ಯಾರು ತೋತಾರೆ? ಡಿಸಿಷನ್ ಯಾರು ತೋತಾರೆ?
I have to take.
Deputy Director of
instructions from-
Public Instructions only, my lord.
But as
DPI
per the-
He is the class 2 officer.
there is a loss to the state exchequer, my lord.
Correct. Who caused it?
That I have to take.
DDPI ಇಂದ ನೀವು ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಕಿತ್ತು.
And person
How these people are?
What it says, my lord,
Huh?
in so far as subsistence allowance is concerned, the rule says, my lord, that the management has to pay the allowance, not the government. Yes, my lord.
Lord, but the proposal is submitted
That
by
is the-
block education officer
We will
seeking
issue
enhancement,
second
my lord.
show cause notice, my lord. We will issue second show cause notice. That is the direction of the KAT, my lord.
Page 77 of my writ petition, my lord. It shows that the deputy director, my lord, has directed reinstatement of the suspended officers. Though that was done on 11/11/2009, my lord, the block education officer submits a proposal to enhance the subsistence allowance on 16/9/2010. And thereafter, my lord, it is approved by the deputy director on 25/10/2010.
and there is no
There's already
answer.
a direction for reinstatement, my lord. The block education officer could not have forwarded a proposal, and we are all working in the office of the deputy director.
And there was no finding or answer, my lord, in respect of delay of 12 years, your lordship.
Those three documents are produced along with the writ petition, my lord. Your lordship may kindly have a perusal of those three documents, my lord, page 77 of writ petition number.
ನಿಮ್ಮ ಪಿಟಿಷನ್
Yes, my lord, 26631.
ವೆಂಕಟೇಶ್ ಮೂರ್ತಿ.
Yes, ma'am. Page 77, my lord. Annexure A3. This is the order of the Deputy Commissioner, my lord.
Deputy Director.
Sorry, Deputy Director, my lord. My lord, 11/11/2009, my lord. Last two lines of the page, my lord. ಶ್ರೀಮತಿ ಪಿ ಸುಧಾ ವಿಜ್ಞಾನ ಸಹ ಶಿಕ್ಷಕರು ಇವರು ಉಲ್ಲೇಖಿತ 5 ಮತ್ತು 6 ಮಾನ್ಯ ಪ್ರಾಥಮಿಕ ಮತ್ತು ಪ್ರೌಢಶಿಕ್ಷಣ ಸಚಿವರಿಗೆ ಹಾಗೂ ನಿರ್ದೇಶಕರು ಆಯುಕ್ತರ ಕಚೇರಿಗೆ ಮನವಿ ಸಲ್ಲಿಸಿ ಅವರ ಅಮಾನತು ತೆರವುಗೊಳಿಸಿ ಸೇವೆಯಲ್ಲಿ ಪುನರ್ ಸ್ಥಾಪಿಸುವಂತೆ ಮನವಿ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಆದ್ದರಿಂದ ಈ ಪ್ರಕರಣ ನಡೆದು ಈಗಾಗಲೇ 6 ತಿಂಗಳ ಅವಧಿ ಮುಗಿದಿದ್ದು ಕೂಡಲೇ ವಿಚಾರಣಾ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಪೂರ್ಣಗೊಳಿಸುವಂತೆ ತಿಳಿಸುತ್ತಾ ಶ್ರೀಮತಿ ಸುಧಾ ವಿಜ್ಞಾನ ಸಹ ವಿಚಾರಣಾ ಕಾಯ್ದಿರಿಸಿ ಆಡಳಿತ ಮಂಡಳಿ ನಡೆಸುವ ಬೇರೆ ಶಾಲೆಯ ಸೇವೆಯಲ್ಲಿ ಪುನರ್ ಸ್ಥಾಪಿಸಲು ಅನುಮತಿ ನೀಡಿದೆ. ಆಡಳಿತ ಮಂಡಳಿಯು ಈ ಕೆಳಕಂಡ ಷರತ್ತುಗಳು ಪಟ್ಟು ಇವರ ವಿರುದ್ಧ ಆರೋಪ ಪಟ್ಟಿಯನ್ನು ಸಿದ್ಧಪಡಿಸಿ ವಿಚಾರಣೆಯನ್ನು ನಡೆಸಿ ನಿಯಮಾನುಸಾರ ಮುಂದಿನ ಕ್ರಮ ಜರುಗಿಸಲು ತಿಳಿಸಿದೆ. They have been ordered to be reinstated. This is on 11/11/2009. Now, my lord, page 79, my lord, 16/9/2010, almost after 9 months, my lord, 10 months, the block education officer writes to the deputy director, my lord, to sends a proposal seeking enhancement of subsistence allowance from 50 to 75%, my lord. Not in the only one paragraph, third line, my lord, ಶೇಕಡ 50ರಷ್ಟು ವೇತನ ನೀಡುತ್ತಿದೆ. ಇವರುಗಳನ್ನು ಅಮಾನತಿನಲ್ಲಿಟ್ಟಿರುವ ಅವಧಿ 6 ತಿಂಗಳು ಮುಕ್ತಾಯವಾಗಿರುವುದರಿಂದ ಶೇಕಡ 75ರಷ್ಟು ವೇತನ ನೀಡಲು ಅನುಮತಿ ನೀಡಬೇಕೆಂದು ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ಕೋರಿರುತ್ತಾರೆ. ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ ಕೋರಿರುವ ವಿಷಯದ ಬಗ್ಗೆ ಅನುಮತಿ ನೀಡಬೇಕೆಂದು ಕೋರಿದೆ. Now the deputy director, my lord, by another order, my lord, at annexure A5, page 81. Grants approval for grant of enhanced subsistence allowance on 25/10/2010.
ಸಿ ನಾಗರಾಜನ್.
Yes.
Nagarajan, yes.
He is also retired and block education officer also have retired, my lord. And therefore, my lord, the others who are working under them are being made as a scapegoat, my lord, and proceedings have been initiated against them.
ಏನು ಇಲ್ಲ ಇವ್ರದ್ದು ಏನಿದೆ ಕಾಂಪ್ಲಿಸಿಟಿ.
But let me take instructions, my lord. What is the
Yeah,
role
fine,
of
fine.
these FDAs, my lord?
ಇದು ಇಬ್ರದಾತ ಇನ್ನಿಬ್ರು ಯಾರು ಏನೇನು?
The other person is second division assistant, my lord, that is WP 28823, my lord, Vishwanath, yes. He was working as second division assistant, my lord.
And 27123 was working as assistant director at that time. He was below the deputy director.
ಇನ್ನೊಂದು
ನಂದು ಎರಡಿದೆ.
FDA.
ಒಂದು FDA,
ಇನ್ನೊಬ್ರು ಯಾರು?
ಇನ್ನೊಂದು ಜಯಪ್ರಕಾಶ್ ಅಂತ ಹೇಳಿ ಗೆಜೆಟೆಡ್ ಮ್ಯಾನೇಜರ್, your lordship.
ಗೆಜೆಟೆಡ್ ಮ್ಯಾನೇಜರ್ MG ಜಯಪ್ರಕಾಶ್.
MG ಜಯಪ್ರಕಾಶ್, your lordship.
ಅವ್ರದ್ದೇನ್ ರೋಲ್?
ಅವ್ರದ್ದು ಏನು ರೋಲ್ ಇಲ್ಲ ಅಂತಾನೆ ಎಕ್ಸಾನರೇಟ್ ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ಸ್ಟಿಲ್ ಇದು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
All have implemented the orders of
we are
the deputy
allowing
director.
ಎಲ್ಲ 10-12 ವರ್ಷ ಆದ್ಮೇಲೆ ಇವ್ರನ್ನೆಲ್ಲ
12 ವರ್ಷ ಆದ್ಮೇಲೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇನಿಷಿಯೇಟ್ ಮಾಡವ್ರೆ. ಬೈ ದಿ ಟೈಮ್ ಪರ್ಸನ್ಸ್ ಹೂ ರಿಯಲಿ ಕಮಿಟೆಡ್ ದಿ ಮಿಸ್ಟೇಕ್, your lordship, ಅವರು ಪ್ರಮೋಷನ್ ತಗೊಂಡ್ರು, ರಿಟೈರ್ ಆಗೋದ್ರು, they are enjoying the benefit. We are hanging in the court, your lordship.
The 2 promotions have been given to my juniors, my lord, because of the pendency of this proceedings, my lord.
No, ನೋಡಿ.
Yeah, yes, me also.
Proceedings are, petitions are allowed. The disciplinary proceedings intended pursuant to second show cause notice are set at naught. Since the decisions in relation to suspension, revocation of suspension, payment of subsistence allowance and payment of enhanced subsistence allowance are taken by the jurisdictional authorities, and in no way the delinquent employees are concerned with the same. First. Secondly, the proceedings of the kind ought to have been initiated long ago and not after a lapse of a decade, as rightly contended by Shivram and Vijay Kumar. First, we have noted that the retired district judge who had held the inquiry proceedings had submitted the report wherein last page of Shivram's first writ petition.
Yes, sir.
Mentions as to why all they are entitled to be exonerated. First off, reversing of the findings of the inquiry report, although is permissible, comma, very strong case has to be made out in that connection. First off, such a case has not been made out in the present case. First, allowed. That's.
Let there be an observation regarding considering our promotion, my lord, which has been.
ಆದ್ರೆ ಇದ್ರ ಮಾಡಕ್ ಬರಲ್ಲ. ನೀವು ಇದು ಎಷ್ಟು ಚಾಲೆಂಜ್ ಇದೆ ಅಷ್ಟೇ.
ಇದರಲ್ಲಿ ನಾನು ಒಂದು ಪೆಂಡಿಂಗ್ ಒಂದು ಐ ಹಾಕಿದ್ದೆ ಸ್ವಾಮಿ, ಪ್ರಮೋಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
ನಾವೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ.
ಪ್ಲೀಸ್
ಆ ಕಾನ್ಸರ್ವೇಷನ್ ಇದರಲ್ಲಿ.
ಪ್ಲೀಸ್.
ಓಕೆ.
ಗ್ರೇಟ್ಫುಲ್.
ಮುರಳೀಧರ್ನು.
Please, Muralidhar, madam. I'm selected in that.
ನಿಮ್ ಕ್ಲೈಂಟ್ ಯಾರು?
MJ Nagesh anta. 271.
ಸ್ಟೇಟಸ್
Superintendent, madam. Below the deputy director.
All right.
Much open.
Okay.
Sir, 34 ಮಧ್ಯಾಹ್ನ ತಗೊಂತಾರೆ ಸರ್. 2:30 ಆದ್ಮೇಲೆ ತಗೊಂತಾರೆ. ಸರ್ ಪಾಸ್ ಅವರು
ಜಾಸ್ತಿ ಇದೆ.
ಯಾವ್ದು ಇಲ್ಲಲ್ಲ? ಪಾಸ್ವರ್ಡ್ ಯಾವ್ದು ಇಲ್ಲ?
ಒಂದಿದೆಯಲ್ಲ, ನಾನೇ ಕೇಳ್ಬಿಡ್ಬೇಕಾಗಿತ್ತು ಸರ್.
ಸರ್ ಇದು 31 ನಲ್ಲಿ ಎಲ್ಲ ಅಲೌ ಮಾಡ್ತಾರೆ ಸರ್.
ಫಸ್ಟಾ ಪಾಸ್ ಓವರ್ ಫಸ್ಟಾ?
Yes, ma'am. From tomorrow onwards, you have to see all the files are in order. Okay? We succeeded today, but still. Oh, study. File like this one. And this we will give to Pradeep AG. Take this also. Transfer. You have to tell him to get the order by day after.
ನಾವು ನಾಳೆಲ್ಲ ನಾವು ಕಲೆಕ್ಟೆಡ್ ಮಾಡಕ್ಕೆ ಸೆಕೆಂಡ್ ಸೆಟ್ಗೆ ಆಗ್ತದೆ ಕ್ಯಾಚ್ ಮಾಡೋದು ಈಸಿ ಆಗ್ತದೆ. ಇದು ಒಂದೊಂದು ಹಾಕ್ತೀವಿ.
ಈ ಸಾಹೇಬ್ರು ಏನ್ ಕರೀತಾರೆ ಗೊತ್ತಿಲ್ಲಪ್ಪ. ಪಾಸ್ ಕರೆಯೋದಿಲ್ವಾ ಗ್ಯಾರಂಟಿನ? ಸೊ ನಾನು ಆರಾಮಾಗಿ ಬರೋದ್ ಬೇಕಾಗಿಲ್ಲ. ಯಾರು ಇಲ್ಲ ಸರ್, ಅಲ್ಲಿರೋ ಕೆಲ್ಸಕ್ಕೆ ಎಷ್ಟೊಂದು ಪೆಂಡಿಂಗ್ ಆಗ್ಬಿಟ್ಟಿದ್ರೆ ಕ್ಲಿಯರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತಾ ಇಲ್ಲ, ಓದ್ಲಿಕ್ಕೂ ಟೈಮ್ ಸಿಗೋದಿಲ್ಲ. ಏನ್ ಬೇಡ
ಸರ್ ಹೈಕೋರ್ಟ್ ಶುರುವಾಗಿ ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು?
ಅಯ್ಯೋ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿದ್ದೀನಿ, ಸಾಹೇಬ್ರಿಗೂ ಹೇಳಿ ಅಂತ. ಸರ್ ನೀವು ಸಾಹೇಬ್ರಿಗೂ ಹೇಳಿ 200% ಇಲ್ಲಿ ರೆಡಿ ನಾಟ್ 100% ವಿಲ್ ನಾಟ್ ವರ್ಕ್ ಹಿಯರ್. 200% ಇದ್ರೆ ಮಾತ್ರ ಇಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. 100% ಅವ್ರದ್ದು 100% ಇವ್ರದ್ದು ಸೇರಿಸ್ಬಿಟ್ಟು ನಾವು 200 ರೆಡಿ ಆಗಿ ಏನೋ ಸಾಹೇಬ್ರಿದ್ದೀವಿ ಎತ್ತು ಬಿಡಿತಾರೆ 230 ಸುಮ್ಮನೆ. ಹೌದಾ? ಇವತ್ತಿಗೆ ನಾವು ಕಂಪ್ಯೂಟ್ ಮಾಡ್ತೀನಿ ರುಬೆನ್ ಸಾಹೇಬ್ರು. ಸೊ ಇವತ್ತು ರುಬೆನ್ ಸಾಹೇಬ್ರು ಸ್ಟಾರ್ಟ್ ಆಗೋದು. ಸರ್ ನಾಳೆನೂ ರಿಪೀಟ್ ಆಗುತ್ತಾ ಇದು? RFAಗಳು ಏನಾಯ್ತು ಸರ್? ಅದು ಕನ್ಕ್ಲೂಡಾ? ಅದು ನಡೀತಾ ಇತ್ತಲ್ಲ ಮುಗೀತು. ಏನ್ ಅದಕ್ಕೆ ಜನವರಿಗೆ ಹಾಕ್ತೀನಿ. ಜನವರಿಗೆ ಹಾಕ್ತೀನಿ. ಚೇಂಜ್ ಮಾಡ್ತೀವಿ.
Sir. Sir, court officer. ಇದು RFA ರಿಸರ್ವ್ ಫಾರ್ ಜಜ್ಮೆಂಟ್ ಆಗಿದೆ. ರಿಸರ್ವ್ ಫಾರ್ ಜಜ್ಮೆಂಟ್ RFA. ಸೆಟ್ಲ್ಮೆಂಟ್ ಏನಾರು ಇದ್ರೆ ಒಂದು ವಾರದಲ್ಲಿ ರಿಪೋರ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು. ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗಿಲ್ಲ. 5:30 of 2014. ಏನಾದ್ರು ಚೇಂಬರ್ಗೆ ಹೇಳ್ಬೇಕಾ ಏನು ಬೇಡ ಅಲ್ಲ? ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಆಗಿಲ್ಲ ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
Still you have to learn a lot. Have to learn.
ಫೈಲ್ ಇಟ್ಟು ಹೋಗಿರ್ಲ ಮೇಡಮ್? ಯಾವ್ದಕ್ಕೂ ಫೈಲ್ ಇಟ್ಟು ಹೋಗಿರ್ಲ? ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ, ರಿಮೈಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಅಡಿಷನಲ್ ಚಾರ್ಜ್ ಶೀಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹೇಳ್ಬೇಡಿ, ಇಲ್ಲಿ ಚಾರ್ಜ್ ಮೆಮೋ ಹೇಳಿ. ಈಗಪ್ಪ ಅದೊಂದು ತಲೆ ಬಟ್ ಎಲ್ಲಾ ಕಡೆ ಬಟ್ ಈ ಡಸಂಟ್ ಅಗ್ರಿ. ಶೀಟ್ ಅಂದ್ರೆ ಕ್ರಿಮಿನಲ್ ಅಂತಾನೆ. ಚಾರ್ಜ್ ಮೆಮೋ ಅಡಿಷನಲ್ ಆಗಿರುತ್ತೆ. Enquiry officer himself has framed. As per the rules, he disciplinary authority add any additional for that purpose it is remanded. Because enquiry officer being the enquiry officer, but judge himself, he cannot frame. No delay as such. Proceedings FIR ಕ್ರಾಶ್ ಆಗಿದೆ ಇದೆ, ಬಟ್ ಅಲ್ಲಿ ಇನ್ಕಮ್ ಸರ್ಟಿಫಿಕೇಟ್ ನ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ತಗೊಂಡಿರೋ 17,000 ಗಂಡನು ಇಲ್ಲಿ ಒಳ್ಳೆ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. And she has given the DD is also obtained through a DC. She has given so she had the knowledge. She is saying, but husband has entered all those. ಅದನ್ನು ಒಪ್ಕೊಳ್ತೀನಿ. ಜನ ಆಗ್ಬಿಡುತ್ತೆ. 50 ಪಾಸ್ವರ್ ಆಗಿದೆ. ನಾನು ಇಲ್ಲೇ ಇರ್ತೀನಿ. ಈ ತರ್ಟಿಗೆ ಶುರು ಆದ್ರೆ ಮಾತ್ರ ಬರ್ತೀನಿ. ಇಲ್ಲಾಂದ್ರೆ ಇದು ಅಟೆಂಡ್ ಮಾಡಿ ಹೋಗ್ತೀನಿ. I will not go this side. I will attend to it. If it takes up it, I will be. So, remanded the matter, disciplinary authority, consider a fresh stage it is vitiated. From that stage you continue. ರಿಮೈಂಡ್ ಆದ್ಮೇಲೆ ಬಂದಿರೋದು. ಯಾಕಂದ್ರೆ ಆಫ್ಟರ್ 2014 ಇದು ಆಲ್ರೆಡಿ 10 years ಆಗಿದೆ. ಕ್ರಾಶ್ ಆಗಿದೆ. ಅದಕ್ಕೋಸ್ಕರ ಸೇಮ್ ಚಾರ್ಜಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ದಟ್ ಇಸ್ ಆಲ್ ಟುಗೆದರ್ the delinquent itself shows that ನಾವು ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ is not disputing it. And that she the husband has being a police officer, he is have to maintain the view of you income certificate ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ ಹೌಸ್ ವೈಫ್ ಅಂತ ಗೊತ್ತಿದ್ದಾರೆ. And she has revealed the reservation. Serious, sir. Common man, okay. The police officer ಅದೇನಾಗಿದೆ ಅಂತ ಬಂದು ಇವ್ರ ಮೇಲೆನೆ ಹೇಳ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ. ಆಮೇಲೆ ಅಲ್ಟಿಮೇಟ್ ಡಿಸ್ಕಸ್ ಮಾಡಿ ನೀವು ಈ ತರ ಬೆಲ್ಲ ಇದು ಮಾಡಿಲ್ಲ ಸಾಲ್ವ್ ಬಟ್ ಕ್ಯಾಶ್ ಸರ್ಟಿಫಿಕೇಟ್ ನಮ್ಗೆ ಕೂಡ big annual income. It has to be the other day he has cash flow. The other day he has even Muslims income below it are category. ಅಂತ ಹೇಳಿದಾಗ ಸಡನ್ ಆಗಿ ನೀವೇನ್ ಹೇಳ್ತಿದ್ರಿ ಏನ್ರಿ ಪಾಸ್ ಹೋಗೋದ ಎಲ್ಲ ಇಲ್ಲಿ ಬ್ಯಾಗ್ ನಿಂತ್ಬಿಟ್ಟಿದೆ ಇಲ್ಲಿ. ಸರ್ ಏನ್ ಸರ್ ಅದು ಕೊಡಿ ಸರ್ ಇದ್ರೆ ನಾವು ಬರ್ಕೊಳ್ತೀವಿ.
ಜಡ್ಮೆಂಟ್ ತೆಗ್ಸಿದ್ದೀನಿ.
ಟಿವಿ ಅಂದ್ರೆ ಆ ಟೀಚರ್ ಜೀಪ್ ನೋಡಿ ಹೆಂಗಿದೆ. ಹಾ ಹಾ
ರಿಪ್ಲೈ ಮಾಡಬೇಕು.
ನಾನು ಒಂದೇ ಒಂದು ಪಾಯಿಂಟ್
ಹಾ, ಹೇಳಿ.
Lords, I went through the pleadings again in my petition. The only prayer made before the tribunal is to quash 1/2/2023 order.
1/2/2023
Order. Because we could not have questioned the earlier
Proposed
order
order or
15/6/2022 because it was statedly prospective. It was not affecting us. Therefore, I had no cause of action against that order. And the two principal contentions we have raised against this order is the reason given in this order. It is only ಕಲ್ಯಾಣ ಕರ್ನಾಟಕದ ಭಾಗದ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಹಾಗೂ ಜನಪ್ರತಿನಿಧಿಗಳಿಂದ ತೀವ್ರ ವಿರೋಧ ವ್ಯಕ್ತವಾದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸೊ ಅದರ ಈ ವಿಷಯವನ್ನು ಕಮಿಟಿ ಮುಂದೆ ಇಟ್ಟು ಅಂತ ಹೇಳಿದ್ರು. And we have taken a specific contention that this cannot be the ground to set aside to make it retrospective. Such a reason is impermissible in law. These are the only things, my lords, that we have said. Therefore, and we have said that order has to be tested on the grounds stated in the order, not beyond that. Tribunal has gone beyond this and say that 6/6/2020 order itself was illegal, therefore they have done the correct thing. That was not a ground made out in the impugned order, and tribunal could not have made it as a ground.
Because of Mohinder Singh Gill.
Because of Mohinder Singh Gill, and then what subsequently in like Lakshmi Metallics, and also there is one Mamta Mohanty also. No relief which is not based on the pleadings can be granted. Of course, my lords, all the questions my lords asked, they would arise someday or the other. And depending upon what my lords would say, my lords, I'll.
ಆಯ್ತು. Yes. ಅವ್ರು ರಾಜಗೋಪಾಲ್ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ಮೇಲೆ ಏನಾದ್ರು ಬಿಟ್ಟಿರ್ತಾರ ಬೇರೆ? He's a great poacher. Yes.
My lords,
Anything new? You can add.
Yes, my lords. There's only one difficulty, my lord. My learned senior, Mr. Madhusudan Naik, is unwell. We had briefed him in the matter. We can have a small. Madhusudan Naik, not well. He has got a very bad cold. My lords could give us Wednesday. If other petitioners could.
Mr. Fadke, ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡೋದು ಏನ್ರ ಇದೆಯಾ? ಹೇಳಿ.
I'm in 35.10, my lord.
35.10. Do you disagree on any point which Mr. Rajgopal has pointed out?
No, my lord, I am sailing with him, my lord. But there is another extra contention that I have taken, my lord. My lord, may kindly take annexure A1 at page 71 of my paper book, my lord.
Mr. Vikram Padke, broadly adopts submissions made by the senior advocate, Mr. Rajgopal, and adds that.
Please, ma'am. My lord, annexure A1 is the order of the governor, my lord. My lord, may kindly take clause 5, my lord, at page 73. May it please, my lord. My lord, the region for which a local cadre has been organized in respect of any category of post shall be a separate unit for purposes of recruitment, appointment, seniority, promotion, and transfer, and such other matters as may be specified by the state government in respect of that category of posts. My lord, the order makes it very clear that
recruitment, appointment,
seniority, promotion, and transfer, and such other matters. My lord, other than these, also the state government may add
but for that notification is necessary.
But insofar as recruitment, appointment, which we are now concerned, my lord, it has to be treated as a separate unit.
Correct.
Because the notification draws from this order, my lord. Because the notification is for both residual parent cadre and local cadre, my lord. My lord, when such a thing happens, my lord, both this local cadre and the residual parent cadre have to be treated differently. There cannot be merger of these things. If there is merger, my lord, what I am submitting is, if law requires it has to be done in a particular fashion, if it is not done so, then it is vitiated at the source itself, my lord, sir. My lord, I'm.
No, 1 second. This is on the premise that this paragraph 5
Please, my lord.
is local cadre specific or ex-local cadre specific, and it cannot be both.
Please, my lord.
How?
My lord, it is like this, my lord. When a local cadre is separated from the residual parent cadre, my lord, both of them, special provision has been made for the local cadre. There is a specific percentage of reservation for it. The rules governing those for the local cadre and the residual parent cadre are different. And if both of them are merged, what will happen? What we are now seeing is the result, my lord. What happens, my lord? The contention of the selected candidates who are in the provisional and the final list, initially not in the provisional list, then they came into the final list because of 1/2/2023, my lord, because even local cadre people were considered for the residual, and only after filling up the residual, their local cadre posts were sought to be filled. That is the mechanism adopted by the examination authority, my lord. My lord, that is an undisputed fact, my lord. My lord, what happens when the order itself says that both of them have to be treated differently? Then they cannot, by whatever means, go against the order, which is the parent legislation, albeit it is a delegated legislation from the president, my lord, because the notification draws its power from this order. And this, if this order says it has to be treated separately, then they cannot, in the guise of correcting a mistake or doing anything else by issuing a circular, they cannot merge these two cadres while recruitment. This is my foremost submission, my lord. My lord may also take the rules made thereunder from the order, my lord, which is at page number 82. If there was any discrepancy in the rule, and if the government had the power to clarify the confusion, only then there would have been a scope for some interference by the government. My lord may kindly take Annexure A2 at page 79. The relevant portion is at Rule 4, page
82.
number 82, my lord. May I read, my lord? The residual parent cadre and the local cadre carved out of it shall be treated as separate unit for the purpose of recruitment, appointment, seniority, promotion, and for operation of reservation. This is also important, my lord. 2 parallel roster cycles shall be operated for the residual parent cadre and local cadre. Separate, my lord. My lord, now my lord may kindly take 6/6/2020, my lord. Lord, 1 second.
With governor's order.
No, my lord. The order at Annexure A3, page 86, my lord.
order.
Please, my lord. 2020 order. Circular, my lord. This circular says, my lord, relevant page.
This is issued by whom?
By the government, my lord. It is a circular by the government. My lord, relevant portion at page 88, my lord. My lord, there are various types of recruitment, my lord. When in gazetted group A and B, minimum degree qualification is enough, and various posts are notified by the government, and a person has options to make his choice. First choice is as AC, Tahsildar, or commercial taxes, all these. But there are also places where specific for single posts are recruited, my lord, wherein specific qualifications are required. As in this case, my lord, assistant professors posts are being called for, my lord. Here, different subjects are there. One person qualifying for one subject cannot qualify for the other, my lord. With regard to that, it says, my lord, page number 88, third paragraph from the top after the note, my lord.
ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಸಮಯದಲ್ಲಿ
My lord, after that, my lord, those are for previous, for multiple option cases, my lord. The next one, my lord, ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ಎರಡೂ ವೃಂದಗಳಿಗೆ ಏಕಕಾಲಕ್ಕೆ ಒಂದೇ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಒಂದೇ ಇಲಾಖೆಯ ಒಂದೇ ಪದನಾಮದ, ದಟ್ ಈಸ್ ಸಿಂಗಲ್, ಬಹು ಆಯ್ಕೆಗೆ ಅವಕಾಶವಿಲ್ಲದ ಹುದ್ದೆಗಳನ್ನು ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳಬೇಕಾದ ಸಂದರ್ಭದಲ್ಲಿ ಮಾತ್ರ ಕೆಪಿಎಸ್ಸಿಯು ಸೇರಿದಂತೆ ಎಲ್ಲ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳು ಸ್ಥಳೀಯ ವ್ಯಕ್ತಿಗಳಿಗೆ ಈ ಕೆಳಗಂಡ ಆಯ್ಕೆಗಳನ್ನು ಒಂದೇ ಅರ್ಜಿ ನಮೂನೆಯಲ್ಲಿ ನಮೂದಿಸಿ ಒಂದೇ ಅರ್ಜಿಯನ್ನು ಆಹ್ವಾನಿಸತಕ್ಕದ್ದು. This is the entire bone of contention in this matter, my lord. ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಸ್ಥಳೀಯ ವೃಂದದ ಹುದ್ದೆಗಳಿಗೆ ಆಯ್ಕೆ ಬಯಸುವಿರಾ? ಹೌದು ಇಲ್ಲ. ಹೌದು ಎಂದಾದಲ್ಲಿ ಈ ಕೆಳಕಂಡ ಆಯ್ಕೆಗಳನ್ನು ಕಡ್ಡಾಯವಾಗಿ ಭರ್ತಿ ಮಾಡತಕ್ಕದ್ದು. ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಗಳಿಗೂ ಸಹ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಬಯಸುವಿರಾ? ಹೌದು ಇಲ್ಲ. ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಪ್ರದೇಶದ ಸ್ಥಳೀಯ ವ್ಯಕ್ತಿಗಳು ಸ್ಥಳೀಯ ಹಾಗೂ ಮಿಕ್ಕುಳಿದ ಎರಡೂ ವೃಂದದ ಹುದ್ದೆಗಳಿಗೂ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಅರ್ಹರಿರುತ್ತಾರೆ. My lord, this is the real question, my lord. When recruitment and selection appointment has to be treated separately, they could not have been given this option that in a single examination, you get one single marks and a choice is given that do you opt for this or not? If they may be asked that whether you opt for this or that, end of the matter. The further asking that even if you are opting for both, and if you get selected, then what you will opt? These are all redundant, and not just redundant, my lord, questions or options which are against the governor's order. My lord, may kindly take the next provision. ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಸಮಯದಲ್ಲಿ ನೀವು ನೀಡಿರುವ ಹುದ್ದೆಗಳ ಆದ್ಯತೆಯಂತೆ, ಆದ್ಯತೆ ಇಲ್ಲಿ ಬರೋದಿಲ್ಲ ಸ್ವಾಮಿ.
Yeah,
please, ma'am. My lord, because of these options, the confusions have been created, my lord. My lord, a question was raised that having participated in the selection process, I am not entitled to question the process. It has been stated that it is a settled law. But there are exceptions, my lord, wherein, my lord, may I pass on the judgment of the Honorable Supreme Court, my lord? Along with the compilation, I will submit, my lord. My lord,
party ಹೆಸರು ಹೇಳಿ, so that
please,
sometimes
I will, with the citation, I will
can
submit.
save your time.
Please, my lord. Dr. Major Meeta Sahai versus State of Bihar and others, 2019-20 Supreme Court cases 17, my lord. My lord, in this matter, my lord,
ಯಾವ paragraph?
paragraph 15 to 18, my lord. Please, my lord. My lord, may I read, my lord? Furthermore, it was a preliminary issue raised that a person having participated cannot question it. Furthermore, before beginning analysis of the legal issues involved, it is necessary to first address the preliminary issue. The maintainability of the very challenge by the appellant has been questioned on the ground that she, having partaken in the selection process, cannot later challenge it due to mere failure in selection.
Go to next paragraph.
Please, my lord. Please, my lord. My lord, 17, my lord. However, we must differentiate from this principle insofar as the candidate, by agreeing to participate in the selection process, only accepts the prescribed procedure and not the illegality in it. in a situation where a candidate alleges misconstruction of statutory rules and discriminating consequences arising therefrom, the same cannot be condoned merely because a candidate has partaken in it. The constitutional scheme is sacrosanct and its violation in any manner is
15,
impermissible.
17, 18.
Please, my lord.
They speak of almost same thing
Please.
in a different reflections.
Please, ma'am. I will not read further, my lord. My lord, here, my lord, misconstruction of the governor's order and the resultant consequences which are observed.
Please repeat.
My lord, misconstruction of the governor's order by saying that, yes, there is a separate cadre, but because of 6/6/2020, my lord, and all further circulars also, by saying that you may opt for this or that when only single notification is issued. It is not permissible. Even when single notification is issued, a question should have been given, only one option should have been given, that you choose this or that.
How you are affected by that?
Please, my lord.
Giving multiple option, how it affects you?
Please, my lord.
Is that at the most, the
Please.
second option could have been avoided.
Please, my lord.
It is not avoided, it is duplicated.
Please, my
How
lord.
that affects your case?
My lord, in my case, my lord, a person who belongs and who has participated in the selection process from the local region, that is Hyderabad, Karnataka region, he is also from my same category, category 1. He has whether I'm not sure whether he has opted for this or that or whatever, my lord. Initially in the merit list, he is at, my lord, he has been shown above me at Raju Hussain Saab, Imam Saab at page number 203, my lord, annexure A19, my lord. My lord, he has secured 137.25. My name is the next one, 51. It is 137. I am lesser to him by 0.25 marks, my lord. My lord, what happens is, he being from, and it is stated that he is from HK, that is Hyderabad, Karnataka. My lord, he has an option. There are posts for category 1, Hyderabad, Karnataka, rural and Kannada medium. He is there. He will get selection over there. And he having got there, he should not be placed in the final selection in non-Hyderabad, Karnataka region.
Yes.
My lord, for a moment, may kindly take page number 203, the last entry 50 in volume 2, if I may.
Yeah.
My lord, page number 203, my lord. The last entry, it is part of annexure A19. It is the final.
Hussain Saab.
Raja Hussain Saab, my lord. C1, category 1, HK, Hyderabad, Karnataka, rural Kannada medium. 51 is the petitioner. My lord, this merit list is drawn on the basis of the marks, my lord. There is no classification as to residual parent cadre or local cadre. This is a combined merit list. My lord, now my lord may kindly take
Yes.
page number 300, which is the final select list. part of the final select list, my lord, where my name also is
Page number?
sure. 300, my lord. A34, page number 300, my lord.
Yeah.
A34 starts at 299.
Final select list.
Please, my lord. My lord, this final select list pertains to residual parent cadre, NHK, non-Hyderabad, Karnataka. My lord, 43, the last name.
Your client?
Not my client, my lord. The respondent.
Raja Hussain sir.
Raja Hussain sir. My lord, if my name was in the final select list, my lord, I would not have.
Come at all.
Please, my lord. My lord, here also, this is pertaining to residual parent cadre, my lord. That is non-Hyderabad, Karnataka. He belongs to Hyderabad, Karnataka. He has applied under Hyderabad, Karnataka. Now he is sought to be included in non-Hyderabad, Karnataka
This
residual.
is because of the option given there.
Please, my lord.
You mean to say, even the options be there, but the list should have been bifurcated totally.
Please, my lord. My lord, once he gives that my name should be considered in Hyderabad, Karnataka, because it should be treated separately, his name cannot, in the final selection list, cannot figure in residual parent cadre. This is my humble submission, my lord.
Because he had applied on this side also.
He could not have because of the order, governor's order. He should not have been provided that option at all.
Paragraph 4.
Please, my lord.
Correct. Recruitment, appointment, promotion, etc. should be totally separate.
Please,
That's
ma'am.
what the clause
Yes.
5 says.
Yes, ma'am.
There is no doubt on that.
Please,
What I'm asking is, say Hyderabad, Karnataka, PWD is there. Let us take an example. Hyderabad, Karnataka, there are 100 posts.
Please.
And of the same department in non-Hyderabad, Karnataka, or the residual parent cadre, what you say. So that, let us say there are 75.
Please.
But the examination authority will ask for or receive the application online. Both.
Please.
It will receive. There, the candidate may opt for this as well as this.
Not as well as this.
Wait.
This
I-
or that.
But suppose if it is totally different, let us say,
Please.
is a person of Hyderabad, Karnataka barred from applying here?
No, my lord. He
No.
is not barred.
That is what I am saying.
Please, my lord.
Application may be same, but while considering it, depending on his choice, it should have been totally separate. There
Please.
are two
Separate
silos-
compartments, my lord.
Silos.
Yes, ma'am.
Hyderabad, Karnataka is different and residual parent care. That is what you are arguing.
That is, please, my lord. That is my humble submission.
Mutually exclusive.
Mutually exclusive. Mutually exclusive.
For a person, because he will take chance here or take a chance here.
Please, my lord.
If he is selected in this list, how can you bar it?
My lord,
Can't prohibit
please,
it.
please, my lord. My lord, my humble submission is this, my lord, that he has a choice either to opt for that or for this in a single, this one, my lord. If there were two, he could have done for both.
A person who doesn't come into the Hyderabad, Karnataka category, he cannot apply there. For that, there is a bar. See, if I am from the
Please.
non-Hyderabad, Karnataka area, I cannot go and apply.
Please.
Because I am disqualified applying there unless you are a domicile of
Please,
that.
please, my lord.
But a person of that area,
Please, my lord.
he is not
Barred from.
applying
Yes,
for this.
absolutely, my lord. But there is one another small, this one also, my lord. Even in the local cadres, for the rest of the state, some percentage is also given. That is also there. But that is not the question here, my lord.
In
Please.
that, one can
Yes,
apply.
but that is not the question here, my lord.
You mean to say that they are working two different or separate silos
Please, my lord.
and independently it has to be considered.
Please, my lord.
Though the particulars of the candidate are same for both.
It may be same, my lord. It may be same, my lord.
That-
But when a single, my lord, my lord, it is in hindsight, it may be very easy to say that they should have conducted two different examinations, allowed for both of them to all to participate wherever they are eligible, my lord. But when they have done this, we are post facto, my lord. how to purposely, how to reconcile this matter, the only option is, my lord, is to treat them as separate units as the order, the parent legislation requires. And any circular going beyond that or going against the very principles cannot hold water.
To say that a common list should not have been prepared.
Please.
Two different lists should have been prepared
Please.
because other criteria, the education
Please, ma'am.
qualifications, department,
Please,
etc., are one and the same.
Yes, my lord.
And the testing his abilities is also
Yes.
same. That criteria is also same, except that they are two different cadres.
Mutually exclusive, two different this one, and it is just a matter of clerical job, my lord. It is nothing more than that. Everything could have been sorted out only if they had adhered to the governor's order. My lord, why don't they do it? We get an indication that there has been pressure from the local representatives of that region, which is also spelled out in the further circulars also, my lord. But be that as it may, my lord, if the order or the law requires a thing to be done in a particular fashion, it should be done in that particular fashion. That is my humble submission, my lord. My lord, there is one another, this one. What consequences it will result in, my lord? My lord, here the question of vertical and horizontal reservations also crop in, because what, as I could gather from my learned senior counsel's submission on the basis of Rajesh Dharia or other matters, wherein it says that irrespective of your category, first fill it up in the general merit category. Thereafter, whatever remaining, it should go to the category, my lord. My lord, this is good only in respect of places wherein there are no different compartments for as this, my lord. It is only in cases wherein one single recruitment takes place for one type of selection process, my lord. Here, two different cadres are trying to be merged, and the argument being that because he is from Hyderabad, Karnataka, because he is more meritorious, even he might have chosen this or that, or even options are not given. Because of his merit, he has to be first placed in the residual cadre. And then this residual cadre is not a category or anything as specified under Article 16 of the Constitution of India to apply those parameters for this kind of a selection under 371J. My lord, there is one line in 371J I would humbly submit and rest my case, my lord, with regard. My lord, may kindly take 371J subclause 1C, my lord.
Clause
1C.
Equitable opportunity.
Please, the president may, by order made with respect to the state of Karnataka, provide for any special responsibility of the governor for, I'll skip A and B, my lord, equitable opportunities and facilities for the people belonging to the said region in matters of public employment, education and vocational training, subject to requirements of the state as a whole. The entire clause has to be read as a whole. My lord, two key words.
Requirement
equitable or
a whole.
Please, please, my lord. My lord, this is the reason that this cannot be treated as a general reservation principle, and general reservation principles cannot be applied here. This is a special provision, and special provisions, if the rules of the general reservation policies are incorporated here, the consequences are disastrous, as we are seeing here, my lord. My lord, it is equitable distribution opportunities, my lord, and subject to the requirements of the state as a whole.
Equitable andrenu?
My lord, there may be discrimination, which my lords are aware, my lord, how distinction.
ಅಲ್ಲ ಇಕ್ವಿಟೇಬಲ್ ಅನ್ನೋದು
ಯಾರಿಗೆಷ್ಟೋ ಅಷ್ಟು ಅನ್ನೋದಷ್ಟೇ. ಇಟ್ ಈಸ್ ನಾಟ್ ಈಕ್ವಲ್, ಇಟ್ ಈಸ್ ಈಕ್ವಿಟಬಲ್. ಯಾರಿಗೇನ್ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಇರುತ್ತಲ್ಲ ಅಷ್ಟನ್ನು ಭರ್ತಿ ಮಾಡಿ,
ಅವರವರ ಅಗತ್ಯದ ಮೇರೆಗೆ.
ಅಗತ್ಯದ ಮೇರೆ ಅಷ್ಟೇ. Lord, here my humble submission is the principles of general reservation cannot be applied here, and residual cadre.
They would not have said this.
Yes, my lord. This is my humble submission.
So
Please.
Clause 2.
Please, my lord.
Read.
An order made under subclause C of clause 1 may provide for.
Clause 1C you have read now.
Yes, my lord.
Read.
Please, my lord. Reservation of a portion of seats in educational, that I will skip, my lord. Next one, my lord. Identification of posts or classes of posts under the state government and in any body or organization under the control of the state government in the Hyderabad, Karnataka region, and reservation of a proportion of such posts for persons belonging to that region by birth or by domicile, and for appointment thereto by direct recruitment or by promotion or in any other manner as may be specified in the order. Lord, taking consideration of this, that as specified in the order, in the backdrop that 2B can be done, an order made under subclause C of clause 1 may provide for. Basically, my lord, the power is drawn from subclause 1C.
Clause 1C.
Clause 1C, man.
Yes.
Please. Lord, I reserve my right to reply after my seniors.
Yes.
If at all it is required, madam. Only on a point of law if there is confusion.
Permit me to address one of the fines.
ಒಂದು ಸ್ಮಾಲ್ ನೋಟ್ ಕೊಡಿ.
I will submit.
I appear, my lords, in 0.2 minutes, 35.2 minutes. Your lordships, my lords, have been taken through the order, government order, the governor's order, so on and so forth.
ಎರಡೇ.
Yes.
Government order, president order, so
Yes.
on so forth ಇಲ್ಲ.
Yes, my lords, through all the orders that have been issued, various orders. My lord, insofar as the present matter, my lords, I am appearing in 35.2, which relates to recruitment of teachers in government schools, my lords. My lord, it's
Teachers in government schools in Hyderabad, Karnataka.
no, my lord,
No.
throughout the
State.
state. The recruitment notification was issued for throughout the state. My lords, the reason why I'm bringing this to your lordship's notice is it stands on a slightly different footing from Mr. Padke's as well as Mr. Madhusudan Naik's case, my lords. My lords, insofar as teachers are concerned, the post is district-wise post, my lords. Each district my lords, a separate, my lords, application has to be filled for each of the district in respect of which, my lords, notification is issued. Now, my lords, the petitioners before the your lordships, my lords, took a calculated chance, made an application to the non-HK post falling within HK region. My lords, your lordships, my lords, have been taken through the reservation in HK. State is divided into HK and non-HK. Within HK, there is classification of HK and non-HK. 80% of posts are meant for HK, 20% of posts are meant for non-HK. Therefore, there is two division within HK. Similar, my lords, in non-HK, where 8% of posts is reserved within the headquarters for HK region, remaining 92% within non-HK is reserved for non-HK. The applicant, the petitioners, my lords, took a specific calculated chance and made an application to the non-HK posts falling within HK region.
HK reserve.
Yes, my lords.
Yes.
The rationale is that a person from Tumkur, my lords, the number of persons who compete in Tumkur would be higher as compared to the number of persons from Tumkur competing in Raichur. Therefore, my lords, in the non-HK post, let's say, my lords, in Raichur, I have a higher chance, my lords, of securing a government employment as against if I had applied in Tumkur, my lords. Because the then prevailing circular, when I made the application, prohibited, my lords, migration of candidates from HK to non-HK after the exams are written and the results are announced. Therefore, my lords, I took a calculated chance. Now, my lords, after the results are announced, by virtue of the impugned circular, those persons who had specifically said that I don't want to compete against non-HK candidates are forced to migrate to the non-HK category. Because of which, my lords, these petitioners have lost out of their chance to secure employment.
Whether loss of chance is a cause of action.
My lords, loss of chance, my lords, insofar as promotion, my lords, might not be a criteria. But here, my lords, what it changes is the eligibility criteria itself. Now, my lords, was I made aware of this? I would not have even applied, my lords.
There at all.
Yes, ma'am. I would have, my lords. Therefore, my lords, I have filed a memo.
So you could have chosen a district where you would have had more chances of
yes,
getting.
Yes, my lords, as per the, if the marks that I have secured, my lords, is the criteria. The first petitioner had a chance of securing employment in 18 of the districts. The second one, 11, the third one, 13 of the districts. I'm eligible, I'm qualified. Now, my lords, because of this circular, I'm debarred. I had made an application to the non-HK post in HK. I don't have an option, my lords, to make a migration to the non-HK in the other area. and I have lost out on the employment. My lords, this was the cause. My lords, the second thing, my lords, that would derive out of the action is the policy itself, my lord, whether migration is correct, so on and so forth. The other point of view would be whether application of that policy to the current existing ongoing recruitment, my lords, is correct or not, my lords. My lords, insofar as the impugned circular that we challenged, what it simply did was made applicable the policy in the earlier circular to the ongoing recruitment process by which we were affected. So in effect, the impugned circular, my lords, took into consideration the past events for its prospective operation of the circular. The applications that were made earlier.
So which is permissible?
Which is impermissible.
But there are judgments.
Yes, it is permissible provided the parent statute or the legislation gives the government the competence to make it retroactive or retrospective. Even if it is not retrospective in nature, it is definitely retroactive.
You can take cognizance of things that have already happened.
Yes,
based
that
upon
my
that,
application.
it can structure a particular stage.
Yes, that is my first submission. The impugned circular, which is retroactive in nature, could not have been made unless that the competence was available in the parent legislation. The second submission, your lordships, of course, your lordships pointed out.
In your view, parent statute is the president's order.
Please.
Let's give immediately one decision which differentiates between retroactivity and retrospectivity.
Very well. I have quoted the judgment, in BSNL. Would your lordship straight away come to internal page 27? I have
27.
Yes. That's para 30. Para 30 minutes. The power
to make retrospective.
Yes. The power to make retrospective legislation enables the legislature to obliterate an amending act completely and restore the law as it existed before the amending. But at the same time, administrative, executive orders or circular, as the case may be, in the absence of any legislative competence, cannot be made applicable with retrospective effect. Only law could be made retrospectively if it was expressly provided by the legislature in the statute. Keeping in mind the aforesaid principles of law on the object, we are of the view that the applicability of the circular dated so and so to be effect retrospectively from 1st April is revising the infrastructure is not legally sustainable, and to this extent, we are in agreement with the view expressed by the tribunal under the impugned judgment.
This is on retrospectivity.
Yes, ma'am. Of a circular.
Circular.
Yes.
You said something about retroactivity.
Yes, ma'am.
What is that?
Let's retroactivity, my lords, as learned senior counsel point, Mithilesh, my lords, where they said it.
Mithilesh Kumari. It is overruled in Rajagopal Reddy.
What was not recognized for the dynamic transaction side. But even if a transaction of the kind was prohibited in the dynamic transaction side, if the litigation were to be filed once after the act comes into force, even then the transaction which would have taken place at some point of time could prohibit the litigation from being enforced. Therefore, in Rajagopal Reddy's case, they said it is not the retrospectivity, it is retroactive. It is retroactive, not retrospective.
Let's
in Mithilesh Kumari versus Prem Bihari Khare, 89 Supreme Court. Justice Majumdar's judgment. Majumdar's judgment. That spoke of retrospectivity. Rajgopal Reddy versus Padmini speaks of retroactivity.
They said that all the transactions did not get invalidated, but a claim when it is made on the basis of those transactions which came into the prohibited parameters, it affected even those transactions as prohibiting litigation from being dismissed.
That is retroactivity.
I make a small compilation of retroactivity and then give it to you.
That's the latest judgment would be SEBI versus Rajkumar Nagpal in 2022. Yes, Rajkumar Nagpal. Retrospective, in that they distinguished by saying retrospective means you change the effects from an anterior date, whereas in retroactive you take into
upon the
past considerations for future implementation. That was the difference, my lords, that was brought about in Raj. Here, my lords, they take into consideration the applications made earlier for prospective implementation of the impugned circular, which, my lords, is retroactive in my respectful submission, and it could not have been made. Let's the second submission, my lords, you, of course, your lordships, my lords, observed it might be suicidal, but the power, my lords, to our case that my lords,
you suicidal, you should be very specific.
My lords,
as to who.
Yes, the only reason, my lord, was that the impugned circular, the decision to make it, my lords, with earlier anterior effect is taken by the cabinet subcommittee. The cabinet subcommittee, my lords, was not vested with that power. In my writ petition, volume 2, the very last page, I have
taken up that content.
My lords, I have produced the document forming the cabinet subcommittee and the powers it was vested.
It has no power.
It has no power. May I just read it out, my lord, for your lordship's convenience.
What was their role in this?
My lords, the cabinet subcommittee at best could only, my lords, oversee the implementation of the 371J orders.
They should be made by the governor himself.
Yes, my lords. It did not have the power, my lords, to take a decision and then, my lords, make a circular.
That power is not given to
cabinet subcommittee.
No power is given to the government. It appears to be your broad proposition.
Yes.
Not government, but governor.
Governor.
In the scheme of 371J,
yes,
no role assigned to the government at all.
Yes, my lords. It uses the word governor.
Governor.
Yes.
In other words, in a way, 371J gives scope for central governance in the state province. It may be, we do not know. Just to test your idea.
The central government,
it will be central rule
within. The governor, was given the power to implement, under the constitution. the central government, my lords, did not entrust it, my lords, to the constitution rather did not entrust it to the government to take a policy decision without, my lords, the approval of the governor. I'll put it, my lords, in that fashion.
Or you can say, not central government,
Yes,
the governor
constitution
himself will
himself.
rule it
Yes, ma'am.
that way.
Yes,
Three situations.
yes,
We have a popular government at the provincial level
yes,
because of federal system. But government can be excluded by orders issued by the president under 371J, A to J.
yes,
And governor himself will do that.
yes,
He is not bound by what the central government will
Yes.
say, will not say.
absolutely.
He does it in his discretion.
Yes,
Even there, the provincial government is excluded
yes,
that way.
yes,
The very purpose is that.
yes. Let's, and my third submission, my lords, is insofar as circular itself is concerned, my lord, whether circular can become the law governing a recruitment. Under Article 13, the recruitment, my lords, is governed only by, my lords, the rules, regulations, and bylaws, or any statute made, my lords, in exercise of powers under the parent legislations. My lords. The circular,
We can say, it all depends upon author of the circular,
yes, my lords.
purpose of the circular, scope of the circular.
Yes, my lords.
Author, purpose, scope. If circular is only to supplement,
Yes,
it is permissible, provided author of the circular has power to
yes,
issue one.
yes. I have just placed one judgment for your lordship's consideration, my lord, in that regard. That is the first judgment, my lord. May I just read the relevant paragraph, my lord? My lords, that is the Punjab Water Supply Board, my lord. Internal page number 18. Internal page 18, para 19.
19, in the instant case.
Yes, my lord. In the instant case, the High Court did not issue a writ of mandamus on arriving at a finding that the respondents had a legal right in relation to their claim for regularization, which it was obligated to do. It proceeded to issue direction.
There it has power.
Yes.
Because they traced it to 162.
Yes, then it failed to notice that a policy decision cannot be adopted by means of a circular, and as noticed herein before, even a policy decision adopted in terms of Article 162 of Constitution of India in that behalf would be void. Any departmental letter or executive instruction cannot prevail over statutory rule and constitutional. Like my lord, Mr. Patke pointed out, these two cadres are entirely different. Now, to allow migration contrary to the orders, my lords, and the statutory rules by way of a circular, my lords, would be impermissible.
Yes.
Just one other judgment, my lords. It pertained to reservation, and the policy of reservation changed during the process of recruitment, my lords. Then, my lords, question arose whether it changes the eligibility criteria, whether a reservation policy which was changed during the process of recruitment could be implemented for an ongoing recruitment process, my lords.
What court said?
The Supreme Court would say that the reservation policy as on the date of commencement of.
So subsequently you cannot.
Yes. May I just draw your lordships to that minute? Of course, it was in the case of vertical reservation, but I can only draw parallel to
Parallel.
this. Yes. I'm not saying, my lord, this is vertical reservation, but page 54 of that compilation.
54.
54. After, my lord, para 47, plus it. Yes, my lord. After that. The circular of the government shall be treated to be in force for the purpose of reservation, which is in force at the time of recruitment. Recruitment commenced by...
They have said it.
Yes.
Cannot.
There, my lord, there was change in reservation as well as age relaxation. My last submission is this, only on the effects of the implementation. The objective of 371J was for upliftment of a region which was defined to be socially and economically backward. Now, by virtue of the impugned circular, those candidates who are bright and who wanted to stay within that region are forced to migrate from that region, my lords, and come to non-HK. What is left for the HK region is only those candidates who are not as meritorious as the rest of them to remain there and to work there. Now, let's please consider a situation. A topmost candidate who secured 99 out of 100. By virtue of the impugned policy, the state government says, no, you cannot stay there. You have to come to non-HK. You serve Bangalore only. You serve Mysore. You can't serve Raichur. Now, a candidate, my lords, while making his application, though says, I want to stay within HK.
He cannot.
He cannot. He is forced to migrate to non-HK.
So it's a forced draining.
Yes, ma'am. And which would, my lords, not subserve the purpose of 371J. It would rather defeat those meritorious candidates, my lords, who want to stay back and develop that region are not permitted to do so, and they are migrated, which is not ultimately the objective of 371J.
So that defeats in a way the object itself.
Yes.
So it will be a case of compulsive brain drain.
Please.
Because he has no option.
He has no option.
So you mean to say only intelligent people alone will be in a position to contribute? Those who are not academically excellent,
No, my lords.
they are useless that way.
No, my lords. My respectful submission is not that. My lord, the candidates are tested.
DVG. Have you heard of DVG?
Yes, ma'am. Of course.
Brahmapuriya Bhakshuka.
Yes.
He had failed in SSLC.
Yes.
Karanta, he had failed in Inter.
Please, ma'am.
But
yes. But, my lords, the objective of the written examination and the selection criteria is to filter out, my lords, the most meritorious candidates.
that's right.
Therefore,
But,
my lords, in terms of the merit in the written examination is all that my submission. I'm not saying.
Esto sari.
Yes.
ಈ ಮೆರಿಟೋರಿಯಸ್ ಕ್ಯಾಂಡಿಡೇಟ್ ನಿಂದನ ಸಮಸ್ಯೆ ಆಗ್ಬಿಡ್ತದೆ ಅನ್ನೋ ಫೀಲ್ ಇದೆ ನಮಗೆ ರಿಯಲಿ.
I take you from that and close my submission.
Less meritorious become more productive.
Absolutely.
Anand Bhaira Reddy ಸಾಹೇಬ್ರು R.N. Bhaira Reddy sir.
Yes.
Not very, in fact, very academically not brilliant, nothing. but when he was appointed as Advocate General, he bought best constitutions of the world and studied for 1 year. He could argue Keswananda. It is only the argument of 4 persons that has been reported by Surendra Malik in the case that shook India. The Nirende, Palkiwala, Sirvai, L.N. Singhvi, father of M. Singhvi, and R.N. Baira Reddy. No other person is referred to. Huh? Correct. In case one.
That's true.
You can't say merely because only academically very excellent iroru matra avrinda ಹೆಚ್ಚು ಉಪಯೋಗ ಆಗ್ತದ ಅವರಿಂದನೂ ಆಗ್ತದೆ. We don't say for a moment.
Yes.
So many Thomas Alva Edison. He was expelled from the school by a letter. Completely useless fellow. He cannot, not only he cannot improve, he will spoil other students here. And mother took him. He asked, what mother, what he has written? They say this school is not fit for you. You are a very special category person. This, therefore, only academic ಅಥವಾ ಎಲ್ಲ academical ಮಾಡೋದ್ರಿಂದ
teachers, my lord, they are ultimately, and they were assessed on the.
Of course, you should have good teachers. That's another thing. Merit is not the only mantra.
That's very true.
Academic merit is not the only mantra.
Please, but my only submission was, if the earlier erstwhile regime where they were given an option, then they had the option, my lords, to either come here, my lords, or to, my lords, remain within their respective regions. But now, my lords, to force them, my lords, against, my lords, what they had preferable, what they had preferred, that would not be against, would be against the very foundation. That's my thought. I have tabulated.
But very beautifully and effectively you argued.
I'm so grateful. Great.
Very articulate, yes.
I made a chart of my submission.
Yes,
I just handed.
Yes,
one
Mr.
page.
Patil.
Request.
ಹೇಳಿದ್ದನ್ನು ಬರೆದಿರ್ಲಿಕ್ಕಿಲ್ಲ. ಈಗ ಹೇಳಿದ್ದು ರೋಸಿ ಇತ್ತು, ವೆರಿ ಅಟ್ರಾಕ್ಟಿವ್ ಇತ್ತು. ಆ ರೀತಿ ಅದನ್ನೇ ಕೊಡಿ, ಬಂದು ಕೊಟ್ಬಿಡು. ವೆರಿ ಎಸ್ ಮಿಸ್ಟರ್ ಪಾಟೀಲ್.
There were some cases in Kalburgi bench pertaining to the some of the respondents here made an impleading application and said the matter is being heard in the principal bench and therefore to defer.
ಕಲಬುರ್ಗಿ ಅವರು ಮಾಡಿರೋಗಿದ್ರೆ we will defer.
ಅಲ್ಲ ಅದಕ್ಕೆ then the court deferred the matter as I was appearing in that case. Of course, those cases I'm not asking for transferring, but allow me to make.
We said, not even humorously, if they are doing, most welcome.
ಅಲ್ಲ ಇಲ್ಲಿ ಶುರುವಾಗಿ ನಡೆದ ಆಗಿದೆ ಅಂತ ಅಂದಿದ್ದಕ್ಕಾಗಿ they deferred the matter hearing. Therefore, ಅದರಲ್ಲಿ ಉಳಿದಿದ್ದೆಲ್ಲವನ್ನು ಇಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ನಾನು ಒಂದು ಪ್ರಾಕ್ಟಿಕಲ್ ಡಿಫಿಕಲ್ಟಿ ದಟ್ ಹ್ಯಾಸ್ ಅರೈಸನ್, ಐ ವಿಲ್ ಜಸ್ಟ್ ಪಾಯಿಂಟ್ ಔಟ್. I request, ನಿಮ್ ನಂಬರ್ ಕೊಡಿ, ನಿಮ್ ಕೇಸ್. For the purpose of reference, would your lordships have 23450 of 23, Miller?
What?
Where my learned friend, senior friend, Rajgopal argued the matter.
Yes, sir.
Please, Miller. In that, your lordship may kindly go to page.
Manjunath Bharadwaj.
Yes, Miller. Kindly go to page 220.
220.
Actually, it is annexure A6, starts at page 219.
Online ಅರ್ಜಿ ಹಂತಗಳು.
ಹೌದು, ಅದರಲ್ಲಿ kindly go to 221, condition number 11.
ಒಂದಕ್ಕಿಂತ
ಒಂದಕ್ಕಿಂತ ಹೆಚ್ಚು ಜಿಲ್ಲೆಗಳಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಬಯಸುವ ಅಭ್ಯರ್ಥಿಗಳು ಪ್ರತ್ಯೇಕ ಅರ್ಜಿ ಸಲ್ಲಿಸಬೇಕು. ಆದರೆ ಒಂದೇ ಜಿಲ್ಲೆಯಲ್ಲಿ ಒಂದಕ್ಕಿಂತ ಹೆಚ್ಚು ಹುದ್ದೆಗಳಿಗೆ ಆಯ್ಕೆ ಬಯಸಿದಲ್ಲಿ ಪ್ರತ್ಯೇಕ ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಹುದ್ದೆಗಳ ಆದ್ಯತೆಯನ್ನು ನಮೂದಿಸಬೇಕು. ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್. ಅಭ್ಯರ್ಥಿಗಳು ಪರೀಕ್ಷೆಗೆ ಹಾಜರಾದ ಜಿಲ್ಲೆಯನ್ನು ಮಾತ್ರ ನೇಮಕಾತಿಗೆ teachers apply. We can apply in any number of districts, but ultimately our appointment, consideration for appointment, selection, etc. will be confined to the district where we take the examination.
Where you take the examination?
Yes.
How that is relevant?
That is how it has been made. How it affects us, your lordship may kindly see now. ಅಭ್ಯರ್ಥಿಗಳು ಪರೀಕ್ಷೆಗೆ ಹಾಜರಾದ ಜಿಲ್ಲೆಯನ್ನು ಮಾತ್ರ ನೇಮಕಾತಿಗೆ ಪರಿಗಣಿಸಲಾಗುವುದು. It's an appointment district wise. Though the exam is a common exam at district level all over the state, appointments are at the district level and appointment is confined to the place where we take the examination. As my learned friend pointed out earlier.
ಇದು ಆನ್ಲೈನ್ ಎಕ್ಸಾಮಿನೇಷನ್
ಅಲ್ಲ,
ರಿಟರ್ನ್ ಟೆಸ್ಟ್.
ರಿಟರ್ನ್ ಟೆಸ್ಟ್.
ಯಾವ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅನ್ನು ಚೂಸ್ ಮಾಡ್ತೀರಿ ಅನ್ನೋದ್ರ ಮೇಲೆ that will decide where you will get appointed. This is something.
Your lordship may kindly see.
Option ಇದೆ ನಿಮಗೆ. Whichever district you can write, you can write from.
Yes, we can apply in any number of district.
But where you write,
where you
decide
write
your
the
place of
examination, ultimately you are confined to that district.
Here you write, do you have an option?
Yes, yes.
ಇದೆ.
Naniga, in our cases, I am from Tumkur. I took examination in Raichur. So my selection, my appointment, everything will be considered only with reference to Raichur district. Raichur district.
ಏನ್ rational?
Rational ಹೇಳ್ತೇನೆ. Your lordship may kindly see page 133. ಸುತ್ತೋಲೆ. ಅದರಲ್ಲಿ this pertains to all the candidates, particularly the conditions with reference to candidates opting for 371J vacancy. Page 135 ನೋಟ್ ಅಂತ ಇದೆ. ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಸಮಯದಲ್ಲಿ ನೀವು ನೀಡಿರುವ ಹುದ್ದೆಗಳು ಎಟ್ಸೆಟ್ರಾ. ನೋಟ್. ಒಂದು ವೇಳೆ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಯು ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಯನ್ನು ಆಯ್ಕೆ ಮಾಡಿಕೊಂಡು ನೇಮಕಾತಿ ಹೊಂದಿದಲ್ಲಿ ಅಂತಹ ಅಭ್ಯರ್ಥಿಗೆ ಜಾರಿಯಲ್ಲಿರುವ ನಿಯಮದಂತೆ ತನ್ನ ಸೇವಾ ಅವಧಿಯಲ್ಲಿ ಅನುಚ್ಛೇದ 371J ಮೀಸಲಾತಿ ಸೌಲಭ್ಯವು ದೊರೆಯುವುದಿಲ್ಲ ಎಂಬುದನ್ನು ಸ್ಪಷ್ಟೀಕರಿಸಲಾಗಿದೆ. ಎ ಕ್ಯಾಂಡಿಡೇಟ್ ಅಪ್ಲೈಯಿಂಗ್, please take Hyderabad, Karnataka area itself, Raichur district or Gulbarga district. There, 80% of the seats are for 371J, 20% are for remaining. If a candidate 1J, if he is to get selected or opt for a post in the remaining, call it as general seats, 20% seats, condition is, yes, you can opt, but during your career, you will not get the benefit of 371J.
No reservation benefit.
No reservation benefit. He becomes a general candidate like anybody else. This is the condition for those coming under, those eligible for 371J, whereas the condition for others corresponding, I would put it as corresponding, it is limited that if you take examination in a particular district,
They
you are only your appointment will be considered. Hyderabad, Karnataka area, particularly Tumkur, Mysore and Shimoga. They applied for %20 seats, several districts, but some of them confined itself to Raichur district, took the examination in Raichur district. Their candidature would be considered only for 20% seat. In spite of it, they applied there because 80% seat, 371J candidates in the normal course will not opt for general seat because they will not get the reservation for their entire career. Therefore, we took the examination in Raichur. In Raichur, examination was held, provisional list was announced. Some of the candidates are selected and they are all for 20% seats and they are all within 1 to 10 in respect of the 20% seats. After this provisional selection list announcement came these circulars. First circular 15/6/22, that is 262.
ಇದೆಲ್ಲ ಇಶ್ಯೂ ಮಾಡಿದ್ಯಾರು?
This is by
ಗವರ್ಮೆಂಟ್.
Cabinet's subcommittee recommendation.
ಗವರ್ಮೆಂಟ್ ಮಾಡಿ.
Government, Adhina Karyadarshi, DPR. In that, your lordship may kindly see 262. It's the circular dated 15/6/22. They modify that condition of reservation that they cannot opt, etc. They modify it. But say in the last paragraph, ಈಗಾಗಲೇ ಗೆಜೆಟೆಡ್ ಪ್ರೊಬೇಷನರ್ಸ್ ಹುದ್ದೆಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಒಂದೇ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಜಾರಿಯಲ್ಲಿರುವ ಪ್ರಕರಣಗಳಿಗೆ ಲೈಕ್ ಅವರ್ಸ್, ದಟ್ ಇಸ್ ಟೀಚರ್ಸ್, ಸೀಮಿತವಾಗುವಂತೆ ಮಾತ್ರ ದಿನಾಂಕ 6/6/20 ಸುತ್ತೋಲೆಯಲ್ಲಿ ನೀಡಲಾಗಿರುವ ನಿರ್ದೇಶನಗಳನ್ವಯ ಆಯ್ಕೆ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಅಂತಿಮಗೊಳಿಸುವಂತೆ ಸೂಚಿಸಲಾಗಿದೆ. When they issued 15/6/22, they said, don't affect the examination and the selection process, which is already underway. And for other, then your lordship may kindly see page
application is excluded.
Yes. This change for not get the reservation.
That will not apply to these people who are already in the halfway through.
Yes,
process.
it is, modification is made, but it will not apply to non-gazetted posts for which all done. It will not apply. Then your lordship may kindly see 286.
One to 23.
1 to 23. Kindly turn to page 28.
ದಿನಾಂಕ
ದಿನಾಂಕ 15/6/22 ಸುತ್ತೋಲೆಯ ಕೊನೆಯ ಖಂಡಿಕೆಯಲ್ಲಿ ತಿಳಿಸಲಾಗಿರುವ ಅಂಶಗಳಿಗೆ ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ ಭಾಗದ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಹಾಗೂ ಜನಪ್ರತಿನಿಧಿಗಳಿಂದ ತೀವ್ರ ವಿರೋಧ ವ್ಯಕ್ತವಾದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ವಿಷಯವನ್ನು ದಿನಾಂಕ 29/12/22 ನಡೆದ ಸಚಿವ ಸಂಪುಟ ಉಪಸಮಿತಿ ಸಭೆಯಲ್ಲಿ ಮಂಡಿಸಿ ಸಮಿತಿಯ ನಿರ್ಣಯದಂತೆ 15/6/22 ಸುತ್ತೋಲೆಯ ಕೊನೆಯ ಖಂಡಿಕೆಯಲ್ಲಿ ತಿಳಿಸಲಾಗಿರುವ ಅಂಶಗಳನ್ನು ಮಾತ್ರ ಹಿಂಪಡೆಯಲಾಗಿದೆ. ಏನ್ ಎಕ್ಸಂಪ್ಷನ್ ಏನ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ, that exemption is withdrawn. Therefore, making that 15/6/22 circular fully effective for our selection also.
Because it's because of this.
Because of this. this second, this thing.
ಜನಪ್ರತಿನಿಧಿಗಳಿಂದ ಅಂದ್ರೆ ಚುನಾಯಿತನೋ ಅಚುನಾಯಿತನೋ?
ಇಲ್ಲ ಚುನಾಯಿತ
ಆಯ್ತು.
ಅವ್ರನ್ನೂ ಕೇಳಿದ್ದಾರೆ, ಉಳಿದವ್ರನ್ನೂ ಕೇಳಿದ್ದಾರೆ. ಪ್ರೊಬೆಬ್ಲಿ ಇವರು ರೆಫರ್ ಮಾಡೋದು MLA ಅವ್ರನ್ನ ರೆಫರ್ ಮಾಡ್ತಾರೆ. I am not going into merit of that decision that 371J reservation should be open. They should have
Vertical,
free this thing for migration. All those things, I am not going into that. I am in respect of candidates who are of several other districts, applied and took examination in Hyderabad, Karnataka area, particularly Raichur district. I was in the provisional list. I am selected within 1 to 10 for the post. After this circular, when the list was made, I am out because 371J candidates were free to this thing, either compulsorily or by option. I was out of that Raichur district because number of posts available are only 20%. I have given a chart in that case that in the normal course, if I am to be considered anywhere in my native district, Tumkur, or any other district, in 29 districts, I would have been selected in the non-371J posts, selected and appointed. This I am saying, whether this circular on merits right, with power, other aspects are already argued, therefore I'm not going into that. Even for a moment assuming it is with power, even
Still
if
you
it is
cannot
with
maintain
power,
it. Still you cannot maintain it.
it is arbitrary. The second condition in Tej Prakash case says, even if it is with power, it will have to pass the test of Article 40.
No, quite natural.
Therefore,
Invoking Article 14 arises where you have power to do certain thing. If you do not have power, you will not travel to 14 at all.
That's why I
no
said,
power, therefore gone.
Even if for a moment assuming it is
They
with
have power.
They had the power. Para 42. 2. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules so permit or the advertisement which is not contrary to the extant rules so permit. Even if such change is permissible under the extant rules or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. All that we are saying is, whatever you wanted to do for, according to them, the true interpretation of Article 371J, full impact of reservation to be given, if that were to be given, correspondingly, it was necessary for them to have considered what would be effect in that. The effect is, by publishing a notification, you have made me to apply it for a particular district and take examination, get selected. Thereafter, I am being thrown out for no fault on my part.
And though you would have been hopefully selected and appointed if you were to be sponsored from any other
district. 29 districts I would have been selected and appointed.
Yes.
The impugned circular of 1/2/23 changes the eligibility criteria itself. Maybe they may say it is only option is given or migration is permitted, etc. But with reference to the notification, it changes the eligibility criteria itself. Therefore, I would respectfully submit the notification of 1/2/23, even if it is held that it is with competence, will have to be struck down as being arbitrary.
Foul of 14.
Yes, foul of Article 14.
Okay.
Please,
Small ಒಂದು note ಕೊಡಿ.
ನಾನು ಇದ್ ಮಾಡ್ಕೊಡ್ತೇನೆ. ಅಲ್ಲಿ ಒಂದು ಚಾರ್ಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ವಿ ಮಾರ್ಕ್ಸ್ ಇಂದು, ಅದನ್ನೇ ಇಲ್ಲಿ ಇದನ್ನ ಮಾಡಿಕೊಡ್ತೇನೆ. In the later vein, your lordship said merit might sometimes create obstacle. That is what we find in this court.
There's a little different way, my lords, with which I was reading it. The scheme of reservation which is introduced under 371J is contemplating providing of a reservation for the territorial backwardness, not to provide for a reservation in the backward territories. This is never the concept. The territorial backwardness is the criteria for the purpose of enabling the persons from that region to get reservations. But the reservations were never intended to be restricted to the regions. Kindly have a look at 371J, my lords.
Please repeat.
What is the criteria? Yes.
They are person specific. They are communal in nature.
Lords, the criteria for extending the benefit of reservation is a territory, the backwardness of a territory. Which is defined. There is no difficulty about which is the territory with which we are
not
referring to.
community or something like that.
No, it is, Lord, this is one of the unique reservations which has been given, where a recognition is given for the persons of a territorial origin and who continues to stay there to qualify themselves for a reservation to be applied with the principles of reservation. That is a special treatment. 371J, your lords, is my kindly see, my lords. Yes. Lords, my apologies, my lord, because reading this repeatedly, 371J, special provision.
There is no justificator for reading. You can go on reading and reading.
Not special provisions with respect to state of Karnataka. The president may by order made with respect to the state of Karnataka provide for any special responsibility of the governor for establishment of a separate development board for Hyderabad Karnataka region with provisions that a report on the working of the board will be placed each year before the state assembly. Equitable allocation of funds for development of expenditure over the said region subject to the requirements of the state as a whole. Milords, I'll just pause here, Milords. These A and B is the region specific.
Correct.
Establish separate region for Hyderabad Karnataka region. It will be placed. Equitable allocation funds for development and expenditure over the said region. Now next, equitable opportunities and facilities for the people belonging to the said region. This is the criteria. In matters of public employment, education, vocational training, subject to requirements of the state as a whole. This is the phrase, Milords, which determines as to what is the kind of reservation which they intend to Milords, implement under 371J. Milords, now there are two principles, Milords. State of Balaji versus state of Mysore says
Balaji versus
state of Mysore, under no circumstance in whatever may you clothe it as, you can never exceed 50. We are already in 50. That, of course, the state will now indicate, Milords, how they will do it. There is not even a possibility that you can indirectly exceed, even by creating a local cadre, that the reservation exceeds 50%. You have to keep it within 50%. So now what was the object with which 371J, Milords, was implemented was whether it provided for creation of a distinct cadre by itself within the existing cadre. That means if the cadre strength, my lords, in the region, let us say is 100, they wanted to create 80 posts as the local cadre. Now, if this 80 posts is created as a local cadre, then only the persons of the origin of that region, people belonging to the said region, they become eligible. If this is the understanding, then it creates a vertical reservation or an exclusive posting, my lords, only to those posts where there is no competition, it is not an open post. If it is to be understood that spread across the state, if there are X number of posts and the reservation requires to be given for the people of that origin, notwithstanding the region, then it should have been implied for the entire state as a whole. My lords, as Mr. Prithvish said, as I can understand, my lords, the constitutional objective was not to restrict the Hyderabad Karnataka candidates to Hyderabad Karnataka. That was never the object. My lords, ultimately the reservation is, my lords, as I can understand, my lords, reservation, yes. My lords, it
is not to disable.
No, this government order is virtually in the nature of disabling what is actually sought to be enabled under the scheme of the constitution. My lords, reservation is something like there is a stream going upstream. So we need to push these people up and ensure that they join the mainstream. So these are all the people who are backward. So push them up the stream. They should come along with the general stream, and that is how, my lords, the object of reservation gets fulfilled. So this is essentially the scheme of reservation. But now what happens is this twofold. The manner in which it can be understood is twofold, my lords. If this is distinctly referred to as a cadre, what is the legal effect of it? Number of posts, which is 80% of the posts in a given cadre, if it exceeds 50%, then how is it that the state would justify, my lords, that this is going to be a vertical reservation or a reservation by itself?
Because the rule of 50% applies to this kind of reservation.
My lords, now that's the reason why I said, my lords, there are two ways.
What kind of order you want to create?
My lords, two ways of looking at it, my lords. The moment we are permitting, my lords, how the state managed with this horizontal reservation of the women's reservation was, they said that this is going to be a horizontal reservation. My lords, how the vertical reservation and the horizontal reservation works, my lords, if I were to just give an example, my lords. If let us assume that SC, ST and OBC is 50 seats, 50 out of 100 vacancies. 50 is the open competition vacancies. Now, once the recruitment starts, then they will have to start making all the persons in the list of merits into 50. That is open competition posts. First, it will be filled up. Now, what they will do even in the open competition, I'll next come to the horizontal. What happens in a scenario of horizontal reservation? Once 50 is filled up, then the inter-se merit, my lords, in the remaining candidates in SC, ST and OBC will be drawn up, and they will be filled up, my lords, in the respective categories. It may be that the 30 seats, let us assume 30% or 30 of the open competition posts are filled up by those persons who would have opted to get the reservations under SC, ST and OBC. But
because
they
of
get
merit.
on the merit, but they enter into the general merit because of their merit. Now, so far as the remaining candidates is concerned, they will get into these cadres. So that means vertical reservation contemplates a situation where the person seeking reservations in merit will get into the merit. Whatever is the residual people who are participating, my lords, in that particular category, they will get filled up in the vertical lists. So ultimately it is filled up. But horizontal reservation, what happens? I will speak, my lords, as to how it works at the time of recruitment and post-recruitment. At the time of recruitment, what they would do in the same scenario, out of 50, they will stop the moment they have done 70% of the postings. Then they will see whether the 70%, that is about 35, includes women and how many women. Then if there are, let us assume that 6 women have got into it or 8 women have got into it, then only the remainder of women in that category gets filled up for the remaining of the 15, which is the horizontal reservation. Remaining again goes into open competition, which may again include women also. But that goes into open competition. This is how the filling takes place. Similar things happens even with the reserved categories. SC, ST and OBC, they will fill up to the 70%, and remaining first they will see whether the women are there in these categories. If the women are there, they are filled up. Let us assume not that in SC category, there are 10 posts. 4 women are already there out of 7. Then the question of giving horizontal reservation to the women does not arise. 3 again goes into the open competition amongst that category of SC, where only men may be selected. This is horizontal reservation. So horizontal reservation is dependent purely on the number of people present in that particular category. Vertical is ensuring that the total number of people are there in that category while pushing all those persons who are in the merit into the open competition category. Now, this is how it works. Now, in the present scenario, if the object with which the Constitution inserted, notes in the Constitution 371J was inserted, was to give recognition, or the, I will say, milords, that the point of consideration of reservation or the criteria for consideration of reservation is only the origin, but extension of the reservation is statewide. If this is the criteria, milords, with which it is to be considered, then that's the reason why I said whether the state wants to treat it as either a horizontal reservation or a vertical reservation. But in my respectful submission, milords, as I could understand, this has to be considered only as a horizontal reservation. Otherwise, it breaches the rule of 50%. Notice the Indira Sawhney's case has dealt specifically with the interplay of the horizontal and the vertical reservations. And of course, even the judgment in Rajendra Kumar Daria's case also dealt with the same thing.
They are all, in a sense, communal reservation.
That's
these are regional reservations.
Even if it is a regional reservation, the backwardness is a criteria for reservation. This is the exception, milords, provided under Article 15 and 16.
Backwardness of area.
Milords, the backwardness is the area wise backwardness. Now the question is whether you can restrict the persons coming from this area or the backward areas to be restricted for their service only in the backward areas. That can never be the object. That's the reason, milords, 371J very specifically stated, milords, equitable is something which I conspicuously find only with reference to horizontal reservations, not in vertical reservations. Kindly have a look at 371J. That word equitable, milords, somewhere rings bells in my ears that this is applicable only for what can be called
horizontal.
Horizontal. Equitable opportunities. The word user of the words equitable opportunities and facilities, milords, equitable opportunities for the people belonging to the said region in matters of public employment subject to the requirements of the state as a whole. Milords, facilities is reference to education and vocational training. There are 2 parts to this provision. Equitable opportunities in the matter of public employment, facilities for the education and the vocational training. 371J(C). 1C speaks about 2 parts. We are considering, milords, it's pertaining to only public employment. It's only the providing of equitable opportunities. And then your lordships may kindly see 2B.
No, of course, there is something in which you are saying. We are just thinking aloud.
Lordships.
If they wanted to exclude vertical reservation,
yes,
they would have said into brackets horizontal reservation.
Even
because they have a lot of experience with reservation provisions.
Yes, milords. They have, milords, extensive milords, experience is there with the state, and there is an extensive inputs by the judicial precedents, which I have explained time and again how it is permissible for them to give the reservations. Now, the all set principle, milords, beyond which neither of us can travel is that there is a threshold bar of 50%. If you are considering it as a distinct reservation by itself, by creating a special category, you can never cross 50%. Otherwise, Lords, even a constitutional amendment cannot breach the public competition in excess of what is provided as 50% rule.
Even on 50%, of course, my.
The latest
exposure
judgment,
to-
Lords, of the Patna High Court of 2024, very recent judgment, Patna had extended, Lords, by creating distinct categories, saying that they are going to make it as 68% instead of 50%. Because the Patna High Court struck it down saying that 50% is sacrosanct. Because otherwise you are complete.
But the apex court
Tamil Nadu,
perhaps,
yes, in one of the,
it is said it's not the thumb rule.
Lords, it
It all
says,
depends upon, at
Lords,
least two judgments are referred.
Lords, Virendra Singh's case, it said, Lords, what the Supreme Court said is that if you are breaching 50% rule,
Special justification.
then there is a requirement of an extraordinary justification as to why the open merit category candidates will be reduced to a lesser number. Lords, ultimately, Lords, merit is something which has to have its own play. So in state of Balaji versus state of Mysore, they said reasonable is 50%. Lords, I cannot say, Lords, that, but this is being treated as sacrosanct. Even Indra Sani's case said that never exceed 50%, but horizontal it is permissible. Then it stands as an exception.
But Shauri, Arun Shauri in his famous book, Falling Over Backwards,
Lordships, Madam, speak.
he has enlisted 12 judgments where violating rule of 50% is justified by the Supreme Court.
Yes, Lords, I have a list of 2-3 judgments of that kind, Lords.
No, for
Yes.
your info, just I gave.
Lords, but what
He
happened?
gives that book is very
I'll-
weirdly written book, Falling Over Backwards.
The only book which I could read
title
of
the
Arun
book.
Shauri, Lords, is Worshipping of False Gods.
No, not that.
No, I'm.
Not, that is on Dr. Ambedkar.
Yes, that's on Dr.
But
Ambedkar.
this is on reservation. This is falling over backwards. On that concept he has treated.
Yes.
He has referred to Mark Calendar, which Kantraj had given to me.
Lords, now,
Our bar
the-
days.
the scenario, Lords, of this kind would throw a light, Lords, as to whether this should be treated as a vertical reservation or a horizontal reservation or a distinct reservation by itself
It
as
looks that
distinct from horizontal and vertical reservation. This is essentially the point, Lords.
vertical or horizontal. Personal elements. or the
Personal
factors.
backwardness. Lords,
Personal, communal, we can say in Madras High Court language, communal reservation.
yes.
There are suggestions, they have said
Yes.
that way. Because community, caste, these things will factor there.
True.
But reason is the dominant factor here.
Correct.
Those factors also will operate in the penumbra.
Lords, now
That way.
what happens is this. I'm just giving illustrations, Lords, so that probably it may spill over to either of the sides. Vertical, probably it may not get into the realm of vertical resolution. I'll also demonstrate why it may not come. But horizontal, it may come because the reservation, when it is given region specific, then all the posts in all the categories are the posts which are required to be filled up from the persons from this region on the basis of the very same reservation policies. Lords, this is where the interplay happens. Interplay between the vertical and the horizontal reservation, which is recognized in Indra Sani, is similar to the one which I am now canvassing, Lords, before your Lordships. That interplay between the vertical reservations in different categories is now cut. Something like this. Now there are 100 posts. 80 posts you make it as regional posts, which is the local cadre. 20 posts you are making it as a non-local cadre. But for this 80 and 20, vertical reservation is applicable. That means in 80 posts, 40 posts are reserved for SC, ST and OBC. And remaining 40 for the open competition amongst the region candidates. And 20 Lords is again for those who are into open competition. Whether there will be, Lords, say interplay or there will be a shifting between them will be a matter which spills into the arena of horizontal reservation. If we permit that the persons who are in the merit within this 80 gets into the 20, then it becomes vertical reservation. If that's how vertical reservation works. So now the first of the circulars which they came about, they said, we will do something like this. That probably appeared to be just and reasonable. they said, you give an option whether you want to claim the benefit of the local cadre. If you take the benefit of the local cadre, even then you will have to give an option that that you are required to say whether you will also get into the merit category, etc. There is an option which is given. Then when they are drawing up the merit list, they have to restrict themselves whether to the local cadre or by applying the principles of vertical reservation, whether you will take out the meritorious candidates from the Hyderabad Karnataka region into the open competition posts and then fill the remainder into the Hyderabad Karnataka region posts. This is where, my lords, there is a requirement, because, my lords, I am also trying to understand, because this is a new concept. My lords, what I could just relate back myself was to the likes of R.K. Sabharwal's case, where it said, if you are drawing persons from two different streams into one cadre, then the proportions with which you are drawing those persons becomes watertight compartments. You can't spill this side, that side. Whether it's in R.K. Sabharwal's case or Badamikar's case, they said it becomes a watertight compartment. Now, see, if that is the analogy applied, then 80 becomes a watertight compartment, 20 becomes a watertight compartment, which does not permit a vertical reservation. So what is the nature of reservation? Now the difficulty which is cropped up is, rightly or wrongly, the 15(6) said, all right, we will give you an opportunity. If you are meritorious and you are opting, we will put you into the non-local cadre. Otherwise, you will continue in the local cadre. That option was given to them. Now, in the recruitment process, which was already in the anvil, or which was about to be concluded, or rather it was concluded and because of the intervention of the court, like the sub-inspector's recruitment process, it reopened, they directed a re-examination to be conducted. Now they are making the circular which is coming to existence subsequently, saying that we will apply the principles of vertical reservation to this. 40 students who have opted for the local cadre, since they are meritorious, we will shift them to the non-local cadre. 40, they are keeping it vacant because they know that some issue is required to be decided by this court. That's what they have done with the the sub-inspectors, recruitment process. Now, if this issue is not resolved, then the state will be doing the same thing till the issue gets resolved. Because the first principle which the state probably committed an error, in my opinion, is to apply the principles of vertical reservation to a reservation under 371J, which was not contemplated, even under the governor's order or the subsequent rules framed. It only provides for...
No other high court considered this aspect under 371A2
J.
jail. A2
only H, my lords.
I.
Yes, I'm sorry. Let's head. If your lords were to see 371, where they given for 371 Andhra D, 371D. Lords, here again, lords, of course, lords, I don't want to, because senior counsel P.S. Rajgopal has already dealt with this, lords. 371D. Lords, 2A specifically requires local cadres to be drawn up. I don't know whether they have just copied the whatever was done, lords, with reference to 371D into 371J1C. May I read 371D, lords?
371B.
D for Delhi.
That is Andhra Pradesh.
Andhra Pradesh. This actually provides for creation of a local cadre, unlike what 371J provides.
J is bit different. Even content-wise, it's different.
Lords, no, but local cadre, what your lords finds in the governor's order is what is distinctly, lords, provided for under 371D. Lords, may kindly have a look at 371D.
That is conspicuously absent in 371J.
1J. But what is there conspicuously in 371J is providing for equitable opportunities by taking the state as a whole unit. Special provisions with respect to state of Andhra Pradesh or the state of Telangana President may by order made with respect to the state of Andhra Pradesh or the state of Telangana provide for having regard to the requirement of each state for equitable opportunities and facilities for the people belonging to different parts of such state in the matter of public employment and in the matter of education, and different provisions may be made for various parts of the state. An order made under clause 1, this is important, Lords, may in particular require the state to organize any class or classes of posts in a civil service of or any class or classes of civil posts under the state into different local cadres for different parts of the state and allot in accordance with such principles and procedure as may be specified.
But this is absent.
You know, this is what they have done in the present scenario, but
This, what they have done accords with 371D.
Notice there was a precedent of how another provision which was inserted under 371D, Milords, was there. So they probably have just taken a cue from it and have done it. And then your lordships will kindly see, Milords, the next provision. Very interesting, Milords, because we have reflection of what is said in 371D in the governor's order. B, specify any part or parts of the state which shall be regarded as a local area. That is the region, what we find in the governor's order. What it says, for direct recruitment to posts in any local cadre, whether organized in pursuance to an order under this article or so under the state government, direct recruitment to any post in the cadre under local authority within the state for purpose of admission to any university. So this specifically provided for creation of a local cadre. This completely is reflected in the present governor's order.
You should have asked them, have you operated 371J or 371?
That of course not the additional advocate general is all smiles to answer it.
All right. We'll
Lordships.
rest the things at this level now.
Lords, there is an implementing application which is filed. We are the recruits. Lords, what happened? We were in the list of all the eligible candidates, which was drawn up pursuant to the sub-inspector's recruitment process. We are in that 40. Now, if vertical reservation is made applicable, 40 from local cadre is brought into the open competition cadre, we will not get appointments. But if Sabarwal's case is applied to keep both these streams as independent streams, I'll get appointment. But that is filed in writ petition number 16343 of 24, because that's also pertaining to the sub-inspector's
petitioners.
VP Hegde Milords appears, of course.
Are you in copy kotra?
We have served the copies on Mr. Hegde.
Anyway, whether application is allowed or not, you will
not
be,
yet.
you are heard and you will be
Lords,
heard again.
Please.
In matters like this,
Lords, I should say this, Milords, that it wasn't an easy task, because when we started practicing on the service side, the most difficult part for us to understand was what is vertical reservation and what is horizontal reservation. The next situation is the government has gone a further step ahead, that for even these kind of reservations, they are making applicable the roster points.
Whether that can be done or it is not yet decided by any court.
Yes. So this is how. So now, but still,
it's a different reservation. It's
a different reservation policy itself.
Appears that way.
Yes. If it is to be construed that it is a distinct reservation policy itself, by providing local cadres and watertight compartments, and the state government's efforts under the subsequent notifications to apply the principles of vertical reservations is not accepted, then most of the things may stand resolved. They cannot adopt the principle, because vertical reservation, the moment you adopt it, then still the principle will be there that you are exceeding 50%. Even if it is a local, regional reservation given, in any name you may give the reservation. But ultimately, if the open competitions possibility of participation in the number of posts gets reduced, then it is a constitutional crisis. It's a serious constitutional crisis.
Let us see.
Please, Milords.
You got the point. Just prepare a note of your submission.
I'm preparing it, Milords.
Lord, for a second, in continuation of Mr. Ravishankar's this one, that inside these watertight compartments, vertical and horizontal reservations can.
Still can operate ಅಂತ
can
ನಿಮ್ಮ
operate.
That's what I'm thinking.
Yes. Yes.
Lords, once we treat it as watertight compartments,
It cannot operate ಅಂತ
then,
ನಿಮ್ಮ-
no, once
excludes.
Lord, once they are treated as watertight compartments, the formula of application of reservation within this framework of the present framework of the reservation becomes very easy. Because 80-20, vertical and horizontal to 80, vertical and horizontal to 20. It becomes a very easy formula. That is what was contemplated in the first notification. But even there was an opportunity given to them, saying that if you fall within the merit, will you still be willing to get into the non-local cadre?
That violates the order itself.
That's
Vertical reservation is 16-4. Horizontal reservation is 15-4. Supreme Court has explained it. They are
but
two
our-
different concepts.
Indras on his case.
Different concepts. How they operate, my lord, have been explained by the Honorable Supreme Court. Horizontal reservation is under Article 15. Vertical reservation is under Article 60. We will not fall into the trap of vertical or horizontal, my lord, while deciding 371J. Because they are totally different. The object of 371J is different, and
16, 15 or
vertical and horizontal, they are totally different. They are constitutional mechanism provided under 15 and 16. Whereas 371J is a special provision. We do not want to fall under 16 or 15. They are totally different. Even when you are applying 371J, 15 and 16 operates in those two separate cadre. Residuary cadre, 15,
Local
16
cadre.
operates, and in local
Local
cadre,
cadre.
15, 16 operates. They are not disturbed.
So that essentially
Therefore,
means the same formula, my lords.
There is no conflict as such, my lord, and I think we should not fall into the trap of vertical and horizontal.
Lords,
We have
lords,
to confine it to only 371J. The percentage and all that, my lord, is taken care, my lord, because both operate in a different area also. They are covering a different field altogether.
Only one sentence. My turn is over still. The view taken is horizontal reservation is a case of classification under 16(1). Vertical reservation is traceable to 16(4). And general principle is all reservations except social reservations, that is caste-based reservations. They are all horizontal reservations. That is the view taken in the Indrasani and also that Shebrol Leela, which came under reservation in
ಅಲ್ಲ
case of.
ಇವ್ರು ಹೇಳೋದು ಚಂದ್ರಶೇಖರ್ ಹೇಳೋದು ಇದ್ಯಾವುದು ಅಫೆಕ್ಟ್ ಆಗುದಿಲ್ಲ ಅಂತ
ಅಲ್ಲ 15 ಬರೋದಿಲ್ಲ ಇಲ್ಲಿ. ಅಲ್ಲ 16(1). Without reference to 16(1), there cannot be any reservation under 371J because it is not related to 16(4).
ಅಲ್ಲ 371 ವೆರಿ ಸ್ಪೆಷಲ್ ಪ್ರಾವಿಷನ್ ಅಂತ ಅನ್ಸಲ್ವಾ ನಿಮ್ಗೆ?
It is a special provision, but one thing is horizontal cannot be anything other than vertical or horizontal. It cannot be angular.
Be that way.
It has to be either X or Y.
All right. Why have you seen his other book, not seen his other books? You should have seen courts and their judgments. Multiple contempt petitions should have been filed against him, but since truth is also treated as a defense. Shauris. Anita gets bail.
Bending
secular
backwards.
agenda,
it is a-
bending backwards.
Bending backwards.
He's a prolific writer.
Let's next date.
Next date, whichever date. held.
Wednesday,
ನಿಮ್ಗೆ ಯಾವ್ದು?
Wednesday, because MR Naik sir wanted on Wednesday.
ನೀವ್ ಹೇಳಿ.
ನಾಳೆ ಬೇಕಾದ್ರೆ
ಅಲ್ಲ ನಿಮ್ಗೆ ಯಾವ
Wednesday. ಅಲ್ಲ, ನೀವು ನಿಮ್ಗೆ ಯಾರು ಅನುಕೂಲ ಆಗೋ ಡೇಟ್ ಕೊಡ್ತೀರಿ.
ಕೇಳ್ರಿ ಮೊದಲ ನಾಯಕರಿಗೆ ಯಾವತ್ತು ಬೇಕು ಅಂತ.
Wednesday or Thursday, subject to my lord's calendar.
No, Wednesday, Thursday. Wednesday is open.
ಇರ್ಬೋದಾ?
Wednesday is.
Wednesday?
Wednesday.
ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದೆಯಲ್ಲ ಕಡಿಮೆ ಹಾಕ್ಬೇಕು. All right, thank you so much. I learned so much from you people.
ಒಂದು ವಾರ ಮುಗಿದ್ರೆ 6 ತಿಂಗಳು ಕೊಂಡೋಗ್ಬೇಕು. ಒಂದ್ ಸೆಂಟೆನ್ಸ್
Court officer, serial number 32 on date ಹಾಕಿ. Court officer sir, serial number 32.
ನಾಳೆ ಅದು